could do. I got to get a few things on the record before we get into the substance, but I appreciate everyone's perseverance in this case. And you're welcome to be seated. You're welcome to stand at the podium. You also can be seated and just have the microphone in front of you. It is your comfort level. Great. Okay.
Is Michelle Hansberry our court reporter?
Nope, there's a court reporter sitting right here. Michelle Hansberry is my judicial assistant,
Okay.
and she will not be taking the hearing down.
Okay, I just need to make sure that I guess the court reporter's got the pleadings, so she's got my email, so she can send me
Right, and we'll get all that on the record. I'm just
yeah, she's here. Triple check that.
Yeah, she was here early. I had to come out to court to grab something around 9, and I wasn't even in court clothes. Her eyes got real wide, like, who are you? Like, same guy, just not wearing the dress. Okay, I think we are all set. Madam Court Reporter, are you all set? Okay, well, let's get on the record. This is 2023 CV 384617. It's Ms. Marquez-Adame versus Big Wake. I'm Judge McBurney. I am in courtroom 8D right now. If I could have the appearance for Ms. Marquez-Adame.
Wick Cawthorn for plaintiff.
And am I pronouncing her name correctly, or should I say it different?
Yes, sir, that's correct.
All right, got it. And on behalf of Big Wake.
Sam Wharton.
Ms. Wharton, you filed it was sort of change of counsel for Big Wake that was confusingly worded, because it said that you're sort of joining the team, but then it said you're not on the team. I trust you are the designated representative. I know Ms. Christie is sort of lead, but you're here. And I just want to make sure there wasn't something funky about what's going on at your firm's side.
No, it was just the prior lawyer that argued this motion back in October is no longer with our office.
Okay.
I just wanted to make it clear, she's no longer with us. I'm appearing instead of her, and I just wanted to make sure nothing got sent to her about rescheduling this.
Okay.
So no.
All right. So I think what happened in your notice is that you put your name in one too many places, and where it should have listed the name of the person who's not with the firm, it listed you again because it said you're on it, and then it said you're off it. Don't send anything to Ms. Wharton. But then you signed it, so I figured it's all good.
Yeah.
You're here. That's the important part.
I did not want anything to go to her because that keeps happening, and so when in all of those cases, I wanted to put my name to hopefully avoid that happening.
Got it. Okay. Let me start with this, and it's an apology. It's an apology to the lawyers, and in particular to Ms. Marquez-Adame, who has been waiting now. We're on year 7 almost for closure on this. Whatever closure is going to be, it may be disappointing closure for her, but closure nonetheless. Part of the age of the case, I guess, is because there was a refiling. So this is a second round at the lawsuit. But there is a big piece of the delay that lands at the feet of the court. This was a case, it's always been assigned to me, the reincarnation of it. But when we had the benefit of some additional resources because of COVID funding, I asked a senior judge to hear the motion for summary judgment. It was through what we call Project Orca. Don't ask why it has that name. It was the very last thing that Judge Brantley heard. It was the last one that got submitted. I don't know if it was the last that got submitted, but it was the last he heard. And we did a bad job of ensuring, as the Orca funding and staffing was phasing out, that they finished what they had. And so this is a motion that has already been argued in front of another judge. And he apparently had some thoughts about it, but the staff attorney who was there to support him isn't here anymore, and was let go, not because of performance issues, but she was a term employee, and that term ended before Judge Brantley and that staff attorney had connected and worked through this. And that took me a while to figure out. I assumed because we submitted it to Orca, that they wouldn't leave it half done. And so I was moving happily along to other cases. And then my staff attorney figured out, wait, there's no order on the motion for summary judgment. They're looking, why do we have a 2023 case still rattling around? Not the fault of any of the attorneys involved. It was a court side error. And then regrettably, when I reached out to Judge Brantley just a couple months ago, having figured out where we were, he said, I'm not able to recollect one way or the other. That would have been information he passed on to the staff attorney who would have done a draft of an order, and that never happened. I read your briefs every which way and reached out to both sides saying, I'm happy to rule on the pleadings. But at least one of you, if not both of you, said, no, I want a hearing. And it just takes one side to say we want a hearing. And so we're having to do it again. And that's the basis of the apology. That's expensive to you all. It's inefficient for the court system. But I made sure I read everything extra close. I try to read everything in any motion for summary judgment, just so that we can spend less time together today, and you can focus on the high points of your arguments. And then I can commit to getting an order out or asking one of the two sides to do a draft of an order based on what I think the right outcome is. So hopefully you accept the apology on behalf of the Fulton court system, not how these things should work. Orca did some great work. I had a number of cases resolved through that. And it just was being last in line meant that they just didn't quite wrap it up. Pivoting to this case, my understanding is that this was a slip and fall at a Chick-fil-A. Ms. Marquez-Adame was coming into the Chick-fil-A with two relatives, and it was in October of 2018. She slipped on some liquid. She says she didn't see it. We have a Chick-fil-A employee who just a couple minutes before had done a round to make sure things were safe and clean. And so a lot of the debate is about, did Big Wake really have superior knowledge of this hazard? If there was a hazard, there've been a bunch of depositions. I got the sense from looking at some of the depositions and the excerpts therefrom that there probably were some language barriers in some of the exchanges, because there were good questions asked and the answers sometimes were a little disconnected. And I suspect that's because the effort to respond across a linguistic barrier led to some confusing answers. And that's not anyone's fault. It just makes the record a little muddier, because where you would expect the answer to be, yes, I saw the puddle, it's my sister slipped and there was a green liquid. And so it's semi-responsive, but it doesn't connect entirely. I also know that some of the things that, or I'm recalling, that plaintiff points to is that I'm blanking on her name, but the woman who was responsible for making sure that the area that Ms. Marquez-Adame was traversing was clean and safe, had a little before the 2 minutes before she had done that, I think her shift hadn't started yet and she was drinking something from a tumbler. And at one point on a video, she's seen like brushing her pants off or something. And so plaintiff points to that as, see, she must have spilled and she was cleaning herself off and maybe that's what's on the ground. And so I'm here today to listen to all those arguments, but I want you to know that you're not starting from scratch, even though it's a new judge in a new courtroom. I immerse myself in it as best I could so that you'll get immediate traction as opposed to me saying, all right, well, tell me why we're here. Is this a criminal case or a civil case? I know generally why we're around. So I'm going to ask Ms. Wharton to start. And then when you're done, we'll hear from Mr. Cawthorn and then Ms. Wharton as the movant. I'll let you wrap up. Okay?
Thank you so much, Judge. Yes, Stan Morgan here for the Movement Big Wake LLC this morning. Good morning. You're correct, Judge. This case involves a slip and fall that occurred at a Chick-fil-A branded restaurant that's owned and operated by Big Wake on the morning of October 22nd, 2018.
Remind me where the Chick-fil-A is.
I believe it was in Austell, Georgia.
Fairburn.
We're here because Big Wake is a Fulton County corporation.
It's Fairburn.
Okay, so the slip and fall was in fact in
Yes.
Fulton County also. Okay, got it.
Sorry, excuse me. So plaintiff, her sister Maria Marquez, and then a friend, Petrus Cardenas, I'm not sure if I'm pronouncing that correctly, arrived at the store that morning. We have objective surveillance video footage that shows that just 2 minutes before the fall, Big Wake employee and dining room host Keisha Neal walked through these.
Neal?
Neal, Miss Neal.
How do you spell that?
Neal.
Great. That's the person I've been talking about with the tumbler and she's wiping her pants down. Okay.
So there's objective surveillance video evidence that shows that Miss Neal walked through the exact area where plaintiff would fall just about 2 minutes later. She testified that she inspected the area before as she walked through and that she found no substance on the floor during her inspection, just 2 minutes before.
But is either the sister or the friend say, when I was kneeling down to help my sister up, there was a liquid on the ground?
Yes, so when they arrived in the restaurant, they got in line, plaintiff stepped out of the line to walk to the restroom. When she was walking to the restroom, that's when the fall occurred. Miss Marquez-Adame, the plaintiff, has made clear that during her testimony that she did not see anything on the floor. She does not know why she fell. Her surmise of why she fell is because her sister, Maria, who was there, who did not see the fall. Maria just saw her sister, the plaintiff, on the floor, went to her aid because she had assumed that she had fallen. Her sister, the plaintiff testified that her sister Maria told her on the scene that she touched the floor and it said, look, it looks wet, it appears to be kind of green. That's what the plaintiff testified to.
She said her sister told her that.
Maria told
Okay.
her that. Yes. And beyond that, no other description. The plaintiff.
So friend, the third person, doesn't provide additional context of, yeah, it looked like coffee from that lady's tumbler.
Also, when pressed, Maria, the sister, during her deposition, makes no mention of a green substance. Maria, during her deposition, all she can do is describe the alleged substance as wet. When pressed and repeatedly asked, what did it look like? What was the size of it? She just keeps saying wet. Maria does during her deposition. The friend, Petrus Cardenas, when asked, she too says she's wholly unable to identify or describe with any particularity what the alleged substance was.
Does she say she saw wetness or moisture on the ground?
Petrus says that she saw nothing on the ground as she was walking over there. And when asked, well, did you actually see anything on the ground? She said she didn't see anything. She just knew that it was wet. And she guessed that maybe it was maybe greasy, I don't know. And then she ultimately said, Petrus ultimately said, I don't know, I can't remember because it was so long ago.
Okay.
So we have the plaintiff saying on the scene, her sister told her that, look, it looks kind of green. But then we have the sister testifying to nothing about anything green on the floor, just saying it was wet and that she touched it. Can't describe beyond saying that the area was wet at no size, no color during her deposition, nothing further. And her sister Maria testified that she didn't look at the floor. She wasn't paying attention to the floor. She was paying attention to her sister. All that she knows is that it was wet. And then we have the third friend, the third person that was there, guessing that it was greasy. Again, saying that she saw nothing on the floor, but guessing that maybe it was greasy. I don't know. I actually don't even really remember because it was so long ago.
Okay.
So we have
And then what does Ms. Neal say? She also sat for a deposition.
Correct. Ms. Neal testified that she did not see any substance on the floor before or after the fall. And the two affidavits submitted.
Yeah, there were, I'm gonna call them bystanders, customer X and customer Y, who said, we didn't say anything.
Correct. And their names were Greg Anderson and Walter Brown. Both Mr. Anderson and Mr. Brown swore and affirmed in their affidavits that were submitted that they were sitting in the area, they saw the fall, they observed the floor both before and after the fall and saw nothing on the floor.
Other than obviously Ms. Marquez-Adame,
Correct.
but not a substance.
No substance on the floor, correct.
Just curious, how do you find someone like that? Ms. Neal's gonna be an easy find and you interview her and she says what she says, but two guys who are having chicken biscuits and you get affidavits from them, there's not how do you recreate who was sitting at the table, or were EMTs called and these guys I'm just curious how you ever track down those two individuals.
Credit card statements and electronic data when you make purchases can tie people back to their names. And I know at least one of them was a regular, so Miss Neal recognized him.
Oh, that's Chris. He's here all the time. And then if you get information from Chick-fil-A that, hey, there happened to be a guy first named Chris, Christopher Jones, who bought chicken biscuit 5 minutes before this happened, then your team can reach out to him and say, hey, can we talk about?
And Chick-fil-A is an establishment that often has a lot of people that are regulars, so that's not uncommon.
Okay.
There are lots of people that are regulars at Chick-fil-A. It happens a lot at McDonald's too, actually.
Okay.
So yes, so I know at least one of them was a regular, and the other one was sitting in the area, and we identified them through speaking with the witnesses, the employee witnesses, and then also, like I said, that data is typically able to pull people's names. So, plaintiff has the burden of proving that Big Wave under Georgia law either had constructive or actual knowledge of the hazard, and that she lacked knowledge of the hazard despite the exercise of ordinary care due to actions or conditions within the control of Big Wave.
Is it, I don't disagree with that, but is it also not, it's superior knowledge?
It's superior knowledge.
Okay.
Correct. Yes.
Because if it was lava on the ground, it's flaming and it's hot, both sides see that. And so Chick-fil-A needs to get the lava off the floor, but Ms. Marquez-Adame is just as knowledgeable about the lava and probably should stay away from it on her way to the bathroom.
Right, yes, so actual constructive knowledge and superior knowledge, but she can't carry her burden on either of those here in this case. And you're correct, superior knowledge is the linchpin of a premises liability like case, and it's the linchpin of her case that she's not able to carry her burden. And on a mutually exclusive ground, the record evidence that's been put forth shows that plaintiff actually does not have actual proof of what caused her fall. The green substance, whether it was greasy, whether it was water, that's all purely textbook conjecture. And that's exactly what the Court of Appeals has repeatedly held is not enough to create an inference of fact to defeat summary judgment. So with respect to proximate cause, when a plaintiff doesn't know or cannot prove the cause, there can be no recovery because an essential element of negligence cannot be proven. So proof of a fall is not enough. The plaintiff must provide evidence of a hazardous substance which caused her fall. Mere speculation as to the cause is not enough to create an inference to defeat summary judgment. And that comes from the Court of Appeals case Moore versus Teague. That site is 255, Georgia Appellate 220. So again, like we just discussed before the fall, plaintiff was asked, what did she see? She said, I didn't see, that it was wet or anything like that. When asked if she knew what caused her to fall, she responded, no.
So the classic, I'm in the produce aisle and I slip and fall, and as I'm looking around, I see crushed grapes all around me. That would satisfy this second basis for summary judgment, because I'd point to, look, there are all these grapes that are under me and on the ground. And I'm able to articulate it specifically, not, well, there must have been produce on the ground because I was in the produce aisle.
Right, correct, exactly. When she was asked, did you personally see that the ground was wet or feel that the ground was wet, or was it because somebody else told you that the ground was wet? She said, I realized it when my sister was told me. Then when asked in two other ways about her personal knowledge of any alleged wetness, she said, it wasn't until my sister said something about it being wet that I realized it was wet. And then in another response, she says, I didn't know about it until I was already laying on the ground, and then my sister told me about it. So we have the statement allegedly from her sister saying, look, it was kind of green, but Miss Marquez-Adame has no personal knowledge of what caused her fall.
But the lack of personal knowledge doesn't seem like that alone would be fatal. If, let's say that one of those regulars said, yeah, I noticed there was a green puddle on the way to the restroom, then the person who is the victim, the person who has the accident, doesn't necessarily, the requirement isn't, I don't think, that the only way you can prove up as the plaintiff that there was a hazard there is that the person who slipped says, oh yes, as I was writhing in pain on the ground, I noticed all this green stuff around me. Someone else could do that, but your point here is that friend can't do any of that, and sister, it's conjecture.
Yeah.
Right. She says the floor was wet, but I don't know what it
I
was.
can't describe it. And then the other one says maybe it was greasy, I don't know. So
Yep.
it's purely textbook conjecture and exactly what the Court of Appeals has held. It's not enough to defeat summary judgment. So Moore and Moore v. Teague, the case that I just referenced, that case involves a slip and fall that happened. The plaintiff slipped and fell in her friend's kitchen when she was hosting a party.
She sued her friend?
The plaintiff, I think it was like a Tupperware party or something like that the friend was throwing, something along those lines. But the plaintiff knew that the ice maker had been leaking at some point during the day from the refrigerator. She slipped and fell. She assumed the floor was wet because she fell, but she did not actually know if the floor was wet. That's what she testified to. And that's the Court of Appeals affirmed summary judgment saying there that's not enough. Another case, Christopher versus Donna's Country Store. Summary judgment was affirmed in that case as well. The site is 236 Georgia Appellate. That was a slip and fall in the parking lot. The plaintiff claimed that she slipped and fell on a greasy substance, but she testified she did not see any greasy substance in the lot and she did not examine the area of the fall afterwards. It's exactly what the plaintiff says here. However, in Christopher versus Donna's Country Store, the plaintiff did say that she saw what appeared to be a greasy substance on her clothes after the fall. So that's why she speculated that she fell in grease, but the Court of Appeals held there, still that is not enough. She simply speculated that the grease caused the fall because it was on her clothes, so that was insufficient to prove negligence. Another case, Shadburn versus Whitlow. This is a trip and fall in a hotel lobby. 3 folks involved, actually. A friend tripped and fell, or tripped, bumped into her friend who caused the friend to fall. So the friend is the plaintiff, Shadburn. And then a third friend was there too who witnessed it. But the plaintiff is Shadburn, got knocked into by her friend. All 3 of the women testified that they believed that the fall was caused by loose carpeting in the area where the plaintiff fell, that they saw later that night. But again, they didn't actually know in the moment if that is what caused the fall. Again, the Court of Appeals held that speculation that she may have fallen on the loose carpet was not enough for causation. The 4th case that is on, again, all fours with our case here, Season All Flower Shop versus Rory. That case site is 323 Georgia Appellate 529. As a slip and fall in a church foyer at a wedding, it's a rainy day. The plaintiff testified that she fell because of moisture on the floor in the foyer because her clothes were wet. So that's similar to the greasy parking lot case as well. But she testified that the moisture was not visible to the naked eye and she couldn't give any description of the moisture. She just assumed that she slipped and fell in moisture because it was on her clothes. Again, the Court of Appeals held you cannot rely on speculation. She must prove more than an existence of a slip floor. She must produce evidence of what the foreign substance was on the floor that caused the fall. And so that's exactly the situation that we have here. Plaintiff is unable and has not been able to put forth evidence of what that actual substance was. So causation alone, summary judgment is warranted. When we then get to the knowledge aspect, there's no, with respect to actual knowledge, there's no evidence that any employee observed a hazardous condition in the area prior to the fall because Ms. Neal had just inspected the area 2 minutes prior and confirmed that there was no substance on the floor. Plaintiff in her opposition brief argues that when we first started talking, that she intends to argue at trial that Ms. Neal spilled her personal drink that she was carrying through the restaurant. Again, this is textbook conjecture. It's a red herring. What the video shows is about 30 minutes before the fall. It shows Miss Neal walking through that area of the dining room. She's holding she testified, it was an insulated, like Yeti tumbler type cup with a lid on it. She's holding it with her arm. She sets it down and then she goes and gets wet wipes and she testifies that she's patting down her legs, her slacks, because they're dusty. She wants to clean up before her shift begins. She testified that there were no spills on her pants. So again, it's conjecture, it's a red herring, and it's foreclosed by Ms. Neal's testimony. And common sense dictates that if your pants were wet, you wouldn't use something else wet to clean up the pants. Presumably you'd use something dry.
These are black pants?
Yes.
Okay.
Yes, but nevertheless, she testified that it was a lidded insulated cup, that she was using the wet wipe to pat down her pants to clean off the dust. And she said that she does that often. That's not the first time that she's ever done that. And that there were no spills on her pants. And again, this is the exact textbook conjecture that the Court of Appeals has repeatedly held is insufficient to establish that there was a hazardous condition on the floor. A good case example of that is First Community Management versus Holmes. The site for that is 353 Georgia Appellate 409. There in that case, the plaintiff slipped and fell on some rocks that were in a landscaped area outside of a car wash. She testified she didn't know what caused her foot to slip. She didn't know what caused the fall. And she testified that she didn't have any knowledge of water on the rocks and didn't encounter a liquid or hazardous substance, but she claimed that the rocks became slippery from the car wash area, because where else would the water come from? And again, the Court of Appeals held that this speculation, that jump, it's not enough evidence to support that there was actually water on the rocks that caused her fall. So again, we have the exact same situation here. With respect to constructive knowledge, plaintiff can show that in two different ways: by showing that an employee was present in the immediate area and easily, keyword here, easily has seen the hazard and removed it, or by showing that the defendant failed to exercise reasonable care in inspecting and keeping the premises in a safe condition. With respect to that first way about the employee being present in the immediate area and that could have easily seen the hazard, we know from the surveillance video at the moment of the fall, there are no employees in the immediate area that appear to be in eyesight. But of course, we know that the area had just been inspected 2 minutes prior. But
Is the camera footage nonstop such that you'd see Ms. Neal doing the inspection and then she leaves? And if someone had come by with a big old thing of lemonade and tripped and you can see lemonade go everywhere, that would be captured? Or it's just every 5 minutes there's a picture taken of that area?
no, you're correct. It's continuous. It's a continuous streaming footage.
Okay,
Yes.
so there is not, in the 2 minutes between Ms. Neal making an inspection, during which she's testified she saw no spills on the ground, and then Ms. Marquez-Adame falling, I'm assuming we would have heard all about it from Mr. Cawthorn anyway, but there's not an intervening factor of someone holding 2 drinks and then one of them drops or something like that.
No, there's not
Okay.
a spill or anything like that. In fact, I believe at least 3 or 4 customers walked through the area without issue.
Okay.
During that 2 minutes. It might be only like 1 or 2. I can't remember off the top of my head.
But more importantly, there's not footage.
It's not an obvious
spill.
Somebody drops their tray and
Okay.
there's nothing obvious like that, correct? So the Court of Appeals held in the case of Value versus Summerfield Hotel Court, that case site is 255 Georgia Appellate 494, that where the alleged hazard is difficult for the plaintiff to see, she cannot establish that employees could have easily seen and removed the hazard. So here we have plaintiff who testified that she didn't see anything on the floor before her fall. So that alone is exactly square with Value versus Summerfield Hotel Court. But then in addition, we also have the affidavits from Mr. Johnson and Mr. Brown, who swore and affirmed that at no point prior to or after the fall did they see any substance on the floor. And we have Maria and Petra's testimony, which actually highlights and underscores the fact that this alleged substance could not be easily seen because they're unable to describe with any particularity what that substance was, other than it was wetness and maybe greasy, according to Petra's. And so with respect to being able to establish constructive knowledge so that way plaintiff's unable to carry her burden there's also no evidence that Big Wig failed to exercise reasonable care in inspecting and keeping the premises in a safe condition. For the second way to show constructive knowledge, the Court of Appeals has repeatedly held that where it is shown that an inspection occurred within a brief period of time prior to the fall, the inspection procedure was adequate as a matter of law. That comes from several cases, but the one cited in our brief is Matthew versus Varsity, which is 248 Georgia Appellate 512. And Georgia courts have repeatedly held that inspections within 30 minutes before the fall are adequate as a matter of law. That was held in the case of Mallory versus Piggly Wiggly, which is 200 Georgia Appellate 428. It was the inspection, the employee testified that they had done an inspection 5 to 10 minutes before and, swept 5 minutes before the fall. That was a slip and fall on onion peel in a produce section. Had swept 5 minutes before the court held that no evidence presented to show the condition had existed for sufficient time to afford the defendant reasonable opportunity to remove the onion, and that because the inspection had been done within 5 minutes, it was adequate as a matter of law. In the case of Wallace versus Walmart stores, 272 Georgia Appellate 343, that inspection was 15 to 20 minutes prior. That case involved a slip and fall as well. That inspection was 15 to 20 minutes prior. And then Hopkins versus Kmart Court, another one, 232 Georgia Appellate 515, the inspection was 30 minutes prior. In all of those cases, the inspections were done within that 30-minute time frame and were all deemed adequate as a matter of law. Or again, we're on all fours, we're square on point here in this case that an inspection was done within the 2 minutes prior to the fall, and the employee testified that she observed no substance on the floor. Plaintiff argues in her opposition that the adequacy of Ms. Neal's inspection should be a jury question. But under the extensive case law that's cited in our brief and the few cases I just mentioned here too, that Ms. Neal's inspection 2 minutes prior was adequate as a matter of law. Plaintiff also argues in her opposition that the case of Lomax versus Kroger Company, which is 348 Georgia Appellate 726, is similar to this case and creates an issue of fact as to constructive knowledge. But the case actually, when read critically and compared to our facts here, actually supports summary judgment in favor of Big Wake and underscores the jury issues that are lacking here. Just to quickly go through that case, because I know it's fleshed out in plaintiff's brief and in our reply, but there the plaintiff fell in what she testified to be a sizable puddle of water that caused the plaintiff's clothes to become soaking wet, and a store security guard and a nearby customer confirmed the presence of the puddle. Here we have the opposite as we discussed. Plaintiff, her sister and Patris are unable to describe the wet area other than its wetness and maybe grease with no particularity. No recollection by plaintiff that her clothes or shoes were wet from any substance. She didn't check to see if there was any substance on her clothes. She didn't feel the ground. We had the two affidavits from the customers, Mr. Anderson and Mr. Brown, that at no time prior to, before, and after the fall did they witness or see any substance on the floor. And we also have the surveillance footage showing Miss Neal walking through the area and not identifying any substance on the floor. And the surveillance video, don't see anything, by the way, as well. But then in Lomax, we have we have an employee who admits that he wasn't looking at the floor when he walked through. He didn't perform any kind of inspection of the area. A second employee falsified sweep logs in that case, said that they had been inspecting the area, but they had surveillance footage that actually showed that employee in a completely different area of the store at the time. So she falsified the sweep log. We also have the store manager's admission in Lomax that the second employee obviously totally failed to perform the inspection as required by store policy. And the store manager's admission that no employee actually carried out the inspection policies on the day of the fall. Again, we have the opposite here. We have Ms. Neal's testimony. She took plaintiff through how, as the dining room manager, she's trained to do inspections every 15 to 20 minutes. She's checking the kiosk, she's checking the floors, she's checking cleanliness of the store, including the floors. And she's trained that if she does identify something, that she's supposed to clean it up immediately accordingly. We also have the corporate witness deposition testimony from Big Wake, who testified that their employees are trained to be cognitive of their surroundings at all times and to look for anything safety related that needs to be addressed. And of course, then we have Ms. Neal's own testimony that she inspected the floor. So very different facts between our case and Lomax here. And so summary judgment again is warranted. As a matter of law, plaintiff is unable to carry her burden in showing that that Big Wake had actual work constructive knowledge of any hazard on the floor. And then as we discussed earlier, the linchpin of premises liability case is superior knowledge But the record evidence and the unrebutted evidence here is that Ms. Neal did an inspection 2 minutes prior. She discovered no hazardous substance on the floor, and there's no evidence that's been put forward that any of her employees have knowledge of some hazardous substance on the floor. We believe this is a clear-cut case. There's no genuine issues of material fact that need to be resolved or that remain. And we believe it would be reversible error to deny summary judgment on any of these grounds alone. Therefore, we respectfully request that the court grant Big Wave's motion for summary judgment.
All right. I appreciate that. Mr. Cawthorn, if you would share your client's perspective on this, please.
Yes, Your Honor. First, just a very quick thing on the mere conjecture cases, the whole mere conjecture line of cases cited by the defense in this case. Mere conjecture cases are not applicable to this fact pattern where we have actual witness testimony that the floor was wet. The mere conjecture cases that have been cited are people who could not say that the floor was wet. They assume the floor was wet because they slipped. So they're taking the slip as proof of the dampness, not actually touching the dampness, as Ms. Maria Marquez did when she testified. So here, this is not a conjecture case. This is a case where we have direct evidence of a wet floor. And since this is summary judgment, Judge, we're just simply asking this court to not sit as a fact finder. We want this court to allow the jury to decide issues of evidence. And summary judgment is only appropriate if there's no scintilla of evidence to support a jury finding in the plaintiff's favor. We're going to share our screen, Judge, because we want to put these videos in front of you so that you can see them and so that we can show you what we believe is an interpretation of the video in plaintiff's favor. Because that's really the issue, is the interpretation of the video and the deposition testimony in plaintiff's favor, as if our theories are correct. Not whether we'll win at trial, but whether or not a jury needs to decide it instead of the judge as a matter of law.
Right.
So I'm going to share the screen, Judge, and the first thing we're going to show is the video of the dining room. This is Exhibit C to the defendant's 30B6 deposition. I have already fast forwarded to 8:32:34 a.m. This is when Ms. Neal walks through the area, pinning the drink container to her chest using her forearm, and then goes and gets a wipe, then wipes down her legs, her jacket, and her hands after she's walked through the area. This is the video that I point to that we will actually argue shows not just constructive knowledge, but actual knowledge by the defendant of the hazard, because the employee herself spilled drink down her clothes and did not go back through the area that she walked. And we're going to play this for you, and then we'll go to another video.
Okay.
Can you see it?
I can.
Okay.
There's a young lady sitting, messing with her phone in a booth.
Yes, sir. Here comes Ms. Neal right through here. And if you see right here, she's got a drink in her left hand and her left arm pressed against the side of her body with her left forearm. Now she shifted it to her other hand and she's sitting it down at the table. And here she's getting these moist towels, white moist towels.
So has this spill already occurred or it's going to happen?
Yes, it's our argument's already occurred because she's cleaning up right now. She's cleaning herself off right now.
And where would you say, if you pause this video for a minute?
Well, just a second. I'll pause it, Your Honor. But I also want to notice she said she was wiping her pants down to get lint off with a white paper towel, black pants to get lint off with a white wet wipe. She also wipes her hands off. Did you see that, Judge?
I did. I want to know where you contend this. I don't remember where Ms. Marquez-Adame falls, but
we're gonna show you that Ms. Adame falls right here.
okay. All right. So by now there is a liquid on the floor, according to you, that you and I can't see. So it's clearly nothing green on the floor right there. But the spill from Ms. Neal, if that's the theory of the case, has already occurred, and there is some puddle. Not using that to suggest it has to be large, but there's some liquid on the ground, basically in front of what looks to me like a garbage can area.
That's correct, Your Honor. And I'm also going to argue at trial. We're free to argue at trial, Your Honor, that this may not be the spill, but this does look like a spill.
Okay.
But because we are also going to argue that the 2-minute walkthrough before Ms. Marquez fell was a completely negligent non-inspection of the area, and that the video shows that
Okay.
pursuant to the Lomax case. So you've seen the wiping and the wiping down of the hands and everything. Now I want to show you, and it's important that she's not just wiping her pants down, and she's doing it with some intentionality, and she's wiping her hand off, and she's looking around her pants and rubbing a white all the way down to her foot, cleaning herself off. Okay. Now, Judge, I'm gonna have to stop share and then load up another video to show you the alleged inspection.
Okay.
Okay, now I'm gonna share video. I've got to stop the video. Okay, stop the video. Okay, now I'll share again. This is Exhibit D to the 30B6 deposition. And this is the video from the same angle beginning at 9 a.m. And we're going to play this through for about 5 minutes, and it goes through to plaintiff's fall. It's our contention that there's substance on the floor right now, that the floor is wet right now. Judge, I can't hear you if you're... Judge, can you hear me? Judge, can you hear me? Judge, can you hear me? I saw your lips moving and I didn't hear you. You can't hear me. Judge, can you hear me? I cannot hear. Judge, I can't hear anything that you're saying. Ms. Wharton, can you hear me?
I would talk to him about how much he
We should be back now.
renting the
There we
room,
go. Okay.
which
Where
I
did we?
spoke to him.
It's a long story. Don't worry about it, okay?
because,
I've let you guys talk too long. And so another meeting started.
Yes, he
Should be
did.
back now.
Okay. Do we have where did I get dumped, Judge?
Just give me a minute, all right?
He
Yes,
did.
sir.
Well, what it was, I asked him. He didn't really answer me, but he said he was interested in renting out the room, but he didn't actually say that he needed care for his kids. But it was just my assumption. That's what my daughter told me.
So your knowledge of Army went to.
Yes, after she talked to him, yes.
And did you communicate?
All right. You should be able to hear me now. And you were showing Exhibit D. So I need you to put Exhibit D back up. I need to know how much longer you need.
It was
About 5 to 10.
Okay.
and they was
Okay. And I will jump ahead a little bit.
No. I'm not rushing you. I need to send an email that moves something.
right, no.
Hey, will you find out where Miss Taylor is? Deputy Gordon, her client's the guy, he's wearing a different
It was dark.
lounge jacket. She cannot be late. So she needs to be here by now. He needs to let us know what the deal is.
They look like she said to her, they looked like they were
Judge, you ready?
Nope.
and taking
Okay.
care of it. She said they just sat in different places in the house and you just didn't understand why, you know what I mean? He started explaining why.
All right,
She's
ready.
concerned about treasure.
Okay. Do you see the video screen?
I do. We're good. I have back stuff, and the thing that came after this started up and that pulled away the equipment in court. We were all still here, and actually my screen showed the video and your mouth was moving, but we couldn't hear you because the device that connects everything had shifted to our next hearing.
Okay. Judge, this next part goes to the Lomax case. It goes to the sufficiency and reasonableness of the inspection.
All right, before you press play, I see some customers sitting there. Do we know which, if any of them we have two affidavits. I don't remember the names of the customers.
My understanding from the 30B6 deposition is the man with the iPad is the one who gave an affidavit as a customer.
Okay, got it. Ready.
Okay. The Ms. Marquez falls in about 2 minutes and the inspection cited in the motion is coming up here in the next few seconds.
Are those the pictures that Toronto English sent you?
Some of them, I didn't choose.
Okay,
Mhm.
but she did send you some pictures.
Yes. Mhm.
And what did you do with the pictures?
I had them in my phone. I thought I had downloaded them, but unfortunately, I only have the picture of Treasure of her laying on the futon.
Is Miss Taylor out there? Okay.
She said that he was locked in a room. The oldest boy, it's Taiwan, the oldest, the
This was
5-year-old.
the inspection, Judge.
Baby boy was on a couch somewhere in the living room, I think.
And Judge, we're arguing she didn't even look at the floor. She was doing something over to the side with a tray, putting something up.
Mhm.
It wasn't an inspection of the floor at all.
Taranya said that he needed pull-ups for the children.
Can you rewind it a little bit? I saw what she did, but then I want to see how many people walk through this area. And I couldn't tell if that gentleman with the dark jacket, so that guy I saw walk through.
He said
Yes,
they're-
sir. There's a few fire EMTs and firemen there actually eating breakfast. And he did walk through the area.
Yeah, but there was okay, we're good. Keep it playing.
Yep, and go to the store and then come right out. Because neither one of them was doing any big shopping.
Just what's coming up is the inspection that, as a matter of law, according to the defense,
Yes.
shows a reasonableness inspection, that there's nothing on the floor and that plaintiff cannot even get to a jury on the issue of inspection. That is what the argument is.
No, I understand what the argument is.
Taranya asked him, and he said, just worry about your own kids or something like that, he said. Or worry about your own daughter.
Once you receive those pictures, did you contact with that?
Yes, I did.
Don't stop it yet. I want to see.
I was
Okay, he comes around the corner there. All right, thank you.
about the child being locked in the room.
Now I'm gonna just to expedite things, I'm gonna bump it forward. This guy walks through there too, Judge.
In the house, it concerned me very
Guy
deeply.
with camo on.
Felt like the
Okay.
children were
And then
Oh, she's coming back.
here's Ms. Neal walking through again.
My
And this,
you know, the
this-
conditions they were living in and how
but there's also, that's not an inspection either, is our argument.
check on
None of this is an inspection.
he cursed her out.
And then plaintiff is getting ready to walk through. Plaintiff is right here, Judge, at the top of the screen.
With the black sweatshirt.
Yes, Your Honor.
Okay.
Yes. Yeah. Basically the same thing that I told you know, the courts, you know, that I had asked, you know, was
In the white spaghetti straps, that's Maria Marquez, the witness who testified about the
see the
ground
kid.
being wet.
Yeah.
In a minute, you'll see her move her shoes. She testifies in her deposition that she was moving her shoes to show
And that the
the
little
ground was wet, to show the fireman that the ground was wet. She testified in her deposition. That's what she was doing, was showing that the ground was wet and slippery.
Somebody pick it up and give it to her. And it was like that was it. She didn't eat, you know, and the other two boys gobbled theirs down. She said
She was fortunate to have about 19 firemen on scene to attend her.
Yes, she was. Yes, she was. Now, Judge, I want to the reason that I say that we want to argue the Lomax case, that the inspection was not reasonable, is because there is a video of a Big Wake employee doing an inspection of the area after the fall. And it is at approximately 9:48. And I'm going to play that for you.
Miss Taylor, don't go too far, please. Okay. He's here.
I know he's here.
yes.
Okay, in a second, a woman in a gray shirt is going to come and do
And they went to the house.
and actually look down at the floor. You can see her looking down at the floor on the video. Right there, she's carrying a tray. Now she's going to stop when she walks halfway back and look down at the floor.
My daughter did, but she was at work. So she asked me, can she bring the kids to me until she got off work? And I said that would be fine.
See, she's looking down at the floor right there.
Yes.
Now she's also going to come back and look at the floor again after she drops off this tray.
There's a white and red bucket that people have touched and moved around, and employees have. Do we know what that white and red bucket is?
That's a cleaning station. They use that for cleaning, for like bussing the tables and things like that.
Yes.
So that white and red bucket could be full of a soapy liquid?
And when I was giving dinner, Daniel,
Right, white, red,
and she took
If you rewind a little bit, there was another employee who was at that station doing pretty much what Ms. Neal was doing, not looking at the floor, but putting a tray down, and that thing right there, so it just reappeared. See that?
That's not a mop bucket.
they can walk, but they
No,
walk.
it's not a mop bucket. It's
But
like
if you dump that out, would dust come out of it, or food, or would a soapy liquid come out of
Are
it?
walking okay,
We don't know.
but the two oldest ones walk like,
The
like.
30B6 deposition, Judge, they testified that it's a bucket that they keep, like, that they use to bust tables and use like to wipe down tables with. He wasn't clear as to whether it was a like sloshing water or just if it held.
Okay.
They made sound, like they wanted.
What I want to
Understand.
show to the court, though, is what an inspection of the floor looks like when someone, because right now this person in the gray is going to look at the floor, point at it, and then instruct someone to go get a yellow wet floor sign.
That they were.
And to get out in front of it, this is not a subsequent remedial measure because the defendant denies the floor was wet.
Based on what I've witnessed in 36 years, no.
So it's used to show the defendant is incorrect about the floor. It's an impeachment evidence. And it's also to impeach the defendant on what an inspection looks like. This is a floor inspection right here. That's a floor inspection.
They weren't even,
That's a floor inspection.
play with toys or
At
there or anything.
4902 into Exhibit D. That's a floor inspection. And in a minute, she's going to come back and put a wet floor sign down where plaintiff slipped.
Ran around and picked up toys and put them down, and I took them out to play. Basically, just ran around.
Did you observe any bruises on them?
No.
And Judge, as soon as she does that, I have about 2 more minutes of legal argument and I'll be done.
Okay.
But thank you for coming in, ma'am. You are officially excused. You get to leave the building, or you can remain in the courtroom. It's your choice.
Okay.
Okay, I'm going to stop sharing my screen. That was at about 50:40. She puts the employee in the black sweater puts a wet floor sign down in front of the workstation where plaintiff fell.
Great.
Judge, I want to point your attention to a case called Pipkin versus Azalea Land Nursing Home. This is a 2016 case. And this case illustrates the difference between circumstantial evidence that would allow an inference versus mere conjecture. In this case, the Court of Appeals emphasizes the difference in what the plaintiff needs to know versus summary judgment. Okay, and in this case, the court cites a number of cases, Smith versus Tenet Health System, where a janitor wiping down a cart prior to a fall and a witness saying that the floor was wet was sufficient to survive summary judgment, where the defendant contended the floor wasn't wet and it was mere conjecture. The something on the floor is what it is. When I believe in our original argument, there's a lot of, we couldn't say exactly what it was we slipped on. And I argued that we don't have to say whether it was Coke or whether it was Pepsi. We have to say that it was wet and that there was a liquid on the floor, and liquids are wet. And this Pitkin case, 339 Georgia App 390, is right on point with regard to allowing a jury to infer that the floor was wet. Okay. And Judge, when you compound that with the Lomax case, where a jury can.
Whoops. Hey, you need to unmute. Not your fault. That just someone had joined the call that wasn't muted, and I tried clicking on that and it hit you. So, but you were only muted for 2 seconds.
Okay. Well, Judge, when you look at that with the Lomax case, that basically says that the corporate record or the testimony of someone that says there was a reasonable inspection can be disproved by a video that shows otherwise. And it's inappropriate for the court to look at the video or interpret and weigh the evidence when you do have a video that could be interpreted otherwise. And it's our argument, Judge, that there are two ways to establish knowledge in this case. One is the constructive knowledge, and that is that the floor was wet. Ms. Maria Marquez testified over and over and over and over again that the floor was wet in her deposition. She was asked 20 different ways, and she said it 20 different times that the floor was wet. The inspection records attached, the incident report attached to the 30B6 deposition shows that the plaintiff was telling the employees that the floor was wet when she fell. So the floor was wet for purposes of summary judgment. The floor was wet. There is a witness who says the floor was wet. It was wet, period. Summary judge. That's for
so we have an issue of material fact. What about the superior knowledge? How do you get past that?
Two ways, Your Honor. One is that there was an employee in the area of the fall within a few minutes of the fall who did not inspect the floor. And if she had inspected the floor, if she had even looked down at the floor, she didn't even look down at the floor. If she had looked down at the floor, she would have seen that it was wet. And you say, why would you say that? Well, I say that because when an employee did look down at the floor, they put a wet floor sign out there.
But that was like an hour and a half later. Yes.
It was about 20 minutes after they took Ms. Marquez, the plaintiff, away in an ambulance.
But almost an hour.
And Your Honor, immediately after the fall, Maria Marquez, not the plaintiff, Maria Marquez is looking at the floor, showing that it's wet and showing that it's slippery, and it's on the video, and she testifies in her deposition that that's what she was doing in the video, is showing that it was wet and slippery. So that establishes that inspection, alleged inspection, was negligent in and of itself, and that's constructive knowledge. Now, we also intend to argue that she spilled something when she was walking through the area the first time, and that's actual knowledge. And so with regard to knowledge, that's plaintiff's arguments for knowledge. And when you look at everything in plaintiff's favor, which is the way it has to be done, Ms. Neal spilled her drink walking through. She didn't go back and inspect the floor. She had multiple opportunities to inspect the floor, including 2 to 4 minutes prior to the fall. She didn't inspect the floor. If she had inspected the floor, she would have seen what Maria Marquez saw when she looked at the floor, and that is that it was wet and slippery. She didn't see it, so the inspection was negligent. They had constructive knowledge, and plaintiff walked through the area and fell. And if Big Wake had done what they were supposed to do, which is inspect the floor and find the hazard, the fall would not have happened. And so that's when you're looking at in plaintiff weighing all of the evidence in plaintiff's favor. And we're just asking, Judge, we are saying what every plaintiff says in this case is let the jury look at the video You know, I don't think that it's not, I don't think, a defendant's testimony about the interpretation of the contents of a video is not dispositive on what the video shows. A jury's determination about the contents of a video is dispositive about what a video shows. If Ms. Neal says it wasn't me, if it wasn't me carried the day, you would never have a criminal jury trial in your courtroom.
Well, different standard, but criminal cases, we don't rely on something like that.
If it wasn't me carried the day, Your Honor, you'd never have a civil trial.
There you go. Okay.
And I will, we're done. Thank you for your patience this morning. Thank you for your time.
No. My patience is greatly extended in this case because of what happened with the ORCA process for the two sides in this. But it has been very helpful to see the video. I've seen stills because they were in some of the briefs, and to have them narrated by the two sides. I promised Ms. Wharton that she'd have the last word. It's going to be just a few words, so we can pivot to the next thing. But I do want to hear what you have to say in response to Mr. Cawthorn. Mr. Cawthorn, yes?
Logistics, is our court reporter capable of attaching the videos to the transcript in this case, or do I need to figure out a way to get it filed in, because the clerk wouldn't accept it last time when I showed up in person to try to get
the latter. You're going to need to figure out a way to do that. They should be willing to take a thumb drive or a DVD, and that just obviously doesn't get scanned in, but they take exhibits like that because it's part of the record. It's how we would then transmit to the Court of Appeals, in the same way with physical evidence. If we had a trial, you can scan in photos, but if her shoes were part of the evidence, that's got to get somewhere.
I understand. I was going to try to see if there was a way to do it by email, because the last time I tried to file it in person, no one at the clerk's office knew how to accept it. But I think if I'll just be a little bit more stubborn next time.
Okay, be stubborn, or I guess I know my court reporter who handles the record from criminal cases will often get the state to turn into digital format videos if they're not too large. I just don't know how large these are. If it's a gigabyte, she can't do anything with that. But if it were 2 megabytes, then that's a file. But it's a video. She can't. So I think you need to work with the clerk's office. If you run into a dead end, let me know, and together we'll work with the clerk's office.
Thank you, Judge.
Okay. All right.
Okay, quickly, thank you. First, with respect to the conjecture arguments that plaintiff made, this case is about pure conjecture when it comes to guessing what Ms. Marquez-Adame fell on. She has not put forth proof or evidence of what it is that she fell on. Her sister claims wetness. Petras claims it looked wet. Maybe it was grease. I don't really know. That is the exact textbook pure conjecture that is referenced and on point with this case and the cases that are cited in our brief that the Court of Appeals has repeatedly held. If you cannot put forward proof of what the hazardous substance is, you cannot establish causation, which is an essential element of negligence.
But you don't mean that Ms. Marquez-Adame has to say, I know it was Dr. Pepper. Not only was it a brown liquid, but it was Dr. Pepper. I slipped on Dr. Pepper.
Right, correct. But here was it green? Was it water? Was it greasy? Was it wetness? When the witnesses were asked, what was the size of it? What was it shiny? They said, I don't know. I wasn't paying attention. I wasn't looking at the floor. I just know it didn't look right. It was wet. And that's all that they can get. It cannot describe with any particularity.
Well, I'll look at Pipkin. The language that was on the screen looked like it gets us into that space that we're arguing over.
And then plaintiff just cited a case that is not cited in her opposition brief, that Pipkin versus the nursing home case, the 339 Georgia Appellate 390.
Yeah.
I haven't had the chance to read it. If the court would allow us
the
opportunity to just do a brief briefing on that, we would appreciate that. But what I could tell, at least just from the brief overview that plaintiff had up on the screen, looked like there was a cart and mop bucket around, possibly. Again, there is a source then of the wetness.
I noticed that there was an additional element.
Separate,
Yep.
which is not the case here.
Okay.
With respect to the claim that the inspection was negligently done, it was a non-inspection of the area. The law says that a reasonable inspection has to be done. This body of law, premises liability law, is all about reasonableness. Reasonable inspections, giving the defendant the reasonable opportunity to inspect and remove the hazard, giving it a reasonable amount of time. It is not reasonable, and the courts have never held that it is reasonable for an inspection for employees to have to shuffle around an entire store with their head down, analyzing every single tile of the floor. In all of the cases cited that I discussed today in our brief, the Court of Appeals held that where an inspection was done within that 30-minute time frame, so one case was 5 minutes, one was about 5 to 10, I believe, and one was 15 to 20 minutes, whether it was a manager, whether it was an employee, whether it was a security guard, all of those folks testified that during that time frame, they did the inspection and they found no hazardous substance on the floor, and that is on all fours with exactly what Ms. Neal testified.
I want to make sure, though, that I'm not going to pin you down to something that you're saying, wait, that's not what we're saying. Exhibit D, we watched.
Yes.
And there was a point in time when Ms. Neal was at that cleaning station, and Mr. Cawthorn said, this is what Big Wake is claiming was the inspection. Is he correct that point in time when Ms. Neal shows up, she puts some trays down at that cleaning station and is present at the cleaning station, and it's just a few moments before Ms. Marquez-Adame walks by and slips and falls, although a few people pass through there after that. That's what you're calling the inspection?
She comes through twice. She comes through first, she walks towards the, they call that a kiosk, that little station. She comes towards it at about 9:02 and she puts the trays away. Then she comes through again. But yes, that first time, when she is, actually, I believe it's the second. It's when what's cited in our brief, if Wick wants to pull back up the video so that we can talk about time exactly. I know you're running out of time, Judge. But what's cited in the brief is that it's at 9:03:41. And that's when the plaintiff is also seen walking in. You can see Ms. Neal and the plaintiff in the same frame. Ms. Neal walks directly towards the area. Her head is facing towards the area of the fall. And then she is at the kiosk and then turns around and walks kind of in the direction of where those booths are at.
I don't remember the timestamp, but Mr. Cawthorn played several times what he said, this is what Big Wake says was the inspection. And I'm remembering specifically what Ms. Neal did and didn't do in that segment. I just want to make sure you are agreeing that that's what Big Wake is labeling the inspection. Because if you feel like there wasn't a segment he played, I guess the other thing is you guys can get me Exhibit D so I can watch it. But
yeah, I don't want to speak incorrectly on the record because I don't know what the timestamp was on that of what he was referencing. But the timestamp of when she identified herself on the video at 9:03 a.m. Is when she's approaching the hostess stand and the plaintiff is behind her, and she testified that she moved around the restaurant. She was making sure that all areas, including the floor, were clean for the guests. And if she had noticed anything, she would have cleaned it up immediately. She identified herself in the surveillance video footage at 9:03 and recalls that at that time she saw nothing on the floor. Okay.
Mr. Cawthorn, put that back up, please. Exhibit D. I don't want us to leave and then later on Big Wake says, no, that you looked at the wrong thing. That wasn't what we call an inspection.
I'm pulling it up.
Thank you.
Let's see, share.
Deputy Gordon, what time is it really? This clock and the clock on my computer are 8 minutes apart. 10:56. All right, so +1. All right.
30. Okay, okay. I think this is the one where.
All right, this is 9:03. Okay, so rewind okay, great. Play, please.
This is the last one, the second one. We played this one. because that's where plaintiff is right there.
The area.
Okay, got it.
Okay.
What else?
Judge, do you want me to leave it up, Ms. Wharton, or do you want me
No,
to?
you can take it down. Thank you.
Thank you, Rick. I appreciate it. So under Georgia law case precedent, an inspection like that, where the witnesses testified that they did an inspection, that they did not identify a hazardous substance on the floor that was within that 30-minute time frame, has been found adequate as a matter of law. The linchpin of plaintiff's cases, did Big Wig have superior knowledge of an alleged hazard? And the answer is no. She cannot carry her burden of proof there. And then with respect to the inspection after the fall, the 9:48 a.m. when the wet floor sign, that happened so far after the
You don't need to address that.
accident. So many people walk over the area, the firefighters, I'm sure, we'd have to examine the video, but I don't know what people had in their hands and.
It just, to me, it's an example of what Mr. Cawthorn is saying. This is what an inspection ought to look like. And so he's contrasting it to what Ms. Neal did or didn't do in the segment we just watched for the third time. But I'm not going to get hung up on, oh, look, there's proof that there was water on the ground. So many intervening events happened that it would be too much of a stretch to say it's the same, whatever it was that Ms. Marquez-Adame may have slipped on.
That's Judge, that's all right. That was intended to show that we've got evidence to show a jury to contrast what an inspection looks like.
Got it.
Right, but the Court of Appeals has never held that an inspection, a reasonable inspection, includes shuffling around on the floor and examining every tile of the floor.
Okay.
So again, this case is on all fours with prior precedent. It's important to note too that plaintiff had the opportunity to cross-examine Ms. Neal about her inspection and didn't ask any of these specific questions. Plaintiff had the opportunity to do that and didn't ask about the inspection. So I want to make sure that that's part of the record.
Okay.
And to plaintiff's notion that the video should go to the jury because the defendant's interpretation of the video is not what's sufficient, it should be the jury's interpretation of the video. I mean, Ms. Neal testified that she did an inspection that day. I mean, it's not a matter of whether or not, we have.
But if there is, I'm gonna push back a little because you said you weren't gonna talk so much. Ms. Neal has made a record and she's testified to certain things. Mr. Cawthorn has presented video evidence that he says isn't entirely consistent with that, or at least it would give a fact finder an opportunity to make its own independent conclusion. Well, what does inspection mean? And standing in and around the kiosk might be different in a fact finder's mind than what an inspection means to Ms. Neal. So I hear you what's in her deposition, but the total record available right now is not only deposition testimony, but and affidavits from 2 customers, but also video testimony where a fact finder can see collectively for itself if it's a jury, if it's a bench trial, the judge. This is what the thing labeled an inspection consisted of. And so a fact finder on its own can decide, did she look down? Did she not? Did she look in the direction of the spill? Did she not? What was involved with that? And it can be contrasted with another example of an employee doing what that person might say was an inspection, all of which is in the record right now that I have to navigate.
And with respect to those affidavits, I know you were asking, we saw those 2, the man in the booth. The man in the booth that's without the woman was Greg Anderson, who made the affidavit, and then the man that was with the woman, the older couple, that was Walter Brown.
Got it.
So that's both of those affidavits. They were sitting right next to them when the fall occurred.
Okay.
And they both in their affidavits said that they did not see anything on the floor before or after. So and again, I just want to thank the board so much for letting us do this again. We understand that things happen.
No, but I appreciate now
Through the cracks.
why you all wanted to have a hearing too, because the briefs are helpful, but to engage and see some of the footage addresses both did Ms. Neal spill and was it an inspection? And seeing those videos was very helpful. Okay. All right. Mr. Cawthorn, anything procedurally?
No, sir, I'm gonna work with the clerk's office to make sure that we get all of because the depot exhibits from the 30B6 into the record, which are what was used today.
Okay, good. I apologize that we muted you briefly. It wasn't because we were tired of hearing from you. That wasn't it at all. There was a technical hiccup and then I clicked on the wrong thing. I may reach out to both of you if I want the videos to watch again. And I know they'll probably come from Mr. Cawthorn, but I won't ever just reach out to him. I'd reach out to lawyers on both sides. And similarly, I may reach out to both of you if I want one side to prepare a proposed order. The other side will, of course, get a chance to preview that. It wouldn't be to rebut it. It would just be to make sure that there's not a misstatement of, hey, that's not what I said in court, or that's not an accurate recitation of X, but not a, hey, I disagree with your legal analysis. Because if I do send out that email, it would be side X. I think you've got the better argument, so get me a proposed order saying motion granted, motion denied. Okay. But I will prioritize this given that this is your second time through this process. Ms. Wharton, anything else?
Thank you so much. We appreciate it.
Mr. Cawthorn?
No, sir, I appreciate it. Thank you for your time.
All right, you guys have a great weekend.
Thank you so much. Bye,
Bye.
Ms. Nelson or Ms. Anyone else who's on the call, do I keep this going or do I cancel this and open up a different one?
You keep this one going right now, Judge. It's a different one.
Okay, great. We have a few minutes to get started with the plea, and then we have to pause, and then we'll finish the plea. But I have the chief judge coming. That was supposed to be at 11. I held him off a little bit because this took longer. So we might as well get started, and then we're going to take a quick break, and then we'll finish it. So if you will, I need the 2 case numbers, please. You guys should come up to the podium, Ms. Taylor and client, and I need to add the witness.
And then I have the case numbers for you.
Okay.
I've got 11 o'clock. 1A.
I'll manage 1A for you.
Thank you.
I just see a motion for a new trial.
It's happening this afternoon. It was supposed to start at 10 this morning, but we moved it so we could do that motion for summary judgment and this situation.
Non-conference, it's hard to know who you is.
Yeah.
Got to ask them, you know.
Yeah.
Which judge do you?
I went up to 6A, and it's to 6 to court administrator. They said 1A Brandon Brooks
Okay, that'd be,
is what it's supposed to be. They got digital boards outside the door, but what they say, coherence to that. Well, honestly, it just takes for time. Until the courtroom, the judge notices. One day they're gonna get that going.
All right. I need those 2 case numbers.
23 SC 191437.
Yep.
The second's 24 SC 004271.
And we're going forward on both?
Yes, Judge.
All right, Ms. Rivers, are you ready?
Yes, I am. Good morning.
Good morning. All right, we have Mr. Bateman here in court with his lawyer, Ms. Taylor, and we are taking pleas on 2 of his cases, 23 SC 191437 and 24 SC 004271. We are at the trial calendar phase. If we don't resolve it today, these cases will move to the trial calendar. However, Mr. Bateman's final plea rights are preserved. So Mr. Bateman If I sentence you to more than what Ms. Taylor asked for, you'll have the ability to talk with her and say, well, no, thank you. I'd rather go to trial. Or you may say, that's not what I was hoping for, but I'll roll with that rather than go to trial. But you will be able to have that conversation and then let me know, yes, I want to go forward with the plea, even though it's not quite what I asked for. Does that make sense?
Yes, sir.
Okay. And unfortunately, like I said, we're going to have to break it into two pieces. We got about 10 minutes to get into this, and I got to go into my jury room for a little bit, and then I'll come back out and we'll finish it. So we will finish it before you go to lunch.
Yes, sir.
All right. Ms. Davis is going to put you under oath, ask you a bunch of questions. You saw this happen yesterday to other people. Same kind of questions for you. We'll get as far as we can in the next 10 minutes, and then we'll finish it up when I return. Okay. This is the court reporter from a different event, so don't worry if she's not typing while we're talking. Ms. Rivers is on virtually. Okay.
Yes,
And Deputy Gordon, are you Mr. Heath? If you could get his case number and give it to me, I'll look it up, figure out why he's here and let you know. My guess is you're going to be able to leave in about 30 seconds. I just need to look it up. All right, Ms. Davis, when you're ready.
A question, Judge.
Yes.
Do I go over the plea, like, I guess the facts for both cases in this, or do I?
Yeah, so what you're going to do is
Sure.
go over all that. You understand you have the right to a lawyer and you're waiving these rights, all the colloquy. When it comes to factual basis, you'll say, Judge, in case ending in 437, had the state gone forward, we would have shown X. And in the case ending in 271, had it gone forward, we would have shown Y.
Okay, good. I just wanted to make sure. Thank you, Judge.
Yep.
Mr. Bateman, please raise your right hand.
Yes, ma'am.
Do you swear or affirm the testimony you shall give in this matter before the court should be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Please state your true and correct legal name.
Name is Lionel Maurice Bateman.
Please spell your first name for the record and last name.
LIONELBATEMAN.
Thank you. At this time, are you taking or under the influence of any alcohol, drugs, or medication?
No, ma'am.
Is there any medication that you normally take that you have not been given today?
No, ma'am.
How old are you and how far have you gone in school?
I'm 32 years old and I made it to the 10th grade. I'm a sophomore.
What school did you attend in high school?
I got a GED, but I went to maternal school.
Okay.
You said alternative school
Yes.
in the Atlanta area, or did you grow up somewhere else?
Now here in the Atlanta area, I got a GED.
Got it.
Are you able to read, write, and understand the English language?
Yes, ma'am.
Are you a United States citizen?
Ma'am.
Are you a United States citizen? Do you understand that you are charged with the following offenses in 23 SC 191437, possession of a Schedule I substance with the intent to distribute, and that would be cocaine?
Yes, ma'am.
Are you aware of the indictment for 24 SC 004271? Judge, we are moving to null pros the first count, which is a DUI, and proceeding on count 2 and 3, which are willful obstruction of the law enforcement officer and failure to obey a traffic signal or light.
All right.
And are you aware of that as well, Mr. Bateman?
Yes, ma'am.
Okay. Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial.
Yes, ma'am.
Have you had enough time to speak with your lawyer, Ms.
Yes.
Taylor, about all the facts and circumstances known to you regarding both indictments, including any potential defenses?
Yes, ma'am.
Do you need more time to discuss these cases with your attorney?
No, ma'am.
Are you satisfied with her services?
Yes, ma'am.
Attorney Taylor, do you waive formal reading of the indictments and any and all defects therein for the purposes of this plea?
We would waive a reading of the indictments and any defects for purposes of the plea.
Thank you. Mr. Bateman, do you remember having been arrested on these charges?
Yes, ma'am.
Your Honor, the state is unaware of any outstanding warrants related to both of these indictments. Attorney Taylor, are you aware of any outstanding warrants related to these matters?
No.
Mr. Bateman, has your attorney advised you of the minimum and maximum sentence for each charge to which you are pleading to today?
Yes, ma'am.
Do you understand that today you are entering a negotiated plea of guilty, which means the state will recommend a sentence to the court?
Yes, ma'am.
Do you understand that the court is not required to accept the state's recommended sentence? Do you understand the court has a right to sentence you to the maximum possible sentence on each charge?
Yes, ma'am.
Do you understand that there are multiple charges to which you're pleading guilty today, and the court has the right to run those sentences consecutively or one after the other?
Yes, ma'am.
Do you understand? Sorry. Do you understand that if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes, ma'am.
Do you understand that you are not allowed to possess or use a firearm while on probation?
Yes, ma'am.
Do you understand that this plea may be used to enhance sentencing in other convictions in this jurisdiction as well as other jurisdictions, including the federal courts?
Yes, ma'am.
Do you understand that if you are not a United States citizen, a guilty plea conviction will affect your immigration status and will result in deportation, just like a conviction at trial would? That is true regardless of any advice by an attorney or anybody else.
Yes, ma'am.
Do you understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm or use a firearm in a crime, that will be guilty of a felony, which can carry a sentence of from 1 to 15 years in prison?
Yes, ma'am.
Do you understand there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be from a conviction following trial?
Yes, ma'am.
For example, your guilty plea may affect the right to vote, to hold public office, to serve on a jury, to obtain a passport, to receive, possess, or transport a firearm, or impact the ability to obtain employment.
Yes, ma'am.
Do you understand that you waive any and all defenses, including mental health defenses, by entering a guilty plea?
Yes, ma'am.
Do you understand that by pleading guilty, you're giving up the following rights: the right to a trial by jury,
Yes, ma'am.
the right to remain silent and not incriminate yourself,
Yes, ma'am.
the right to confront witnesses against you,
Yes, ma'am.
the right to the assistance of counsel hired by you or to court-appointed counsel if you cannot afford an attorney at a trial of your case,
Yes, ma'am.
the right to the presumption of innocence,
Yes, ma'am.
the right to testify on your own behalf and to present other evidence,
Yes, ma'am.
the right to subpoena witnesses and compel the production of evidence,
Yes, ma'am.
the right to have the charges against you proved beyond a reasonable doubt,
Yes, ma'am.
the right to appeal if convicted of these charges after a trial.
Yes, ma'am.
Do you understand that you have only a limited right to appeal a guilty plea conviction?
Yes, ma'am.
Do you understand that you only have 4 years from today for a felony charge and 12 months from today for a misdemeanor charge to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes, ma'am.
How do you plead to indictment 23 SC 191437 to the count of possession of a Schedule I controlled substance, which is cocaine?
Guilty.
Judge, he wants to enter an Alfred plea on those charges and wants the state can recite about the facts that you will see why we are asking for an Alfred plea.
Got it.
He wants to plead under Alfred. He believes it's in his best interest. He does not agree with the fact that he is guilty in the case, but he wants to take advantage of the plea negotiations.
Okay. Is that to both cases or just the first one?
Just to the
drug case?
Right, the drug case.
Okay.
Judge.
Mr. Bateman, in 24 SC 004271, you're charged with willful obstruction of a law enforcement officer and failure to obey a traffic signal or light. How do you plead?
I'm guilty.
I'm going to pause you all there. I would like to get from pretrial your criminal history, because then pretrial can sign off, because then we got to take a break, and I just want to excuse as many people as possible. So, Ms. Washington, did you get a chance to gather any criminal history information on Mr. Bateman?
Yes, Your Honor, I do. Do you want the whole criminal history?
Actually, I'd like to know how many convictions you found and whatever activity there's been since 2023. His arrest in the second case was actually a couple years ago. So I'm interested in most recent activity and then how many total cycles and felony convictions.
Okay. There are a total of 19 arrest cycles. The last arrest appeared to be the case that's on your calendar today, the one from October of 2023. So that was the last arrest. In regards to the felony convictions, there are one in 2021, one in 2009, 2006, and 2002. So I believe that's a total of 4 felony convictions that are listed.
And the one from 2021 is for what?
The one from 2021 is from Fulton County. It's for aggravated assault, possession of a firearm during, burglary in the first, possession of a firearm during, and possession of a firearm during. So that's 3 counts.
Got it. Okay. Thank you so much, Ms. Washington. You have a great weekend.
Thank you. You too.
Mr. Heath, you don't have court today. I did sign an order earlier this month, a couple weeks ago, terminating your probation early because everything had been going well. We had a hearing on it because there's a victim in your case, and I needed to make sure the state had contacted the victim, who said, I don't have an objection to Mr. Heath's probation being terminated early. So I don't know if Mr. Hudson said you had court today. There's nothing in the system that says you have court. There was activity in one of your cases ending probation.
Judge,
Okay.
could you please ask Mr. Heath to contact his supervising officer because I have already uploaded that document you signed to our system.
Got it. Do you have a phone number for your probation officer? Call that person. All right, appreciate you being here. We are going to be at ease for about 15 minutes. I will have Ms. Hansberry or Ms. Nelson. Can one of you contact, I don't know if you want to reach out to like Hillary Porter or someone who would know what litigation manager is supporting non-complex today down in 1A. But Ms. Taylor is stuck here in 8D. She is not late to 1A. She just can't clone herself. And I want to make sure she and her client aren't getting sideways with, I think it's Judge Brooks. It's either Brooks or Mao who's covering the calendar today in 1A. I will be back as quickly as we can.
Yes, Judge, I'll do that. Thank you.
Yeah, thanks. Thank you. All right. And I will mute this. So you all. On. We are on. Hey, Ms. Rivers, you good to go?
Yes, I'm ready.
Thank you. So, Mr. Bateman, you had entered an offered plea to the drug case, regular guilty plea to the obstruction and running a red light. I got the criminal history, and I don't know what else is left. I know the factual basis is left, and obviously the state's recommendation, and then we'll keep pressing. Any questions before we do that? No, we're good? Okay.
Has anyone threatened, forced, or promised you anything to get you to enter this guilty plea
No, ma'am.
and or the Alford plea?
No, ma'am.
Is it your decision to waive these rights and enter this plea because you are in fact guilty
On
on the misdemeanor cases
the misdemeanor cases,
Yes.
and with regard to the felony charges?
Alfred.
Alfred.
Okay. And is this plea freely and voluntarily given with the full knowledge of the charges against you?
Yes, ma'am.
Your Honor, we believe that the facts would show at trial for the judge.
Is that your family here?
No,
No,
sir.
Okay.
For 23 SC 191437 on March the 17th, 2022 at 3263 Donald Lee Hollowell in Atlanta, Georgia and Fulton County, that officers with the Atlanta Police Department were performing a crime suppression in the area because of recent illegal narcotic activity. Upon their arrival at the location, which is a gas station, they noticed several males congregating around a vehicle in the parking lot. The males began to disperse the location. Some of them went inside the store. When the officers entered the store and began to search, they noticed that there was some abandoned Nissan vehicle keys next to the sweet tea case inside of the store. No one claimed ownership of the car at the time. Officers identified an abandoned car in the parking lot, which was a Nissan Altima. They smelled this distinct odor of marijuana coming from the vehicle as the vehicle's window was down. Officers began to impound the vehicle and did an inventory search. They located some drugs, one of the drugs being 4.767 grams of cocaine, and that was confirmed by the GBI. They also located in the center console a license belonging to Maurice Bateman, and some miscellaneous bank cards that were within a wallet. And that's how they were able to place the defendant, Mr. Bateman, with the vehicle where they located the drugs. They also reviewed the surveillance footage from the BP and saw Mr. Bateman place the keys next to the sweet tea. With regard to 24 SC 004271, on September the 30th, 2023, about 11 p.m., officers were in the area of 3263 Donald Lee Hollowell Parkway, Atlanta, Georgia, and Fulton County. They did observe a black color BMW that was attempting to make a turn, but instead of to make the turn, the vehicle ran through a red light. They also saw and observed the BMW cross the double lines and go around a car and then pull into an apartment complex. And it was at that time the officers activated their blue lights. Mr. Bateman exited the vehicle, took off running. Officer Coleman with the Atlanta Police Department announced himself, was in uniform with his badge prominently displayed, and gave him commands to stop. Ultimately, a couple of officers were able to stop Mr. Bateman. I believe he was tackled and tased. And so he was charged with willful obstruction and failure to obey a traffic signal. Judge, based on kind of the facts of the first case and how the drugs were located, we are offering a probated sentence. The offer, as my understanding, is 3 years probation to the one count of possession of a controlled substance, because it is around the 4-gram amount, which is a low amount of drugs. And the misdemeanor accounts can only be sentenced to 12 months each. So I guess it makes the most sense with 24 SC 04271 for the willful obstruction to be 12 months probation, and the failure to obey a traffic signal to be 12 months probation consecutive. And then with 23 SC 1914337, that is 3 years probation to run concurrently with the previous case. Mr. Bateman will also have to do a drug and alcohol evaluation and treatment if that is required, and complete 60 hours of community service. And that is the recommended sentence from the state.
All right. Thank you for that. Let me look up one thing, and then I'd like to hear from Ms. Taylor. All right. Ms. Taylor.
Thank you, Judge. That is the negotiated plea in this case, and he was offering the Alfred on the 4-5 case ending in 437. He denies that he was that he is on scene that he put any keys to that car by any key in that store. That was not his vehicle. He was riding with someone. His ID was in the vehicle. He understands the nature of the charges against him and what the evidence would be if he were to go to trial. He certainly, that's why he wants to enter the plea of guilty under the terms of offer. He understands that he could be found guilty based on this set of facts and circumstances and the possible testimony of the officers at that hearing. But he was not seen at that vehicle or anything, seen doing anything, that his ID was in it, but it was not his car. So, and then Judge, on the second case, the traffic case, we would ask that you go along with, like I said, the negotiated plea of the case. He indicated he's 42 years old. He hasn't had any arrests just since that incident in 2023. And it indicated to me he wants to do what he's supposed to do so that he can hopefully one day file for to get his record clean. I said, and the way he could do this by getting a pardon, and you have to, go for a period of time and show yourself approved and be a good citizen. And certainly it's possible to do that. He was working. I don't know, you tell me you had any children. I'm sorry.
I have two
children,
12 and 10.
12 and 10 years old. And I've talked with his significant other, the mother of those 12 and 10-year-olds, and he does support his children. And like I said, he's been to court whenever he was asked to be here. I think he is still on probation from that 2021 case, Judge. I understand that this is going to run concurrent with that. I think he had been compliant other than these cases. I don't know what they did when he got arrested on them, but this probation is to run concurrent with that. I think he has a year or two left on it. I'm not sure.
Okay, well, we're going to find out because Ms. Simpson's on the call, so she's going to get me up to date on that.
All right.
I'll turn to her in a minute.
All right.
Mr. Bateman, tell me what you do for a living.
My uncle, he owns site. He come get me from time to time to help him out. I'm like a helper.
Okay, and your uncle does what?
He owns his own business. He's the supervisor on the construction site.
Got it. So your uncle is in the construction business.
Yes.
And sometimes you help him with that.
Yes, but I had a job. I was doing road paving, but they laid me off because my feet is flat and I can't stand on my feet too long.
Okay. Have you ever applied for disability?
Yes, sir. That's what we're on right now.
Okay. How often do you do work with your uncle?
Whenever needed, he might just call me like I can leave here, call me and say, hey, did you come to work today?
Okay.
Stuff like that.
But is it typically like you do it once a week, once a month, 5 times a week? How often?
Lately I've been doing so all this month. I've been doing all this month, but he just called me when needed because I'm his nephew.
Okay. And you said you were doing some work where they roll paper?
No, the name of the company is roll paving when they lay down the asphalt on the street. They lay down.
Got it.
Yeah, they lay down on my feet due to my feet is flat.
Okay. So what kind of work have you done where it doesn't hurt your feet?
Just with my uncle, he hasn't gone around looking the material, make sure everybody show up properly and sign the paper in and out, make sure everybody is there on time, stuff like that.
Okay. Got it. You've got 2 kids. Do they live with you?
No, sir. they live with mom.
Okay. When you were here yesterday, you were with a young lady.
That's my wife.
That's your wife. So you're married. She's not the mother of the kids.
No, sir.
Okay. Does she have any kids?
No, sir.
All right. So just the two of you live together?
Yes, sir.
All right. And what part of Atlanta do you live in? Or do you live in Atlanta?
Decatur.
Decatur. All right. So you're a DeKalb resident.
Yes, sir.
Any reason why you would need to be on Donnelly Hollowell?
No, sir.
You don't have family that lives there?
Yes, my grandparents, they stay in 766 Alpha Road on Bolton Road. They've been living in the house 42 years. I'm 42 years old. They've been living in the house 42 years since I was a kid.
Your kids and their mom don't live off Donnelly Hollowell?
No, sir. No, sir.
Okay. All right. Good to know. Do you have any questions about anything?
No, sir.
All right. Well, Mr. Bateman, I find there's a factual basis for your plea in both cases. I appreciate Ms. Taylor explaining how it is that your wallet and your ID and your bank card ended up not just on the floorboard, but in the center console of the Altima that had the cocaine in it. And a jury would wrestle with it. They might say, I don't buy that, that's not your car. Or they might say, yeah, that's a tough one. We don't find that the state proved beyond a reasonable doubt that you were the only one who had access to the car. And if the state can't prove that, then maybe the jury doesn't find you guilty of the drugs. But it's risky to go to trial on that. And so you're saying I'd rather work it out. The other case, clearly that was you ran, they caught you, they tased you. Maybe you don't run next time if you run a red light and they pull you over. But you're pleading guilty to that. I find that your pleas are knowing and voluntary. Voluntary means no one's forcing you to enter these pleas, and knowing means you've understood all the things that Ms. Davis and I have been talking to you about. Do you agree with both those?
Yes, sir.
Then I'll accept your plea. I'm sentencing you pursuant to the Probation Options Management Act, which means that while you're on probation, if you have a technical violation, that means you miss a meeting or something minor, you and probation resolve it. You don't have to see a judge. If it's more serious, you get arrested for something, that comes back to me and we work through the consequences. Ms. Taylor, can someone in my office sign both indictments? I think one of them is technically an accusation, but both charging documents indicating Mr. Bateman's two pleas.
Yes, Judge.
Ms. Davis, can we sign for you?
Yes, Your Honor.
And Mr. Bateman, is it all right if someone signs on your behalf?
Yes, sir.
We'll do that. So I have to ask, yesterday you were dressed very nicely, red jacket, white shirt, and a frilly bow tie. Today we've got kind of maroonish velour, plum velour. Where do you get your clothes?
I go to Riches and Sets.
Okay. And where do you get money for that kind of stuff?
My wife, she support me, and my uncle as well.
Your uncle, the construction guy?
Yes, sir.
Does your wife work outside the home?
No, she works from home. My wife, she actually works for the Boys and the Girl Club. She is what is that?
I don't.
I mean, she's like
Your
a
wife?
she is like a director for the Boys and Girls.
Okay.
Club.
But she's able to work out at home?
Yeah, she works remote from home.
Okay.
From a computer.
Got it. But she makes enough money that you get to dress like that?
Oh, yes, sir, absolutely.
Okay. Well, I hope you treat her well. Your two kids, boys or girls?
My 12 years old is a little girl, and my 10 years old is a little boy.
Okay. How often do you see them?
I see them like once a week.
Okay. All right. Well, Mr. Bateman, in 23 SC 191437, I am sentencing you to 3 years probation. Special condition of probation is that you not be on Donnelly Hollowell Parkway. Don't be on it. Don't drive there. Don't go to a gas station there. Stay away from it. That street and you don't get along well. Okay?
Yes, sir.
So if you got to go visit your grandparents, figure out a way to get there where you don't go on Donnelly Hollowell.
Okay.
You'll submit to a drug and alcohol abuse evaluation. That's not me telling you that you abuse any drugs or you have an addiction, but it's going to have a doctor or a professional just talk to you about what you do and how things go. And if that person recommends any treatment, that might be going to some meetings or something, that treatment will be part of your probation. And finally, you'll need to complete 60 hours of community service. You'll need to have completed at least 30 of those in the first 6 months of your probation.
Okay.
All right?
Right.
We'll be reporting in DeKalb County. Ms. Simpson, who's on this call, is going to give you reporting instructions. But I think that's way out in Conyers somewhere where you first plug in.
Yeah, yeah.
You know where it is.
Probation officer, that's why I go now, no
Got it.
report.
And you may end up having the same probation officer. I don't know. You'll figure that out.
Okay.
You have a second case, and that is 24 SC 004-271. Was the DUI, like, what makes this a felony? Was it all misdemeanors?
That is a good question.
Student judge, they lie, I heard,
Okay, just.
oh, go ahead. Okay, let you tell.
Well, I'm curious why that case is here, not meaning in front of me, but it looks like to me 3
I said that. in the
misdemeanors.
I said the same thing.
Marijuana, you know, the GBI and their testing requirements for marijuana. So it was like over a threshold, but non-threshold, where you be able to test it.
And then the state decided not to prosecute that count?
Yeah.
Okay.
It wasn't tested.
Got it. So it got kicked over from state court to you all, and they're like, well, we'll keep it. Okay, well, neither here nor there.
Right, and what he was trying to say was, he fussed about that. I think it was the same officer involved.
Yeah, he go harassing me,
It
yeah.
actually was the same officer from the 2022 case.
Another reason to stay off of Donnelly Hollowell.
That's the first thing I told him, Judge, when I looked at both the cases. Why would you go back over there?
Because that officer may be on that same beat, and he's going to see you've got a distinctive look, and he's going to say, you know what? You didn't signal, and you may not have signaled. He can pull you over because of that.
That's what he's saying, that basically, and that's not the only, he's been stopped by that officer several times with no charges. He feels like the officer's harassing him.
Well, I'm not going there. I don't know if
That's what I told him.
Officer probably doesn't appreciate some of the things you've done, but if you stay away from there, we don't need to worry about that.
That's right.
Here's what I'm doing with the case ending in 271. Count 1, the state has dismissed. Count 2, I'm sentencing you to 45 days in jail. Count 3, 45 days in jail. You've already done that, so it's a time served sentence. It's not going to say that on there. It's going to say 45 days in jail, but you're going to get credit for the time that you've already served. It doesn't make sense to put you on misdemeanor probation as well. That's actually a different agency. You'd be reporting in different ways. Super complicated. Last thing we need. You're going to be supervised. It's just going to be through felony probation. So 45 days to serve, count 2, 45 days to serve, count 3. That closes out the 24 SC case.
Okay, you understand that?
Ms. Simpson, how are you?
How you doing, Judge?
I'm great. How much time remains on Mr. Bateman's 21 case from DeKalb?
So that case, is not in DeKalb, it's actually ours.
Oh, it's our case. It's being supervised in DeKalb.
Yes.
Yes, Judge.
Got it. How much time is left on that?
So he has 3 years, 5 months, and 22 days remaining.
All
And
right.
he already had a revocation on that case.
That was question 2. So this plea is not going to create a revocation issue on the 21 SC case for Mr. Bateman.
No, Judge, he had his revocation with Judge Carnicel right after his arrest.
Got it. What did she do?
She revoked him, give me a second because I already have it up. He was revoked 45 days and reinstated.
All right. There's that 45 days again. You're getting a lot of mileage out of those 45 days. Don't get arrested again while you're on probation. I might not give you just 45 days. You'll be on probation. It will be supervised out of DeKalb because that's your address. This sentence will end before your other sentence ends. You've got about 5 months more on that other case, but they're running together. It's one officer. You're not going to have to report in 2 different places or anything like that. Ms. Simpson, what are the reporting instructions for Mr. Bateman?
He needs to contact his supervising officer on June the 24th at 8 a.m.
Okay, meaning he should show up at the office, or at 8 a.m. he should call that number?
He can call his officer and they can advise if they need for him to come in the office. They probably do because they have to go over the conditions of this sentence.
Okay. All right, but now you've got me confused. On June 24th at 8 a.m., is Mr. Bateman supposed to be in Conyers at the probation office, or is he supposed to be picking up his phone to call officer so-and-so?
I would advise him to call before the 24th and find out if he needs to come in. And if they say, yes, you need to come in, then his reporting date would be the 24th.
Got it.
He needs to let them know, I've been given a reporting date for the
You don't know?
24th. If I have.
Okay. Got it.
Okay, and he right now is on call-in, so he doesn't really have an officer. So I guess he would just call
He has an officer.
I know, but I'm just saying he because he calls in that he doesn't have, there's no officer's name is what you're saying?
Yes, I want to know exactly who I called in, so I have to give, so
Okay,
I will get all that.
let me give you that right now.
Okay,
Yes.
Are you ready?
yeah, I'm ready.
The officer is, and I'm going to have to spell it because if I'm going to butcher this last name. It is N as in Nancy, G as in green, E as in elephant, N as in Nancy, E as in elephant. There's a hyphen, and then there's I as in igloo, G as in green, W as in west, E as in elephant.
Okay,
And the cell phone number is area code 470-423-1838.
okay. We'll make sure that Mr. Bateman has this information in his phone before I leave here. Before he leaves here, we'll make sure he has this information. I have it, plus I will email it to Mr. Bateman to remind him.
Okay, thank you.
All right.
So, Mr. Bateman, you understand, you got to make contact with that officer. That officer may say, don't worry about it, you don't need to come in. But you're telling that officer, I was given reporting instructions, June 24, 8 a.m. And that person is going to say, yep, I need to see you then on that day. Or that person may say, don't worry about it, here, we're good.
Date or whatever.
Yeah.
Right.
Okay.
But call them before the
Yeah.
24th.
Yes, ma'am.
If I'm you, I'm gonna call them, next week.
Yes, ma'am.
All right.
To put a real clear polish on it,
Right.
if probation tells me you didn't show up on the 24th, they're going to give me a warrant to sign. I'm going to sign the warrant. So just make double extra sure that either you show up that morning at that place or your officer said, no, don't worry, you don't need to go.
Yes, sir.
And then you're in a good space.
Okay.
All right?
All right.
Ms. Taylor, anything else on behalf of Mr. Bateman?
Nothing else from us, Judge.
Ms. Davis, on behalf of the state?
No, Your Honor.
All right, I'm sorry you guys had to stick around that extra time, but better than going to trial. So appreciate all this.
All right, Judge. And I'll get a copy of the sentence as well and get that sent over to you, okay?
Okay.
Now I'll get that next week because the judge has to sign it, has to be filed in the clerk's office.
Yes.
Ms. Taylor?
Yes.
He's gonna he's gonna have to sign it when he report. That's why I say he's probably gonna have to go in the office just for that quick moment because
Right.
there's a signature place on the disposition that they have to sign.
Okay. So, he got to sign it
When he contacts his officer, that's why I
I
say his
got you.
officer is probably gonna have to have him come in. It'll be just for a quick moment, but there's a space that the
Got the
defendants
name?
have to sign.
I'm gonna text it to you too.
Okay.
Make sure you got it.
Yes.
All right. Thank you.
Good luck.
All right.
Thank you, Judge. That's all I had to maybe excuse.
June
Yes, ma'am.
June 24th.
Uh-huh.
Okay.
Like I said, I'm checking all the shit.
Judge, was those the 3 years for both counts?
No.
There was only one count.
Oh, I'm looking at 2.
Well, let me look. I got the indictment here.
Just one count.
The indictment's just one. The calendar says 2 things, but the indictment is just cocaine.
Oh, okay. Thank you, Judge.
You're welcome. All right, so Ms. Nelson or Ms. Hansberry, anyone on this call, do I leave this up for the Singleton matter or is DCS going to be dialing into the other Zoom, so I should end this? Thank you for sticking around. Appreciate it. Oh, no, you can be excused in just a sec. Mr. Armstrong's covering the motion for new trial. Are you going to make sure to do the bench warrants from the trial calendar? Good. Okay. Excellent.
Judge,
All right.
I'm not sure. I'll have to check with Michelle.
Okay, I'll leave this up then. And it may, I know because we had that hang up with the civil matter. So I'll leave this up. I'm just going to mute it now. I just don't know what DCS is going to be dialing into. They assume they have the link to the session that kicked us off earlier. And Ms. Simpson, you're welcome to stay on, but it's motion for a new trial hearing. So we won't be needing input from probation.
Okay, thank you, Judge.
You bet.
No, please leave it going.
Department of Corrections and everybody has this one.
Did you hear that, Judge?
I did. Thank you. I will leave it up.
Okay, thank you.
You bet. Don't see DCS. Ms. Hansberry, any info on our
I
friends
just
from?
reached out to them. I haven't heard back yet,
Okay, thank you.
but they were notified of the change.
Okay.
Judge, do I can find some dependent exhibit tags?
In the folder that you would have brought that has defendant exhibit tags in it,
That I used up?
you could look in the top drawer right there. I won't tell Ms. Rivers you're going through her stuff.
I think this is awesome. That was interesting. Amendments?
If you'd like to mark through the word states, I have some states exhibits.
This will contaminate your exhibits.
They're in a folder inside the drawer.
In that top drawer on the right?
Yes.
Okay, that's what I thought.
Okay. Oh, good.
Just give them one sheet.
Not bad. You're gonna sign the other.
I know you're going to bill us for it anyway.
For the record, should reflect that Mr. Armstrong did give it to me.
Is this one?
Oh, yes. Do you think they may be on the other Zoom link?
Your Honor, I forwarded the link that we received yesterday to Victim Services, and it seems that they can't get on the Zoom link either.
Right, we had an issue this morning. This was supposed to start at like at 11 this morning or something. I had things happen earlier this week that meant that I needed us to start at 1, and other things filled the morning. Some of them were on a different Zoom. That one didn't end as early as I had hoped. And so the Zoom link that you shared with the victim's family interfered with what was going on. It started up and took away the podium and put it on what I'm going to call the motion for new trial Zoom. We took it back and put it on the Zoom that had been set up for the civil hearing. And we've just extended that one out. So it's a different link. That's why I'm concerned DCS may be sitting on there with the victim's family. And so maybe everyone can work it out. Mr. Singleton and Mr. Grigley's family can make amends. But there's a different link for what you see on the screen. I'm happy to send that to you and you can push it out to everyone else.
Yes, please. But currently, we don't see anything on, there's one screen maybe, but everything else that we can see from our vantage point is not.
What's on your screen?
Completely dark.
Dark.
This happened before. I
Yeah,
used to it.
yeah, okay. Well, right now it's the podium and the witness are the only ones that are in.
That's the podium that is showing that what Mr. Hort is looking at is exactly like that on the near the witness stand.
Basically, yours is dark, mine just has your picture.
The podium one is dark?
The podium is the only one that has what you described, the
Correct.
podium and the witness.
Right.
That one's just dark and mine just has your portrait.
Handsome visage. Let's do this. What a day. All right, Mr.
That
Armstrong.
makes me feel great.
Oh, I sent you the wrong one. Don't. Here we go.
I will try to get on before I send it. See if it does something.
Hold on.
But I shouldn't try the one I just received?
No. All right. The second one that should come in a slightly different format that I just sent is the one you should try to get on. I believe. I should just make everyone show up in person.
The Marquez-Adame versus
Yes.
Gateway?
Yeah.
Okay. See if join works.
You sent it to me too, because I seem to have the same problem.
I'm going to send it to you and to Ms. Rolak the moment that I get, that I can see that it actually worked. So don't make things worse. Something's happening.
Something's happening.
Okay, so seems to work. All right, so. It is to your Hotmail address? Okay. Let me know when that goes through.
How you doing today, Ms. Ross?
I'm doing well, sir. How are you?
Well, better now that you're here. What would you otherwise be doing on this nice Friday than being back in 8D for a third time on this case?
Probably in some rural circuit somewhere.
Well, you're welcome then.
Some murders.
So Kevin, send that attachment.
Yes, I've sent what I received from the court. It
went in a weird format, but the Zoom should be in there.
It should be able to click on him.
What's on the screen now in front of you, Mr. Hort? The little screen.
Same thing as the podium.
Good. There's something wrong. Is your screen still black?
My screen, well, they turned my screen on, so I look at your handsome visage as you described it.
Your words. All right. It's not letting me get into the controller on that one to link it. Ms. Hansberry, any update?
Ms. Tillman's getting into the system now. She just got the new link. All right. Thank you.
Okay.
All right.
Here we go. All right, Coffee Correctional just joined. Need the camera to go on and we should be good to go. GDC, are you able to turn the camera on at Coffee?
Yes, sir. I just pressed open video.
There you go. You did it. Excellent. All right. Ms. Rivers, good afternoon. Are you ready to get us on the record?
Yes, I'm ready, Judge.
Great. Well, I apologize to everyone for the shifting times. We're supposed to start this morning. I had something come up. We're supposed to start at 1, but because of annoying technical issues, it was a different Zoom. And so I think we had some of Mr. Grigley's family on another Zoom wondering what's going on. And Department of Corrections were on the Zoom they were supposed to be on, but we switched over. But we've got everyone now. This is 00SC 09016, State versus Singleton. Mr. Singleton is appearing from Coffee Correctional. He is on the screen. I can see him. He can hear us. We have his lawyer, Mr. Hort, here in court. Mr. Armstrong is here representing the state. And we are on day, I've lost count, of a series of hearings in connection with Mr. Singleton's motion for new trial. Ms. Ross is here again. I think Mr. Hort has more questions for her. I'm going to start by letting Mr. Hort lay any procedural groundwork he wants to. I'll see if Mr. Armstrong has anything procedurally, and then we'll pivot to continuing to build the record.
Yes, thank you, Your Honor. I do have some procedural matters, but I also thought it might be better to wait and try to get Ms. Ross's testimony done today.
I bet she'd appreciate that. Help me remember to talk about procedural stuff when we're done with Ms. Ross. All right, Ms. Ross, if you'd come on up. Deputy Gordon will swear you in again.
Can't guarantee you it's some of my procedural issues.
Ryan, do you swear affirm that testimony you will give the truth, the whole truth, and nothing but truth, so help you God?
I do.
Lord, y'all see. Can you say this for your name? Correct.
Sheila Ross, SHEILA ROSS.
When you're ready.
Thank you, Your Honor. Thank you again for coming in. First question, anything you want to change in your testimony from the prior hearings?
No.
Would you agree as a prosecutor that if not the first rule, certainly a general rule, you don't ask questions you don't know the answer to?
Not necessarily.
Oh, a little bit learned that lesson with the O.J. Simpson case.
I didn't try that case, but maybe they did.
You are familiar with the black glove. If it doesn't fit, you must acquit.
Yes.
Okay. Do you have any objection to Mr. Armstrong providing us with your notes from this case?
What do you mean by notes?
Handwritten notes.
Notes she would have made contemporaneously, Ms. Ross, during the trial, or notes from an interview she might have had with a witness leading up to the trial, or all of it?
All of it for her work product in the case.
Okay.
I filed a motion for discovery, and I would reference that motion. And part of that is that Mr. Armstrong claimed this privilege, but then waived it because he did already provide us at least one note.
He's referring to a Post-it note that is on the back of one of the pieces of discovery that I turned over a year ago.
Was the Post-it note inadvertently included, or you purposefully included the Post-it note?
I included the things that I was turning over to him as they appeared.
Okay, in other words, you didn't modify anything.
I didn't modify anything. I wasn't making any decisions about it.
The Post-it note was attached to what?
Some document from discovery. It was on the back of it.
Okay.
That Post-it note, we've turned that over, so that's out there.
Understood, but the Post-it note was attached to, for example, a police report or something from the crime lab, and there just happened to be a Post-it note attached to it.
I don't remember what it was. It might have been those things like the defendant summary screens, the one that had like 404 or SB 440 listed for Leslie Singleton and not for the other two defendants.
Okay.
I don't remember what it was, but it was attached to one of the documents that was discovered.
A discoverable document. It was not a Post-it note attached to someone's notes, and the page of notes was what was included. Okay, all right.
Paragraph 9 asserts that the note was related to the statement of state witness, the bearer. And again, in the discovery provided by Mr. Armstrong to us.
Okay, so we actually have a question on the table that Ms. Ross needs to answer. I just had you clarify what you meant by notes, and it would be notes that Ms. Ross made at any point during her work on the Singleton Waters third guy case.
And does that remain your answer after our discussion, that you have no objection to those notes being provided?
Oh, she didn't answer the question. I interrupted and said, I'm sorry, what do you mean by notes? I didn't let her answer, and I apologize for interrupting, but I didn't want us to wade into, oh, that's not what I thought you meant by notes. But now I know what you meant.
I thought I heard a no. So anyway, the question. Do you have any objection?
Defer to the district attorney's office on what they're going to do on that matter.
Would you agree that these notes, even 24 years later, could be used to help refresh your memory?
Potentially. I have no memory of notes from this case, though. I'm sure I took notes because I take notes all the time, but I have no specific memory of notes from this case.
That is a good answer. And let me show you the note. Again, it's attached to our motion for discovery filed May 16. Is this your handwriting? Here I'm asking a question. I don't per se know the answers.
Right. Hold on a second. That does look like my handwriting, yes.
Any reason why it took 30 seconds to acknowledge it as your handwriting?
Because my handwriting has gotten sloppier over the years.
So you had to rewind 24 years to how nice was my handwriting back in 00?
It looks a lot nicer than than it does now.
Okay.
And sometimes, like me, you need to put your glasses on.
Well, there was that too, but
Just
it
fine.
made it easier too.
I have Ms. Wardell taking notes because my handwriting is so bad. Judge, did you want to rule on it now or wait? What's your thought on our motion?
I'd like you to keep asking questions. You said we were going to defer procedural stuff until after we're done with Ms. Ross, but she has on the record said her answer to the question, does Sheila Ross as an individual and the prosecutor from the case have any objection to the district attorney's office disclosing her notes, her work product? Her answer was, that's a district attorney call. My words, but that I think summarizes what she said.
Yes.
Okay. Next topic.
Thank you. Do you remember the assessment of Leslie Singleton and his family prepared by the Juvenile Department of Justice?
No.
Do you remember Mr. Gishard ever talking to you about this assessment or something similar like that?
No, I don't have memories of mine and Mr. Gishard's conversations about this case outside of court.
Do you know, Mr. Hort, if that assessment was prepared in connection with sentencing, sort of like a pre-sentence report, or if it was simply a report that was available that summarized how Mr. Singleton had done at the youth detention center during the time he was in custody?
Thank you. Yes, and Mr. Armstrong certainly can correct me if he has a different interpretation, but it's my understanding that it was prepared early on in the process. Unfortunately, that report is not available. It's lost, missing, whatever. And the person that wrote that report even knew Mr. Gishard has passed away also.
How do you know the report exists or existed?
When the court helped us actually look at the clerk's file, there was a reference in that file to that report.
Okay, so it's meaning it had been filed into the record?
Well, it was in the file, but as far as I know, it was not on Odyssey or anything like that.
It was in what file?
That file that you helped us.
The clerk's file?
Yes.
Okay, so when I said record, I don't mean, unfortunately, something you and I could easily find in Odyssey, but back in the era of this case, it would have been in the clerk's file so that if someone asked for the record of this case and was able to go through the physical file, of which we only have parts now, you think that DJJ report would have been in there?
It was referenced.
Okay.
And then from what we could find out when we actually then contacted the agency, it no longer is in existence. After X amount of years, they destroy the paperwork. And the person that wrote the report, again, she's passed away, so we couldn't talk to her.
Okay.
Mr. Ross, I want to show you what is remarked as defendant's proposed exhibit U. And Mr. Armstrong, let me likewise give you a copy.
I want to go back before we talk about proposed exhibit U. And you're not testifying, but I'm just trying to understand what would have been in, not the substance of it, because it could have said Mr. Singleton is a bad kid or he's a great kid, but what would have been in there? What's the nature of the type of information that would be in a report like that?
As far as I can tell, my belief is that it would have been similar to what we had done 20-some years later, Defendant's Exhibit A, an assessment of Mr. Singleton, his family, the good, the bad, the ups, the downs, that type of thing.
Okay. So it's something of a history of what's gone on in Mr. Singleton's life leading up to him coming into DJJ custody.
Even before that, it's up until when he then was arrested, because I understand it was ordered very early on. I don't think it was per se related to sentencing or anything of that much later on.
Okay.
Okay, back to defendant's proposed exhibit U. It's a report from the Fulton County Police Department provided to the defense by Mr. Armstrong. Does that include a case synopsis of what Debbie Blaylock and her daughter told the police?
Well, I read the first page, but not the second, because then I decided it was probably better to listen to His Honor than to read. So if you want me to read the second page, I will.
If you wouldn't mind, thank you.
They are both mentioned in here, yes.
Thank you. Was Debbie Blaylock's statements in defendant's proposed exhibit U and then also her testimony at trial truthful?
Objection, Your Honor. Why is he asking one witness about whether another witness's testimony is truthful?
So that's generally not where we go with, hey, did you believe this other person? I guess if Blaylock came in here and testified and it was inconsistent with what Ms. Ross was saying, I'd need to figure something out about that. But did you, maybe you mean to ask it in a different way, and I'm not putting words in your mouth, but is Ms. Blaylock someone who testified at trial?
Yes.
And was the question more, does this report, is it consistent with her testimony at trial? Or, because commenting on the veracity of someone, that's not what we typically have witnesses do. I didn't believe that person. That's not relevant.
One, she was the prosecutor. Two, Debbie Blaylock was one of their main witnesses because she also was a victim in this case. And two, we already had testimony from this witness that she believes Waters' testimony was truthful. So my follow-up question, what about this witness? Was her testimony, her statements truthful? And I think she can offer that opinion. One, again, as the ADA in that case, was there, you were not, the rest of us was not. So I think it's an appropriate opinion from this person.
Okay, Mr. Armstrong, anything else you want to say in particular in connection with, I'm not remembering it, I trust it happened, that we've already had an exchange about Ms. Ross's view of the veracity of Mr. Waters's testimony?
The fact that the defense has already asked her to comment on other witnesses' veracity doesn't make it any more relevant for a second witness.
Okay.
Ms. Blaylock testified at trial in the state, is absolutely relying in part on her testimony.
Okay.
But if there's a specific detail or something like that, that's really important to note. I think that that's something that if there's a record, it's the record that's going to speak to the difference. And I don't think just randomly asking people, was this witness truthful? Was that witness truthful? That doesn't seem relevant to anything that I'm aware of before the court.
Okay. I don't think it's a random request, but I agree on the relevance piece. Mr. Hort, if there's something in the document that Ms. Ross has in front of her that you want to ask about, as in her report, she says it was dark out, but at trial, she didn't testify that it was dark, or she said it was light or something different, we can explore that, but I'll sustain the objection as to the generic and summary assessment of, yes, I believed her or she was truthful.
Let me try this first. We would move to have admitted in evidence defendant's proposed exhibit U, which again is the case synopsis of the testimony statements given to the police department by Ms. Blaylock and also by her daughter.
Any objection of Mr. Armstrong to the admission of defense U for purposes of this hearing?
Yes, Your Honor, it appears to just be 2 pages of a longer document. And so I would submit that the whole document we don't have an objection to as far as being part of discovery. Coming in from the truth of the matter asserted, that's a different thing. We object to that. But as far as showing what was in discovery, we don't. But we would like the actual full synopsis as opposed to an excerpt.
Okay. I know, Mr. Hort, sometimes you give us everything you've got, and you may only have 2 pages from a larger document, which highlights another issue 25 years later. Do you have the whole document? And if so, is there a reason why we're only working with a few pages? Or is Mr. Armstrong misreading this? And that, in fact, at the very bottom of the 2nd page, it says end.
Yes, I do have the whole document. And for some reason, I kind of guessed Mr. Armstrong would make this objection. So I do have that whole document. My purpose in just doing U was to what Ms. Blaylock said and what her daughter said.
Okay.
With the rest of it to not necessarily being something this court needs to know. But again, if that's the preference, I can certainly.
Well, but I heard Mr. Armstrong's objection being a little different. I noticed what you held up, like has a photograph on it, for example, and that may well be Sergeant Grigley. But
yes.
What Mr. Armstrong said to me was there's more to her statement. In other words, there's a page 3 or a page 4. And so my question to you is, why wouldn't we put in the entirety of her statement? Because I'm hearing there's no objection to that insofar as it's being tendered as a subset of the discovery in this case. So I would ask that the entire statement go in. I don't know that I need that cover sheet that has the photograph unless that has more of the summary of her statement. And you said it was her daughter's statement?
Yes.
Okay.
So in addition to what I offered in talking so far as the daughter's statement, the defendant's proposed exhibit U ends with, and she stated that they were on. The next page goes, the phone. She ran to his side and tried to comfort him. About this time, the Fulton County Police unit started to arrive.
Okay, but that's someone, I guess, recounting what she remembers about the situation.
Yes, but not what happened. So this is post what happened.
Okay. Is there a reason you don't want me to see post what happened?
I just didn't think that was relevant.
Got it.
I certainly didn't have no objection.
Okay, then let's make U, exhibit U, the full statement that she and her daughter gave. No?
So do,
Well, what I'm reading is a summary, and it says in it that she will be taken down to the office for a more formal interview. So just so that we're clear, you as a synopsis, there would have been formal interviews of both Ms. Jeter and Ms. Blaylock, which are not part of this synopsis summary that are these 2 pages.
Okay, I remember Mr. Hort saying this is a summary, so this isn't the end all and be all. He wants to get into evidence. Mr. Armstrong is saying no objection as long as the whole document comes in. So show Mr. Armstrong all of what big U would be, see if he has an objection, and if he doesn't, let's call that U and we can press on.
I'm sorry, you do not want the first page with the BOLO.
The BOLO?
And checklist, yes.
Show it to Mr. Armstrong and maybe you'll agree no BOLO on it.
Because the issue is what Gary Bouchard would have seen in discovery, I think that the whole thing should be in there, especially because the case synopsis page is not the one right before the second page that you received. And the second page that you received begins, then I.
Okay.
And so I would ask for the whole thing to be you.
More is generally better. So if you're running out of stickers, let us know. But you, exhibit U will be the full document.
Could I do U1? So there's,
No, because I don't want an exhibit to be the partial document.
okay.
That's going to be given back to you for you to keep.
We should see one more time. So.
No, I have the.
So then we would move to admitted evidence defendants exhibit U.
It's admitted.
Can I give you this U back?
Please. And I would ask, and obviously I don't have my computer with me. Mr. Armstrong, did you send us the statements that Ms. Ross referred to, the full statements when they went apparently back to the station?
I'm not aware of what I'm being asked. I apologize.
Ms. Ross said that this was just a synopsis that they then were taken to the station where they gave.
I gave you everything that I had that was not handwriting.
Do you know what's that in there?
So we've gone around on this before. If you don't have a recorded statement or a transcript of a statement from either of those 2 witnesses, then the state doesn't have them anymore. They've given you, Mr. Armstrong has put on record a number of times, everything the state still has, you have. And so this may be something you'd want to add to a catalog of obstacles you face in perfecting a motion for a new trial on behalf of your client that you don't have what Ms. Ross said should exist, which would be either a recording of those statements or a transcript of those statements. But I'm not saying you don't have them. I also know that you have on one occasion or more said, hey, there's this disc with a lot of stuff on it. What's on there, Mr. Armstrong?
So if you search what I sent you, it will include something that is entitled 15-Debbie Blaylock 7 pages. And that includes police reports and police summary of what her statement was, it appears.
Which is you.
No, here. You want to see it real quick? Debbie Blaylock 7 pages, clicking on it. You have waiver and consent to search. You have statement forms.
Okay.
But this is among the materials I sent you guys.
And I apologize for being difficult, but
You're not being difficult, maybe a little flummoxed by the digital discovery, but you're entitled to understand what's going on.
well, my concern is that not everything was fully on Odyssey. Mr. Armstrong was able to find, for example, the motion in limine. But I also asked Mr. Armstrong for Singleton's application for bond, reduction of bond, sent by fax November 14, 2000, and that was a request made on April 23rd. And I still have not received that. So I don't know that I have received everything that Mr. Armstrong has.
Mr. Armstrong, my sense was that you have gone through both the district attorney's case file and whatever you've been able to find through requests to the clerks and provided everything that's not work product to Mr. Hort. Is that correct?
That is my belief, Your Honor.
Okay, so if there's something that was faxed at some point, whatever Mr. Hort just described, and he doesn't have it, I'm not saying he doesn't have it. Again, it could be on some disk. It means you don't have it.
So he's not telling me what he's missing, in the sense of he wants to just make sure that what he sees is the same thing that I see, but he's not telling me what it is necessarily. He wants me to take every filing from that is present in the state's file and to scan it, to make a copy, and send the case to the filing. I was happy to do so in this situation where the clerk's office did not include the full document, but there's nothing that he's given me any information to believe that that would be anything other than me just doing work for work's sake.
Okay. Has Mr. Hort had an opportunity to go through, sit in a conference room in your office, not your personal space, but the DA's office, and go through the file that you've got so he could put Post-its on, I've never seen this, I've never seen this, so not making you do work for work's sake or do work for Mr. Hort?
I identified for him in the emails that I sent him, the things that I did not scan,
Mm-hmm.
and I identified those documents by date and by name.
Okay.
And
So,
how many pages they were.
okay. So the things you didn't provide, you've described them in the level of detail you just gave me. So Mr. Hort knows the things you didn't get to him. And why would you not give it to him? Because it's not discoverable, or you think someone could spelunk into Odyssey and maybe find it?
Because he has access to Odyssey, is my understanding. And literally that is simply me doing work to do something for no reason. And there is a wild amount of work to do for public servants in Fulton County. Going through a case and literally scanning filings that are in Odyssey is a fool's errand.
Okay, I appreciate that we're all busy, but what makes you confident that the things you didn't produce are available in Odyssey for a case that's 25 years old?
I've looked through Odyssey. We've asked them to scan everything that they have. There are the issues with the January 30th, 2001 transcript that we've identified, but he has not told me, I have looked in this date on Odyssey and that document isn't there. Because at that point, I can go check to see if that's there. He's asking me to scan in something that I have no reason to believe is not already scanned in from looking at Odyssey itself.
So you shared with him, let's say it is a motion to suppress, I'm making this up, from September of 2021. You're letting him know, hey, I didn't give you a motion to suppress from September 21, so he would know what date to look for in Odyssey to find that.
So
just as an example.
As an example, basically, like I sent him an email, I just forwarded to the court, Mr. Hort, to show that I sent 15 dated by like 7 pages on March 5th of 2024. Number 32 is motions, filed materials not scanned, other materials 15 pages. I believe after one of our hearings earlier this year, he asked me to itemize what those things were. I did itemize them.
Okay.
He just asked me to go ahead and scan them just in case.
Okay, got it. All right, we're getting into procedure. You've got a witness here, burning a hole in our pocket. So let's pivot back to this witness. We can talk more about discovery and you and Mr. Armstrong when we're done with Ms. Ross.
That's fine, but I do need to respond. His statement is not completely accurate. And I've got an email that exactly tells why it's not.
What part of his statement are you challenging?
So on April 23, 2025, I sent an email to actually Judge McBurney, Kevin, Elizabeth Markowitz. I apologize if I'm being difficult, but this is so frustrating. The inability to access and review documentation from 2001. And now it appears that what was once not that important is now important. I have looked at Odyssey over and over again. The partial motion in limine is what I found online. I guess I assume that's also Mr. Armstrong would have found in his search for documents and known this to be true. Then when I asked him then for Singleton's application for bond/reduction of bond, sent by fax November 14, 2000. I also requested some other documents. Mr. Armstrong responded back, questioned my request for those documents. So then there was an email from me again to all of you on May 8. Thank you for identifying what is on the thumb drive. I'm sorry, I did not mean to offend you asking for the 5 documents, but I was only trying to make sure I had everything and minimize my cost to the county. I'm sorry, but I don't remember ever asking you to put the 4 media disc in the record. I was surprised when you did it at the last hearing. I did not find an odyssey and would appreciate if you could provide me the Singleton application for bond/reduction of bond.
What's so important about that?
It appears that that may be the, other than the generic consolidated motions, the only motion filed by Mr. Gashard. And I'm curious what he said in that motion.
Next time we have a break, Your Honor, I'll go get it.
Okay. All right, can we move on?
Please.
Maybe Mr. Abate could get it for you.
It is the brown box below the chair manifest. Below the red chair part of the shelf.
That's a lot of colors. All right, back to Ms. Ross, please.
Your Honor, then we would move to admit into evidence defendant's proposed Exhibit S, which is the Atlantic Journal-Constitution article, imprisoned as juveniles waiting decades for parole. And I have a copy to show Mr. Armstrong.
Okay. What's the relevance of, when was this article written?
I believe it came out on Monday.
Okay, so an article written in 2025 is relevant to Mr. Singleton's motion for new trial in what way or ways?
As to cruel and unusual punishment.
How is cruel and unusual punishment something that we'll be working through in the motion for new trial?
How well we are.
And how, tell me how am I assessing that? It was a legal sentence. I mean, you can, if you want to just put that placeholder in there, I'm happy to cite umpteen cases from Georgia and our U.S. Supreme Court that say is a life sentence, while long and harsh, is not cruel and unusual punishment for someone who was prosecuted as a juvenile. Case laws out there. I
have cited and will cite United States Supreme Court cases that suggest this could be cruel and unusual punishment. This article goes back and, for example, talks about people that have been. Well, I don't want to know about the contents of the article right now because I'm not sure.
Well, I'm going to hear from Mr. Armstrong on his objections to what would be hearsay and I think arguably not relevant. What would be relevant would be what courts that control the law that I would apply have to say about cruel and unusual in conjunction with a life sentence for someone convicted of murder, despite the fact that maybe he wasn't 17 when the crime was committed. Mr. Armstrong.
We would object to basically hearsay and relevance because it's not relevant about the issue of parole to the issue of whether this person was in fact guilty, and it's not relevant to Ms. Ross's testimony.
Right. Let's tie it to Ms. Ross. What is the connection of this article? Ms. Ross is not a vehicle for you getting all these other things, whether it's you or S or something else. She's here to talk about her connection to the case, which wouldn't be an article that Ms. Gross wrote last week.
Yes and no. The relevancy is with regards to cruel and unusual punishment and the actions of the parole board.
Okay. Of which Ms. Ross is not a member.
My thought is to ask her, one, if you read the article, two, if you haven't, if you wouldn't take a moment and read it, does this accurately reflect the process in Georgia? Okay. I'm going to prevent you from going in that direction because Ms. Ross is not on the parole board. And if you want to ask her about the sentence in this case, you can do that. But her views on the parole board or the process would be opinion, not relevant, maybe even speculation, unless you're able to establish that I'm mistaken. And in fact, Ms. Ross at some point has been on the parole board and could talk about it from an operational perspective, as opposed to I've been told, hearsay, I've read, hearsay, I understand because, so
I doubt this is the right witness to get into that space. I'm understanding a little more why you will want to talk in another pleading perhaps, or an oral argument about this, but I don't think this is the vehicle for that.
And I was trying to avoid having to call in the Atlanta Journal-Constitution reporter. I'm trying to minimize all of our time here in courts. And two, I do think Ms. Ross does have that experience, in some sense, the expertise that she's been doing this for some time now and is familiar with the Georgia process.
Okay, last thing on this, and then we're going to move away from parole. Tell me what parole has to do with anything about whether there was a defect in the proceedings at Mr. Singleton's trial, because I can't grant a new trial because parole doesn't work well. That's not a basis for a new trial. There may be a habeas challenge, there may be some lawsuit that someone wants to bring against pardons and parole, but their fulfillment of their obligations or their failure to do so is beyond trial. It should be beyond appeal. Regrettably, we're not beyond appeal yet, but it has nothing to do with, did Gashard do a good job? Did the trial judge do a good job? Was a witness truthful, et cetera?
And I would respectfully disagree for two reasons. One, Gashard should have raised cruel and unusual punishment during this case.
To the jury?
To the court.
Okay.
And by not doing that, that was ineffective assistance of counsel.
When it was sentencing?
Well, he should have raised, I think, even before sentencing, because we all knew it was going to be a mandatory life.
Right.
And we all knew that Mr. Singleton very well may die in prison. You talk about whether the parole board is doing their job. Are they doing their job when nobody's giving it?
Okay, I'm understanding now that perhaps he should have pursued some mechanism to get this case back to juvenile court or challenged the SB 440 proceedings or whatnot. So there is a connection. This isn't the witness to build any connection like that, unless you want to ask her, did Mr. Gashard ever talk to you about cruel and unusual punishment?
And I understand the court, but I also, I don't think Mr. Armstrong even disagrees with the accuracy of this article. So to me, it would be beneficial to this court to have it, because I think you can, as a judge, say, hey, this is cruel and unusual punishment. Maybe not at the time of sentencing because of Georgia law, but the fact that the way the parole board operates, what is given to me, that in essence does become a cruel and unusual sentence.
Okay, well, when we don't have Ms. Ross sitting on the stand, you and Mr. Armstrong and I can talk about whether that comes in. It wouldn't be anything Ms. Ross would be authenticating. If it comes in, it would come in after we have a discussion. It's not a Ms. Ross article.
Could we at least agree that so far as admissibility, we don't need to bring in the Atlanta Journal reporter?
Let's talk about that when we're talking about your procedural things, because we know Ms. Ross wasn't that reporter. So if we finish with her today and let her go, we don't need to bring her back to get the article in.
Recognizing the court has not admitted Defendant's Exhibit S. Did you read that article in the paper, Ms. Ross?
I read parts of that article. I did not read the whole article.
What you read, did that appear to be an accurate recitation of the treatment of juveniles in Georgia?
No.
I show you what has been marked Defendant's Proposed Exhibit B.
V as in Victor?
Yes.
Okay. Have you shown it to Mr. I was looking down. Did you show it to Mr. Armstrong? He knows what V as in Victor is? Okay.
It's a statement of Mr. Ybarra, dated July 7, 2000. And of course, a copy from the bench. Is that Kismara Ybarra's statement to the police, Fulton County Police Department?
That's what it appears to be based on the document you handed me.
Can you remind me who he is and his connection to the case?
Yes, he is somebody that testified for the state at the trial. We're questioning his testimony. Also, at the last hearing, Ms. Ross indicated that a statement she made to the court was based on what she had in the files. So I'm trying to bring into evidence what was in the files.
Okay.
So we would move to have admitted evidence defendant's proposed exhibit V as in Victor.
Which is the entire document.
Yes.
Okay. And Mr. Ibarra was connected to the case in what way?
He was a state witness.
I heard that part.
And connected Mr. Singleton getting the gun that was taken allegedly from a Officer Populus.
Okay. Got it. Mr. Armstrong, any objection to adding defense V to the record as part of discovery?
If this is in fact the whole thing, no, Your Honor, because it is something that would have been in discovery.
Okay. V is admitted.
What was the plea agreement we reached with the defendant, David Marquez?
I don't recall.
Let me show you the final disposition for David Marquez. Copy to Mr. Armstrong.
Your Honor, I'm going to object, asked and answered. They already talked about David Marquez's sentence and why it was different last time.
Okay. Are we retilling ground here?
I don't believe so.
What was his sentence?
First offender treatment.
Okay, but 100 years to serve first offender or probation?
10 years to serve, community time served.
Okay. You can present that to her. Let's just keep this part streamlined because we may well have covered some of it already.
Does that refresh your memory that Mr. Armstrong, excuse me, Mr. Marquez, apologize. Mr. Marquez received first offender treatment and
It does not refresh my memory, but this is a document that appears to say that that is what happened to him.
When it doesn't refresh your memory, meaning you have a different recollection
I
or?
just don't remember. But
Okay,
If
so,
the certified, if it's not certified, but this looks like a sentence sheet that was very typical for Fulton County back in 2000.
yeah,
It has his name on it. And the sentence is what the sentence is reflected in here, but I don't have any specific memory of what his sentence was. I know
Got it.
I did not try him. I remember not trying
Okay.
this case twice.
no reason to doubt that his sentence was 10 years to serve, reduced to time served, first offender, whatever it says.
No reason to doubt that this sentence sheet, which is not marked, is accurate.
Okay. Does that have a letter on it?
I'm sorry,
Do you, that's defense what? What,
I can certainly do it that way. I was just trying to refresh your memory.
oh, you're not even tendering this, you're refreshing her recollection.
But I was going to ask the court now to take judicial notice of that final disposition. It's, I got the book and page number.
I'm trusting that that was his sentence. So what are your questions about that and him?
Okay, did you want a copy in front of you at this point?
Nope.
Is it true that at the Marquez bond hearing on November 28, 2000, you told the court that nothing has changed since September 11, 2000?
I will defer to what the transcript says. I have no memory of the bond hearing.
As a matter of fact, one thing has changed, and it changed about an hour ago, in that the state has secured the testimony of Michael Waters. Does that sound about right?
If that's what the transcript says, that's what the transcript says.
Okay. And I can reference the bond motion from Marquez, page 9-10, 2000.11.28. And the other one I referred to, Marquez bond motion, page 10, 2000.11.28. Is it true at the November 28 Marquez bond hearing He told the court that Marquez was guilty as a party to the crime because he knew Singleton and Waters had the gun. He'd seen the gun and it was part of an earlier plan to lay down in the street so they could rob someone.
If that's what the transcript says, that's what I said.
And again, reference in bond motion for Marquez, page 10-11, 2011.28. Isn't it also true that Waters told you earlier on that same day, November 28, when you asked him what David's involvement was going to be, he really didn't have any involvement. He just wanted to come. And following your effort to include the laying down as evidence of Marquez's guilt, you then acknowledge you guys abandoned that plan. Does that sound correct?
No, you'd have to show it to me. I have no memory of what Waters said to me.
Your Honor, I'm going to object to this line of questioning for two reasons. Number one, it's just having her confirm whether something was said on the record, which we don't need her to testify to.
Assuming we have the record, but I guess we do if he's reading from it.
Right.
Okay.
And the next thing is relevance. This David Marquez's involvement in the case is something that's in the record. This is not adding or changing anything about it.
Okay, I think we've been here before though, not necessarily with these specifics, but this is about why did you say one thing to the court and later it was different and showing that overall Waters' story changed. Is that where we're going with this? Because
No.
okay, where are we going this time?
Where we're going is that Marquez was charged with murder, felony murder, everything the same as Waters and Singleton.
Mm-hmm.
And the state had no proof that he was guilty other than apparently something happened beforehand with the laying down. And what I'm trying to show is that the state then refused to let him out on bond and then tried to get a statement from him, get him to testify against the co-defendants. And this kind of shows the mentality of the state back then that we're going to keep this kid in jail until he decides he's going to testify for the state. This is our normal, and this is the process we used in this case.
So pretend for a moment that's true. What does that have to do with the motion for new trial?
It corroborates, one, this is, with all due respect, how Ms. Ross operated back then. And two, it confirms the pressure put on Waters, why he testified. And three, it just says something about what's going on here. Are we keeping people in jail just so we can try to get them to testify?
So, but what put that in the context of, Judge, you should grant Mr. Singleton a new trial because they hypothetically, they strong-armed Marquez.
The reason why is because we're trying, and I believe we can show and have showed and will show, that the state knew that Waters and Ybarra were testifying falsely at trial.
Ybarra or Marquez?
No, Marquez didn't testify. He didn't take their deal.
Okay, so all the more reason we don't need to worry about Marquez because he didn't even testify. So, and Ybarra talks about how someone got the gun, not what happened at the scene of the crime where Sergeant Grigley was shot and killed.
Well, yes and no. To finish what I was going to tell the court, Ybarra said in his statement, told the police, he said the real truth is a dude named Mike Waters is the one who tried to pull the carjacking and he pulled the trigger and shot the police.
Okay.
At trial, Ms. Ross, again, with all due respect, changed that.
Well, she didn't testify for Mr. Ybarra.
Well, yes and no.
She took the stand and said, I'm Mr. Ybarra and I'm going to testify, or she asked him questions?
She asked him questions.
Okay, and what did he say at trial? Because my understanding is that the evidence at trial from everyone was Mike Waters shot and killed Sergeant Grigley, and no one has said Singleton shot and killed Sergeant Grigley.
If you remember correctly, Waters said this was all Singleton's idea.
Okay, but whose idea it is different from who shot and killed him.
Well, let me find that. So again, as I've indicated to the court, Ibarra's statement says, the real truth is a dude named Mike Waters is the one who tried to pull the carjacking, and he pulled the trigger and shot the police. At trial, Ms. Ross asked Mr. Ibarra, and I'm referencing volume 2, page 533, you say then after he told you that he told the real truth. So what did he tell you after that? That he got shot in the process of a robbery. And again, this is what Leslie told Mr. Ibarra. And then Ms. Ross asked him, in the presence of committing a robbery? And Mr. Ibarra says yes. So he changed the real truth from Waters doing this, and that Leslie got shot in the process of a robbery, to that Leslie got shot in the process of committing a robbery.
Leslie, who was the one in the driver's seat of the car that was being taken away. And you're saying that someone referring to Mr. Singleton as committing a robbery, driving the car, is changing it from it was Mike Waters' idea and Mike shot the guy? How are they not consistent with each other?
And Ibarra admitted on cross-examination that this was false, that he told the police the real truth was that a dude named Mike Waters is the one who tried to pull the carjacking, and he pulled the trigger and shot the police. Volume 2, page...
So Gary Guichard, in his cross-examination, confronted him with the prior statement and got all that out.
Yes.
That sounds effective.
It is effective, but it also shows that if we had a witness that lied, and it shows that the state knew that when they asked him that question, that was not the real truth.
Okay.
I'd just like to state for the record,
I'm sorry.
I've never suborned perjury. So I didn't know, as you're saying all in your questions, I don't know witnesses lied. My opinion is none of my witnesses lied on the witness stand. And if they lied, then I would have a duty to correct that.
Right.
I would ask that you strike that.
I'm not going to strike it because you're making some pretty serious accusations that, again, I don't think go to the motion for new trial. But you're choosing to interpret things certain ways. I think
I'm giving you the black and white.
I heard the words. They're not contradictory. For Mr. Ibarra to say that Singleton was committing the robbery is not Mr. Ibarra saying it was his idea. It's him saying he was part of it. And I know your view is different. The record established at trial is not that Mr. Singleton had nothing to do with it. And you're going to argue what you want to argue. I'm just giving you a little preview of what I'm going to find. It's not that Mr. Singleton had nothing to do with the carjacking that resulted in Sergeant Grigley's death. That doesn't mean maybe he shouldn't get a new trial, but in terms of was there sufficient evidence for a jury to find him guilty, you're spinning your wheels if your argument is going to be there was not sufficient evidence to show that he was party to a crime.
And I am assuming, hoping that you have not already decided this.
Based on what I've heard, I'm just telling you based on the many hours that we've been together on this, and my review of the record, which I'm required to do to include the trial transcript, which is the record of what happened at trial, not an article that a reporter wrote about what pardons and paroles is doing now. Based on the evidence presented to the jury, you have not yet convinced me that there was insufficient evidence for a jury to convict Waters, had he not pled, Singleton, who did not plead, guilty of being party to the crime of the events that led to the death of Sergeant Grigley.
And with respect, I am not sure what you even base that on. It's one thing to say conclusively it's in the transcript, but if you do look at the transcript, and that's been the nice thing with all the delays we've had with this motion, I've had chances to go back at the transcript and realize, as I did here, when we're talking about what was the real truth, and then the state turns that around as to something else. And then I look at, did Singleton do anything? No, he jumped in the car. And as somebody pointed out, if Waters getting the gun by some means from Singleton means he's guilty, maybe we should also then charge the manufacturers of the gun. Because but for them, there wouldn't be no gun.
People tried that. That hasn't gone well either. So let's keep pressing on, but I need you to veer away from, unless you've got something that is about as clear as, I don't even know what the scenario would be, but so let's, once you ask some questions that aren't about were you suborning perjury? Because the example you just gave is far from that. Ibarra saying that Singleton was part of this, but it was Waters' idea. Those are not inconsistent. Those are, you're describing one part of the elephant and it's got a long and stringy tail. Another part of the elephant is it's got tusks. It's all the same thing. You're just talking about different aspects of it. And you haven't shown me a witness who says Singleton wasn't there. Singleton had nothing to do with it. You know the evidence. He was in the car.
Is that guilt?
Well, jury said so.
Yep.
And you can say the jury was wrong, but you know the uphill climb you have about all the way the inferences need to be read and the conclusions drawn as to sufficiency of the evidence. I hope you're not thinking that's your best argument here, because that's likely a losing battle based on the transcript.
Well, with all due respect, I think maybe I know you better than you do, that when you do actually look at the transcripts after we've had these motions, after I have been giving you what is our case, you say, wow, that does make sense.
Okay. I remain open to that, but you're not going to get there by saying, Ms. Ross, you suborn perjury. I'm not precluding you, but it needs to be clearer than, because you putting on the record, you suborn perjury, didn't you? Those weren't your exact words when it is so unclear that that's what happened. It is Ibarra saying, hey, whatever the words were, but Singleton committed the robbery. And then on cross-examination, he says, yeah, I told the police it was Waters' idea. And maybe he then said, and it was Waters' idea. It can be Waters' idea and Singleton can be a part of it. Waters can say, let's go do this thing. And Singleton can say, great, here's a gun we can use to do that. Singleton can say, I'll be the one who gets in the car. I'll be the one who drives the car. You're the heavy, you've got the gun, I'll get the car. And the fact showed he got the car. He was in the car. So
you're saying if the state gets an answer that Waters was committing the robbery and then turns that around and says that it was Singleton getting the robbery,
that is not what you said Ibarra said to the police. He says it was Waters' idea.
No, I can read it again.
Then give me the document. I'm done hearing you say it and I don't have the words in front of me. So what do I need to be looking at to see what Ibarra told the police?
So one, you need to look at defendant's exhibit V as in Victor.
All right, I've got that.
And then two, you're going to need to look at volume 2, where the state asked, you say then after he told you that he told you the real truth, and again, this is what Leslie told you, Ibarra. So what did he tell you after that? That he got shot in the process of a robbery. And then Ross turned that around in the process of committing a robbery and got a yes answer. And Ibarra cross-examined, acknowledged that was false.
No, he didn't. He didn't. What he said on cross-examination was, I told the police it was, what's his name? It was Waters' idea.
He told the police the real.
I don't have the transcript in front of me, so you're going to need to hand me the transcript as well.
Okay, do you have V?
I have V. V is right here.
And it's right on page 1. He said the real truth is a dude named Mike Waters is the one who tried to pull the carjacking and he pulled the trigger and shot the police.
Yep, I see
Nothing
that.
about ideas.
Pardon me?
Nothing about ideas.
Okay.
It's talking about what was the real truth. And that's then what the state then turned around is the real truth being that Leslie said he was committing a robbery.
Okay. You should explore a different area now with Ms. Ross.
I can move on. Does it remain your position that Waters and Ibarra testified truthfully?
Don't answer that question. Next question.
Does it remain your position that Detective Martin testified truthfully?
No more questions about who testified truthfully. If you want to confront this witness with an excerpt from a transcript and some other document and they're inconsistent and you think this is the right witness to explain those inconsistencies, that's fine. Do not ask Ms. Ross again, do you think witness X testified truthfully? In toto, don't ask why. I'm telling you now, okay? We're making the record. No more questions. Did you think this witness testified truthfully? If you want to go to a specific instance, and not only say, hey, was this truthful, but have the basis that you believe makes it not truthful. That Ms. Ross would have known at the time she asked that question. You can explore that with this witness. Otherwise, we are done with her view of the veracity of witness statements at trial. Understood?
And that's exactly where I was going. But I thought, why not first ask her? If she agrees with me that their testimony was not truthful, then I really don't need to go through all of those examples.
Okay, but we're not doing it that way. The way we're going to do it is that you identify a specific.
At trial, you elicited testimony from Waters that Leslie picked up what looked like a little wallet. And I'm referencing volume 3, page 663.
So Ms. Ross doesn't have the transcripts in front of her. Maybe it's about to
Give me a
get
moment
there.
to give it to her.
Okay, great.
I learned that lesson a long time ago, that either you will object or he will object.
Okay, excellent.
So I'm giving you page 663.
Volume 2,
Volume 3.
volume 3.
So again, my question, at the trial, you elicited testimony from Waters that Leslie picked up what looked like a little wallet. Volume 3, page 663. Did you know that Waters was going to say this?
I have no memory of my prior conversations with Mr. Waters. And for the record, my exact question was, at some point, as this defendant is getting into the driver's side of the car, do you see him touch anything? Answer, yeah. He went down and picked up something that was laying on the side of the car. Question, were you able to see what he picked up? Answer, it looked like a little wallet. So the word little wallet didn't come out of my mouth, just to be clear. It came out of the witness's mouth.
And this is you asking Mr. Waters?
I'm assuming, because I don't have the whole transcript. I just have one page. So
Okay, but let's assume it's Mr. Waters, and he says the defendant, and that would mean Singleton?
yes, he said the defendant, which would be Singleton.
Okay, all right.
So back to my question. You elicited testimony from Waters that Leslie picked up what looked like a little wallet. Is that correct?
I asked a question if he picked something up. His answer was it was a wallet.
A little wallet.
Okay, if he said little wallet, yes.
We have it right in front of you, ma'am. Is that what it
A little
says?
wallet.
Thank you. Did you know Waters was going to say this?
I have no memory of what Waters was going to say.
Does this maybe refresh your memory that in addition to you talking to Waters on November 28, you talked with Waters again prior to the trial?
I may have talked to Waters prior to the trial. I have no memory of the times that I talked to Mr. Waters.
She was right. 50 Cent, yay,
Hold
and I'm
on.
gonna say this on record.
All right.
That sounds like somebody's voice now.
It was Ms. Allen who didn't have her device muted. All right.
So I'm going to show you what's been received in evidence as defendants exhibits W and X, those being the two statements from Michael Waters on July 7, 2000. And Mr. Armstrong, do you need to see another copy?
I'm trying to find it separately. So these are from July 7th?
Yes.
I do not need a copy.
And my question is, and this may help you in your review, true, this was not in Waters' July 7, 2000 first or second allegedly truthful statement, defendant exhibits W and X, or in Waters' November 28, 2000 statement, defendants exhibit Y.
And when you say this, meaning in those three different statements, Mr. Waters didn't say something about picking up a little wallet?
Yes.
Okay. You've reviewed this more carefully and closely and more recently than any of the rest of us. Does he say something to the contrary? He didn't pick up a wallet, or he picked up a big wallet, or it's just not in there, as in maybe no one asked him that?
One, I find it hard to believe nobody asked him. This is
Well,
the first time it came out at trial.
Know what the questions are, because the questions are listed here. So which is it? It's just, it didn't come up, or he says something that contradicts it. Singleton never picked anything up, or he picked up a big wallet, because you focused on the word little.
Well, I was trying to be accurate in my recitation. The indictment only mentions the cell phone. So my questions to the ADA is, one, does this suggest that she knew he was going to say that? That's why she explored that area. And two, does that then also support that she talked with him prior to the trial?
Okay. Well, she's answered today several times, and her previous sessions multiple times. She doesn't recall every time she would have interacted with him or what he said in each of those interactions. I suspect she'll say the same thing if you ask again, but I'll let her review those documents to see if, so she can answer your question.
I also don't recall, was there a video recording of Waters on the same day as well? I just don't remember. Was he videotaped by the police?
Am I allowed to answer that?
Please.
I believe so. I
Okay.
believe that's been turned over to Mr. Moore.
All right. So I haven't reviewed the video, but what do you want me to do with these three things that you put in front of me for, if you come with transcript?
Well, his question was, in any of those statements, was there a discussion of Singleton picking up a wallet, a little wallet? I think that, and I don't mean to speak for you, but that's what we're looking for, because that's what I pressed Mr. Hort on, is he knows what's in there. And it doesn't sound like there's anything contradictory. There's an absence. There's no mention of that event occurring. Is that a fair summary?
Well, it's a contradiction because it's not there. When the state then did their indictment, they did not include the little brown wallet. They only included the cell phone.
I don't know where the word brown came from, but
Page 663. It looked like a little wallet, a little brown wallet.
okay.
So my question is, it's true that that is not in any of those three statements?
Well, I haven't had a chance to read all three of the statements, but I'd have to do that to answer.
So I don't like it when we use a witness to summarize something that you've got in evidence. And so if X and W and Y are all in evidence, then I can all by myself, and you can make that assertion in a pleading that it didn't come up. Either it wasn't asked, or when he was asked to describe what happened, he didn't say anything about a little brown wallet. We don't need the prosecutor of the trial to say it wasn't in there, if in fact it's not in there. You know that it's not in there.
Okay. I can move on to my next question, but I'm trying to follow up with the court's suggestions that we get to specific examples. Would this support Waters' letter, which is defendant's proposed exhibit B, that he and you met before the trial?
Objection, speculation, and argumentative. He's asking, would this support?
And we know the answer, which is Ms. Ross has said, I don't recall if I met with him or every time I met with him.
Maybe I misheard. I thought she said she didn't know how many times she would have met with him.
Oh, okay, same thing, I think, but let's do it one more time, and then we won't ask it again. Go ahead and ask. Did you meet with Mr. Waters other times?
Other than these three statements, did Mr. Waters give any other statements?
Okay, well, first of all, be clear. I was not at the police department when he was interviewed, so you can't count
Right.
those. I wasn't there.
Other than November 28th statement, did you have any other meetings with Mr. Waters?
I am sure I talked to him at some point before I put him on the stand. I
Thank
don't know
you.
how many times I talked to him.
Thank you. At trial, Waters testified, because we're going to rob a drug dealer and you know we had guns, so if they start shooting at us, we're going to shoot at them. Volume 3, page 645. And let me give you a copy of that. Copy to Mr. Armstrong. And you start with line 15 with your question.
Your Honor, I don't think a question was raised. He's just handing her a transcript.
Right, she's reading this. What's the question?
Did you know Waters was going to say this?
I have no memory of what Waters was going to say.
And again, true that this was not in Waters' July 7, 2001 or second alleged truthful statement, defendant's exhibits W and X, or in Waters' November 28, 2000 statement, defendant exhibit Y.
I have no idea. I haven't read it for that.
You still have those, I believe.
But she's not going to read them again. We just went through this. I will take your word as an officer of the court that that isn't in any of those three statements.
Thank you. Did you talk with state witness Ybarra before the trial?
I have no memory of speaking with him, but I'm sure I did because I talk to usually all my witnesses before trial if they're willing to speak with me.
Did you ever ask Ybarra what, if anything, he knew about the Clayton County case?
I have no memory of what I said to him or when I talked to him.
Is that something you would have? Clayton County, again, that's where it all started with the gun, Officer Populus.
I don't know. I have no memory.
Okay, but my question is that something you would have asked Ybarra, hey, do you know anything about what happened in Clayton County?
Objection, speculation. She says she doesn't know.
I don't know.
Right. She's told you, I'm going to ask a question. Is there any witness who testified at Mr. Singleton's trial that the state called, whose conversations with you, you have a specific recollection of? That question I didn't ask it well, but I just want to avoid us going down this road with each witness.
No,
you talked to probably, your practice would be to have had a conversation, at least one, with every witness you were going to call who was willing to talk with you. Do you remember the specifics of any of those conversations you would have had if you followed your standard practice?
No.
Okay. That's in the record.
I am showing you transcript volume 2, page 528-530. Copy again from Mr. Armstrong. Is it true on that page, line 2, page 528, you asked Mr. Ybarra, do you know about the incident that led to the death of Sergeant Melvin Grigley?
That appears to be the question in the transcript, yes.
And the answer, do I know any information? Question, have you heard about it? Answer, have I heard about it? Yes. Is that correct?
That is the transcript you read, yes.
Does that refresh your memory that you may have talked to him about Clayton County before the trial?
No, it does not.
And again, then I would indicate as an officer of the court that the Clayton County incident is not mentioned in Ybarra's statement to the police. Defendant exhibit V as in Victor. Still on volume 2, 528-530. You should still have that in front of you. Going to page 530. Did you ask Mr. Ybarra, what did you say when Leslie showed you this Glock 40? Answer, where he got it from. Question, and what did he tell you? Answer, found it in the woods. Question, you have to speak up. Answer, found it in the woods. Is that correct?
You have read the transcript correctly.
Did you know this was false?
None of my witnesses testified falsely, no. Did I know that what was false? That what he testified to was false?
What he just said?
No, that is what Leslie told him. That is what Leslie told him where he got the gun. So no, he's telling us what Leslie told him about where he got the gun.
If Leslie lied to him, then he's saying something that's not truthful, but he is relaying to the jury what your client told him. He claims your client told him that. So if you're acknowledging your client stole a gun from a deputy in Clayton County, then yeah, that's not true. But you understand, Ibarra says, this is what Singleton told me. And the prosecutor says, what did Singleton tell you? He said X. That may be untrue, what Singleton said to Ibarra, but that doesn't mean that Ibarra is lying.
What it means, and hopefully again, the court will see this from the transcripts, what Leslie said he did to protect his friends.
Leslie said whatever he said for whatever reason, but you are claiming that Ibarra is lying. What's your basis that Ibarra was being untruthful when he said, Leslie Singleton told me he found the gun in the woods?
Ibarra was actually there in Clayton County when that happened.
And Ms. Ross knows that how?
Well, one, that's my questions to her. Did she know it was false? And if she says yes, because I knew that he was in Clayton County, so what he was telling me wasn't true. This was used to show guilt of Mr. Singleton.
It was used for however it was used, but you're seizing on this example as, look, here's Ibarra lying, and maybe the state knew that. How is it that you say Ibarra knew otherwise?
Because Ibarra was there in Clayton County. So he knew that Leslie didn't find it in the woods.
How do you know Ibarra was there? So I guess you need to be careful where you're going here. You're saying Ibarra would testify if he were here now. Yeah, I watched Leslie rob the deputy.
I don't think he would use your words, Judge. And again, I respectfully ask that you not make any conclusions until you see all of the evidence.
What would Ibarra say, since you know?
Yes, I was there.
I was there for what?
In Clayton County. We were there, we're a bunch of kids acting stupid, whatever. This person then throws his book bag at us. We take off, grab the bag, didn't know there was a gun in it, no intention to rob him. Supporting what Leslie's going to be telling you, probably in a better manner than me, but essentially there was not a robbery of Officer Poplis.
Okay.
Your Honor, I have several objections.
Yeah, we are so far afield, and
For past while, we've been doing a quiz on the transcript and argumentative questions in the sense of what conclusions to draw from facts, but we're not asking the witness facts. Number 3, all Poplis stuff is irrelevant. I'm gonna have to address it somewhat in cross-examination, but again, Clayton County was not raised in this trial.
okay. All right. I hope you can see, Mr. Hort, the degree to which you need to excavate to attempt to illustrate that what Ibarra said at trial isn't true. It shows you how remote you've gone from what's going on at trial. And you've yet to demonstrate that the state had any information that Mr. Ibarra was connected to the state, as in the Fulton County prosecutors handling the prosecution of the murder of Sergeant Grigley, that they had any information that Ibarra was connected to a Clayton case, and that his statement that Singleton told me he found it in the woods was knowingly, factually inaccurate to the prosecutor. It's an argumentative question. I mean, you knew differently, didn't you?
Well, 1, I wish I could call Mr. Gishard as a witness.
But you can't.
2, I wish I could call Mr. Greenberg as a witness.
But you can't. Those are great arguments to make in this case.
So this is my alternative to try and ask Ms. Ross, what happened way back when? What can you tell us?
And she said, I don't remember. That's also a great argument for you to make, but she doesn't remember.
I will move on. Do you know whether there was any pressure by the police or anyone in behalf of the state on Ibarra to elicit his testimony?
Well, I know I didn't pressure him because I don't pressure witnesses. And I have no knowledge that the police would have pressured someone or would have brought it to somebody's attention.
Is it true that Ybarra had charges in Fulton County and Clayton County during this time frame?
I have no memory of what his status was.
Is that something you would have checked out to see if your witnesses have anything pending?
Usually,
And back to the other one, Detective Martin did a one-on-one show up with Leslie and Populous. Wouldn't it make sense?
Objection, relevance, and speculation.
I can finish my question.
Okay, you can finish. Don't answer the question. There's an objection.
If you've got this 3 kids that hang out together, 4 kids, whatever, to ask Detective Martin to do a show up of Populous and see if he recognizes Marquez, Ybarra, Waters, see if any of those folks were present in Clayton County. Wouldn't that have made sense to have him check that out?
So tell me why Ms. Ross has anything to do with the question you're asking. Do you have reason to believe that Ms. Ross directed the one-on-one show up, or this is something that happened independent of the district attorney's office work on the prosecution of the Grigley murder?
That question comes later on the road. My question to her is, I would expect, as good as she is, she would ask Martin, hey, check out these other 3. See if Populous can identify them, or if there's any proof they were there in Clayton County.
Did this show up occur? When in the timeline did this show up occur? Before or after Mr. Singleton had been arrested for the murder?
After.
Okay. And after he'd been indicted?
He was at the juvenile facility, so I'm not sure. Again, with the time factor, I can't tell you the exact date. We've tried to get that information from Fulton County, from the juvenile facility, have not been able to get it again because of the delay in time.
And what during the trial of Mr. Singleton for the murder of Sergeant Grigley came up about a Populous show up?
Again, one of our arguments of ineffective assistance. The Gashard didn't bring it up in a motion to suppress, didn't bring it up at trial, didn't do anything about it.
I didn't ask my question well. What did the jury ever hear at the trial of Leslie Singleton for the murder of Sergeant Grigley about a one-on-one show up with Populous?
They did not, and that's our argument. That if Gashard would have been doing his job, he would have showed what the police did and did not do to affect their credibility and also to...
How would it have been not error? How would it have been, not been an error for the judge to allow something like that in? That there was a one-on-one show up in a case that's not this case, that Detective Martin allegedly did something related to a different case that wasn't evidence in this case.
And one, we don't know, if there was a motion to suppress hearing. It appears from the transcripts there was. So we don't know if that was brought up at that point in time.
To suppress the one-on-one ID that wasn't used at trial?
You suppressed Leslie's statement because of improper pressure, improper tactics by law enforcement.
Okay, stop there. Mr. Armstrong, anything you want to add?
Leslie Singleton turned himself in and gave them a false story that he planned to tell them the night he turned himself in. Whatever happened with Populous is completely separate. There's nothing in this trial that had been suppressed by any issue involving Populous.
Okay, I agree with that. We took a little turn I wasn't expecting, that it was something about maybe there should have been a motion to suppress Mr. Singleton's statement to the police, and maybe there was, and we can't figure out if there was. But you should ask a different question than about Martin and Populous and a one-on-one show up, because it sounds like that isn't something that came up during trial.
Hopefully you will see why it's relevant later on.
Okay.
For the record, Tyler Host does not allow me to upload documentation, but it shows there was a case against Ybarra filed October 10, 2003, a non-capital felony, and a case before Judge Simmons in Clayton County. The Fulton County case was also in front of Judge Downs. I have asked Mr. Armstrong for copies of those documents.
You're asking me for copies of Clayton County documents?
No, I've asked you for copies from the State versus Ybarra in Fulton County.
The Judge Downs case?
Yes.
Okay. And what's title host?
Tyler Host is the discovery.
Okay.
It's a means of online finding documentation.
Okay.
Familiar with that.
Sorry?
I'm not familiar with what that is.
That
What are you saying?
Tyler.
Are you saying
Oh, Tyler Host. Okay.
It's my Michigan.
It is. Definitely, that was an accent. I do know what Tyler Host is. Thank you.
Again, my email, June 11, 2025.
Stop. I want you to finish with Ms. Ross today. I don't think I'm gonna have her come back again. So let's turn to questions for Ms. Ross concerning her connection to the case and facts that were presented or evidence that was presented to this jury in this case, not Clayton.
So again, we've got a Fulton County case against Ybarra, Judge Downs. Were you involved in that case?
You're telling me Ybarra was charged with a case that was pending before Judge Downs at the time that the trial was going on?
No, because his indictment number was a 03 something.
Right, and this trial was 01?
Yes.
So his question was, were you involved in the subsequent Ybarra
2 years
process?
after the fact, no. I don't.
And I'm
know.
sorry, do cases in Fulton County go immediately to indictment? Or do they hang out there for a while till the prosecutor decides to charge?
It depends on the
Exactly.
case.
So it could have happened.
Well, what was the arrest date?
I don't know. I've asked for that information.
Well, I have no
can't get it.
knowledge of any
I will
case he
just
had
read off-
regardless.
Stop, we can only have one person talk at one time. Court reporter can only take down one. What is Mr. Ibarra's first name?
Casimiro, Casimiro. And it appears that the case that he's referring to is 03SC09388.
Got it.
From the way that I read Odyssey, he was indicted on October 10th, 2003, and the date listed for the offenses is at September 29th, 2003.
I see the same thing.
And I would have appreciated knowing that before I came today.
Okay, no one asked me, but that looks like it. The offense date I'd put less weight on, but definitely the final disposition was filed. And there's nothing to click on, so there are no documents that we can open here in January of 2004. But the bind over was in October of 2003, so that's a likely offense date of September 2003. So we're getting a field. Let's get back to you and questions for Ms. Ross related to her work on this case.
Do you agree that it would be helpful to have Mr. Ybarra testify at this hearing?
I'll defer to the district attorney's office. I don't know about your hearing.
You know a lot about our hearing, but
I've been here 3 times.
Yes.
But I don't know what goes on beyond me being here.
okay.
For the record, as an officer of the court, Judge Downs instructed the jury that admissibility of a juvenile singleton statement required the jury to consider his age, education, knowledge of the juvenile as to the substance of the charge, methods used in questioning. That statement must be freely and willingly given without coercion, duress, threats, use of violence, and without any suggestions or promises of leniency. That a statement induced by the slightest hope of benefit is not voluntary. And reference volume 4, page 1048-1051. I'm trying to expedite for the record. Gashard did not call any fact or expert witness at trial relating to the admissibility of a statement given by his juvenile client.
You're asking Ms. Ross to affirm that Mr. Gashard did not call an expert to that effect?
I can, but I thought you wanted me just as an officer of the court to reflect what the file does or does not show.
Okay, so 2 things. I appreciate that. That's something you could do in a brief, an argument, et cetera. We don't need Ms. Ross sitting here while you do that. So I'm not taking issue with anything you said. And that's another example of why it would be really helpful to have Mr. Gashard here to ask him, why didn't you call an expert to that effect? But it doesn't seem like a Ms. Ross thing.
The Clayton County officer Darren Bell's statement to Detective Martin is dated January 18, 2001. And you provided this statement to the defendants on January 31, 2001. Is there a reason why this took so long in a major murder case after you talked to the detectives on November 15, 2000 about getting the ball rolling?
I didn't track your dates. Are you telling me it took me 2 weeks to disclose a statement?
Well, it started November 15. So then it took 2 months for Detective Martin to follow up on your request. And then it took, yes, 2 weeks for you then to provide the statement to the defense.
And your question is what?
Is there a reason why?
No, I don't see that as unusually long, especially for Fulton County.
When was the trial?
March, I think.
March
of
2001.
01.
Okay.
maybe.
So it was a couple months before trial, but you're identifying there were some lags in getting it to the defense. And this was Mr. whose statement?
Darren Bell, and I think that's in as exhibits.
Who's Darren Bell?
He is the officer, Exhibit J, that raised all these issues so far as the validity of Officer Poplis.
Okay.
Did you talk to Detective Martin about the Clayton County case after he talked to Officer Bell?
I do not remember my conversations with Detective Martin about the Clayton County case.
Is that something you would have?
Probably.
True, you didn't ask for copies of the two reports referenced by Officer Bell related to the inconsistencies in the information he received about what happened in Clayton County.
I have no memory of what you're talking about.
Did you ask Detective Martin to look into Officer Bell reporting that Poplis didn't want Clayton County to have the bag, and he sent someone to get the bag and take pictures of what he wanted them to have?
I don't remember my conversations with Detective Martin.
Backstepping a moment, did I give you defendant's exhibit U?
You did not. I have V, but I'd love to get U so I can make that part of the record. Thank you. Nope, no apologies. I wasn't going to let you leave without it.
Did you know that on July 16, 2002, Populous tampered with evidence? The GBI investigated, he failed a polygraph, and the district attorney's office agreed not to prosecute him in return for a suspension of 5 days.
Objection, facts not in evidence.
We'll show you what's marked defendant's proposed exhibit N.
Also, he's asking her to comment on whether things happened that established a Chevy basis of knowing.
Right. Well, I mean, I think you don't need to worry about reading M, because if you don't know these things about Poplis, that's not refreshing your recollection. That's informing you for the first time. And I think we've established, Mr. Hort, but I'll let you ask this last question about Ms. Ross's knowledge about Poplis, that wasn't a case she was plugged into. It wasn't a case she's followed. It wasn't an active part of her investigation is the wrong word. I'm certain the DA's office did some investigation. They do prosecution, not investigation. It wasn't an avenue they were pursuing. And that frustrates you. You think Gashard should have done more with that, and that should have been maybe more of a thrust of the defense in this case. But unless I'm misremembering, Poplis didn't come in and testify at the trial and point to Mr. Singleton as the guy who took his gun. Am I misremembering?
Well, our argument is that Populous tampered with evidence in this case. And here I've got another case where he tampered with evidence, failed a polygraph.
Okay, Ms. Ross, were you aware of any of that?
No.
Okay, next question.
My follow-up question to that is, she obviously was part of the Fulton County District Attorney's Office at that point. Wouldn't it have been the norm? Say, hey, Populous was involved in your case. What do you think? Any ideas?
How was Populous involved in the murder prosecution where Sergeant Grigley was the victim? How was Populous involved?
Because that's where the gun came from.
Who said to the jury that the gun came from Populous?
That refers then to the motion to suppress that we don't have the transcript for.
But you didn't answer my question. Did someone during the jury trial at which Leslie Singleton was convicted by 12 jurors for the murder of Sergeant Grigley, party to the crime, didn't pull the trigger, not the shooter, did someone tell the jury during that trial that the gun came from Populous?
Well, that's my point. We don't.
No, you're not. Well, did someone?
Question that's not a yes or no answer.
It is. That is you can explain your answer, but either someone did tell the jury that the gun came from Populous, or someone didn't tell the jury. What's the answer?
The answer is, I believe, and I'd have to go back through the transcripts, and hopefully my assistant is taking good notes to see if that ever was inferred or said. I don't believe Populous's name came up.
I don't either. I have no doubt that in the record, there was reference to the fact that it was a gun from a deputy, it had to be stolen. So there were nefarious clouds circulating around the gun that Waters used to shoot Grigley, not your client. But I don't believe if you do a word search in the transcript, you will find Populous's name. So
unfortunately, I cannot do that with the transcripts.
Understood, but I don't believe, were you able to do that you would find Populous's name in there. So why are we exploring this?
Because again, my point is, this was a major murder case. Populous was connected. So when it comes out to find out if he should be, his certification revoked, what should happen, it goes to the Fulton County District Attorney's Office. The norm, and you were in the office, I've been an assistant prosecutor, you check to see, hey, anybody know anything about this guy?
But Populous didn't testify at Singleton's trial. Reports he wrote weren't relied upon in Singleton's trial. So it could well be that Populous cases, although he was a deputy, not an APD officer, so he's not out there making lots of cases. There wouldn't have been lots of cases in the Fulton DA's office made by Deputy Populous. But you make a good point. He becomes radioactive. If you have a case where Populous touched it and there's a finding that he was in some way deceptive, he got fired, good prosecutors are going to say, wait, let's make sure Populous didn't touch my case in some way. And if he did, let me finish. If he did, we either need to re-examine the evidence or wall that part off. In other words, don't say to the jury during the trial of Leslie Singleton, Populous says Singleton robbed him. And in the trial of Leslie Singleton, party to a crime for the murder of Sergeant Grigley, I don't believe any witness ever said, nor a prosecutor argued, another way we know this guy's guilty is that he robbed Deputy Populous, and we know that because Populous told us, and Populous is an officer and an honorable man.
My point is exactly what you said, that in 2002, 2005, whatever, motion for new trial not decided. If the district attorney finds out, whoa, this is worth looking into, I'm not so sure the fairness of this trial if the officer who says it was stolen from him, if he's already acknowledged tampering with evidence. Maybe it's something we need to look into.
Okay. What would change in the trial of Leslie Singleton if it turns out that the gun wasn't stolen from Populous? I don't know what this story is about a backpack being thrown, but Waters, Singleton, Marquez all had to have known that wasn't their gun because stamped on the side, it says Fulton County Sheriff's Office or deputy or law enforcement. So everyone involved in the murder of Sergeant Grigley knows that that's not their gun. They didn't buy it at a pawn shop. It is a stolen gun of some sort. Okay, full stop. What changes if we do this trial again?
If Leslie did not steal the gun, if it was thrown at him, and yes, as a 16-year-old kid, he grabbed the backpack, the book bag, ran, they kept the gun, yeah. Not what we would do as adults, but when you look back at the age of 16.
A lot of adults might keep a firearm for whatever reason, but what changes Waters' testimony? What changes the surviving victim's testimony if a jury for a second time doesn't hear that Waters stole the gun from Poplis because they didn't hear it the first time? I'm not Waters, Singleton.
Instead of thinking Singleton stole the gun because it's got Fulton County on it, then they would hear the reality, the truth of what did happen. And then that's what bringing in the experts, that's what bringing in witnesses that he made.
Okay, got it. And that's a good argument to make about how there could have been a more effective defense. I don't think it's a Ms. Ross thing.
Your Honor, I apologize. Can I request a company break?
In a moment, how much do you have left for Ms. Ross? And tell me the topics. And how much do you have left for Ms. Ross? And then I want to know what the topics are, because I may just excise some topics if it has anything to do with Poplis. Ms. Ross isn't going to be answering more questions about Poplis. Okay. That may shorten what's left.
Well, I was going to finish this line of question by asking her if she knew that his certification was revoked in 2005. Okay. And then I was going to offer into evidence Defendant's Exhibit N, which is the case summary from the PCC.
What's the PCC?
Maybe my law enforcement colleagues can better answer that.
I don't think Ms. Ross is going to be able to authenticate that document.
Okay.
I'm saying, what is PCC?
No, that's not what he answered. He said that Ms. Ross wouldn't be able to authenticate Exhibit N, which is, I'm assuming, the records that show that Poplis was decertified or something.
And I was not going to ask her that. I was just going to then offer it.
Okay. We can take up N after we're done with Ms. Ross, because it sounds like she isn't a foundation layer or authenticator. Okay. So Ms. Ross, were you aware of the fact that at some point things ended poorly for Deputy Poplis and he may have lost his post certification?
No.
Okay. What topics remain for Ms. Ross?
So I was going to then go into the statement that Leslie gave to Detective Martin.
Okay. And that's not something we already covered with Ms. Ross?
Well, that's the benefit that I have. One, I look back through my prior questions to Ms. Wardell also has been taking great notes. So by comparing her notes, the questions I'd earlier asked, no.
Okay.
So not repetitive.
Got it. So the statement to Detective Martin, what else?
Then I was going to ask her what, if anything, she knew about lead investigator Marvin Dixon.
I thought Martin was the lead investigator.
Mr. Dixon was the lead investigator.
Oh, on the defense side?
Yes.
Okay, I'm sorry.
And then I was going to talk about Waters' plea. And then I was going to talk about jury instructions. Then I was going to talk about cruel and unusual punishment. And then I was going to ask her about Carl Greenberg. And then I was going to ask her about the 2005 motion for appointment of counsel and status conference.
When did you leave the district attorney's office that time around?
04.
Okay.
Or was it 02? 02. And I was back in 04.
Oh, you were back.
I was back.
Okay, so questions about what was going on in 05, you might have been in the office.
I was in the office, but I didn't handle appeals.
Okay, all right. That doesn't mean he's not going to ask you about it. Just say you didn't handle appeals. So I appreciate that overview. We're going to take a break in a moment. We're going to skip cruel and unusual punishment for this witness. Her opinions on that aren't relevant. Doesn't mean it's not a topic for you to advocate about, but this isn't a witness with which we'll explore that topic. And what was the one just before cruel and unusual punishment?
Jury instructions.
Jury instructions. Tell me just like, what's the kind of example that's just not going to be in the record? Isn't it true the judge didn't give this charge? Isn't it true the judge did give this charge? There's a record. I don't, usually prosecutors don't testify in these motions for new trial hearing, but I don't know what you'd be asking a prosecutor about that. You'd be asking Mr. Gishard a bunch of questions. Why didn't you ask for this? Why didn't you object to that? Of course, you can't do that. What do we?
That is essentially why, because I can't ask those questions to Mr. Gishard or Mr. Greenberg.
Okay.
He was there, so this is the best I can do.
Okay, but the record will show what happened during a charge conference and what Mr. Gishard asked for or didn't ask for, objected to or didn't object to. Ms. Ross's opinion about whether he should have done something or didn't, not relevant. And I don't need to hear that. So how about this? We'll take the break. When we come back, if you want to articulate why we ought to get into jury charges, maybe you can persuade me, but otherwise we can streamline things. We're going to leapfrog the cruel and unusual punishment. We'll probably leapfrog the jury charges as well. Let's find out one more piece of data. Mr. Singleton. I don't know why,
Yes, sir.
why you fell off. You're here. How late do we have you?
Up until 5 o'clock.
Oh, a little longer than I thought. That's great. I had heard that they shut down a little earlier. So we've got you, and you're in the same time zone. So we got a little more time with you. That's good. Any questions from you procedurally right now? Or are you good to go?
Procedurally, could you explain that more? Because that's kind of, legalese, I might not be aware of how you're trying to.
Oh, procedure, like just, do you have any questions about what we're doing next?
I'm just waiting to speak. So I'm just being patient, going through the motion. I'm just waiting to speak so we can get some clarity to a lot of things that I'm hearing.
Okay, got it. It doesn't sound like today is your time. We're going to get through Ms. Ross, and then we'll figure out when it is we can reconvene. And Mr. Hort, of course, will be in touch with you on that. But I don't want you to disappear on us. We're going to take 5, 6, 7 minute break and then get Ms. Ross back on the stand. Mr. Armstrong.
I wanted to point out that Mr. Body went and got my file. He also made copies of a couple things that were in the section that was referred to. One is the application for bond or reduction for bond, and one is Mr. Gishard's request to charge. But I can't turn them over to Mr. Hort until I get confirmation that because somebody's handwriting is on here, that me handing this to you will waive all possible work products.
I'm going to tell you it doesn't. I make a ruling right now that it doesn't.
I've handed those 2 documents over to Mr. Hort.
Okay.
I already have the request to charge. Thank you.
All right. I'm dying to read the bond motion when he's done reading it, but let's take that break. I'll mute things here and we'll pick back up in 6, 7 minutes.
Your flags are much more separated from the rest of us than was the juvenile court of Torrey County.
If a defendant has a hold of one of these flags,
You
there
know,
are bigger issues going on. The supposed little Kevlar panels here aren't going to be protected.
You have Kevlar panels?
Yeah. So in theory, it used to be what's supposed to happen if Deputy Gordon goes nuts and pulls out his gun. If I go down here, he could light it up and I'd be all right.
Oh.
I didn't install them. It's not like a McBurney thing. They were already in here. I think they're in all the courtrooms.
I just never heard of that part. I've been here a decade.
There's some secrets still
Apparently.
out there. All right,
Everything is.
let's be productive. We're back on the record. Mr. Hort, did you decide you're not going to ask Ms. Ross about jury charges, or is there something you want to articulate to me that would convince me we ought to explore with Ms. Ross about jury charges?
Obviously have an offer of proof of what I was going to do, but then I'm also going to try to minimize those areas so we can finish with her today.
Okay, let's press on.
I did want to point out, Mr. Armstrong graciously showed me on his computer what information he had on Ybarra. And there were indications there of violence in 2001. They very well may have been minor types of offenses, but they are apparently there.
Okay. I did get a copy of, it's like a draft copy of the indictment of Ibarra from 0304 involving some kind of carjacking. But again, that postdates what we're talking about.
And what I was going to do, and I understand the court's instructions, we do have allegations that Ms. Ross knew that this testimony wasn't false.
Whose testimony?
Waters, Ybarra, Detective Martin. So what I was trying to do today, in some sense, to be fair to her, is to give her an opportunity to respond to those. But I don't need to if you don't want me to.
Well, you're getting into complicated waters because you're making an allegation. I guess that it's not that witnesses are entitled to be prepared for something like this, but it's not that the judge made a mistake or that someone was ineffective, but it's that someone technically committed a crime, certainly violated all sorts of bar rules. That's a complicated space to get into. And it seems like the kind of thing where seems like I would like you to file something that lays that out so Mr. Armstrong can see it and I can see it. And then I'd be more comfortable saying, let's put someone under oath to answer those questions. And I want to be very clear. I'm not saying that you're blindsiding anyone or doing anything underhanded. You're entitled to ask witnesses questions. But if it's getting into an area that involves someone's recollection of what happened 25 years ago, who since then has prosecuted, I don't have enough fingers and toes times 10 to cover all that. I think the prudent way and the equitable way to work through that would be for you to map out in writing. Doesn't need to be as detailed as you're sometimes known to do, but to sketch out, these are the things that I'd want to explore. And then we could have a discussion, certainly with Mr. Singleton plugged in, but we don't even need to be imposing on Ms. Ross's schedule about, is that something that I'd let you explore or not? We'd make a good record of it. And if I got that wrong and said, no, we're not going to do it, you'd certainly be able to challenge that if there's a ruling I make that you choose you want to appeal. Okay? So let's stay away from those areas during the remainder of your examination of Ms. Ross. But you waive nothing and you are not walking away from that type of examination.
And so then what I was going to do and will not do then is I was going to ask her about what came out in Clayton County so far as Leslie's statement to Detective Martin. And was she aware of any of that? I guess I already ever talked to you, that type of stuff.
Okay.
Okay. Ms. Ross, was there any offer ever made to Mr. Singleton?
Not that I remember.
The Clayton County jury transcript, page 128.
Hold on, the Clayton County
Yes.
transcript? Okay.
She's testified multiple times that she has no knowledge of what happened in Clayton County at his second trial.
Okay, well, let's let Mr. Hort ask the question. Don't even hand her the transcript yet. Just ask the question first, and then I'll see if we need to go any further with a question about what happened in the Clayton County trial, not prosecuted by the Fulton DA's office and thus certainly not by Ms. Ross. Was the Clayton County trial, how many years after the?
Soon thereafter. I think it was in 2002,
Give me one
maybe.
second, Your Honor.
Okay. I don't need the precise date, but was it 1 year later or 5 years later?
It was within 1 or 2 years, I think within a year.
It was July after the March. So July 2001, March 2001 was this trial, July 2001 was Clayton.
Oh, so it really was just a few months apart. Okay. All right. Either way.
Okay, so the Clayton County transcript says that Leslie's mom said Detective Martin convinced her to get Leslie to help the police, and that if he gave them a statement, if he was involved in this case, he could just get 10 years or something like that. So that, the problem again is we don't have transcripts from any motion to suppress in Fulton County or this subject area. So this is what came out in Clayton County. So that's leading to my question. Does that suggest that there was an offer made to Leslie, testify 10 years, something like that?
No, it was not.
Would you have been willing to talk with Susan Wardell about a plea?
I'm willing to talk to anyone about a plea.
Okay. And Gashard never explored this with you to your memory?
I don't know if he did or not. I don't remember.
Okay. And you're aware of Ms. Wardell's extensive experience, expertise in juvenile behavior?
I do.
And you've worked with her in the past?
I have.
Were you familiar with Fulton County Conflict Defender Office lead investigator, Mr. Dixon?
I don't think so.
Okay. Again, being the lead investigator, that doesn't ring a bell or anything of that nature.
It's not my investigator. So no, I don't work with defense attorney investigators. I only work with my investigators. Because they have an attorney-client privilege with, or work product privilege with their attorneys.
My point is
You can share with me your point later, but just questions for Ms. Ross. And she's saying she doesn't know Mr. Dixon.
Yeah, I was just trying to explain that we're on two different pages here and I was trying to show her or tell her what I was trying to do.
Okay, don't just ask questions.
Okay. Did Waters get a plea deal?
Waters pled to life plus 10.
So he did get a plea deal.
Yeah, yes, it's in the record. I wouldn't call that a deal, but he got life plus 10, yes.
Do you recall any reason, Ms. Ross, why you wouldn't have made a similar offer to, I know you don't know if you did or not. I hear you loud and clearly on that, but does anything come to mind as you re-immerse yourself into this case as to why you wouldn't have extended a similar offer to Mr. Singleton through his counsel?
Definitely there would have been a similar offer, but that's hardly a deal that anyone would take. But yeah, life would have been an offer that the district attorney would have accepted for the shooter and the non-shooter.
Okay.
But there are not many people that want to plead to life.
Okay, understood. And I most of all understand that the specifics of what happened 25 years ago, you don't have in front of you anymore. But nothing's jumping out and saying, well, Singleton, who wasn't the shooter, should have been offered something greater than life plus 10.
No, that would not. I don't believe that would have happened.
Okay.
Showing what's remarked as defense proposed exhibit T, a copy of which has been given to Mr. Armstrong. Is that the letter from you dated December 4, 2000, where you disclosed that there was a plea agreement with co-defendant Michael Waters?
Okay.
I would move to have that admitted in evidence.
Mr. Armstrong, any objection to admitting defendant's T, as in Thomas, into the record?
No, Your Honor.
All right, it's admitted. Thank you. when it says that the plea colloquy is attached, I guess it's literally the transcript. He had already pled to counts 2 and 7. And so that's what you're guessing, you don't have it in front of you, would have been attached.
Yes, that seems to be correct.
Okay.
In your closing argument, you said, and I'm referring to volume 4, page 214, Waters was getting life plus 10. He's not getting anything out of this. Is that correct?
If the transcript said that, that's what I said.
Okay. Without the plea deal, what was Waters looking at?
You'd have to show me the indictment, but at least 1 life sentence. And then, so here it says he got life plus 10. And this would be life with the possibility of parole because, right, in 2000, the only way to get LWOP on a murder would to be file a notice of death penalty or whether they're a recidivist. So he was only eligible for life with the possibility of parole on the malice murder count. The felony murder count, since it's 1 victim, would be vacated as a matter of law. And then it would just be a matter of what felonies are remaining on the indictment that he could be sentenced to if he was convicted of everything on the indictment.
Let me show you a copy of the indictment.
So malice murder, he would be eligible for life with the possibility of parole, which would have been both the maximum and the minimum that he could be sentenced to at that time. Felony murder, felony murder, felony murder, that's counts 2, 3, and 4 would have to be vacated as a matter of law. And then hijacking, that's 2 separate victims. I don't know what the penalty, the maximum penalty was for hijacking back then. Armed robbery, count 7 is a life sentence as a maximum, minimum of 10. Ag assault would be 1 to 20, except he could only be sentenced on Debbie Blaylock's ag assault because Mr. Grigley's ag assault would merge into count 1. And commission of firearm during commission of a felony would be 5. So I'd have to add it all up.
But it could be 2 consecutive life sentences plus at least 40 for the 2 carjackings, which I think was 10 to 20, plus 5 more. So 2 consecutive lives plus 45. Maybe more, but not less, if we're maxing everything out.
If we are, yes.
Yes.
Although the ag assault count.
Oh, I forgot about the ag assault on
the ag assault
her.
would have to merge. His would merge, hers would not.
Right. So it's actually 60.
60 or 65?
Yeah, 65, correct. Most importantly, in theory, it could have been 2 consecutive life sentences, and it wasn't.
So still, he wasn't getting anything out of this?
Whatever he pled to is in the record. It was disclosed to the defense attorneys and it was disclosed to the jury. If you want my personal opinion of I would ever plead to life, I wouldn't. So I don't think that that's a good deal. But that's all I can tell you is what he got. It's disclosed to the defense attorneys. It was disclosed to the jury.
And she's free to argue in closing argument that he didn't get anything for it. She's not going to say it's a great deal, so you shouldn't believe him. Oh, she's an advocate in the same way that Gashard would say, what a great deal this guy got. He was looking at 2 consecutive life sentences plus 65 years. No wonder he's sang like a bird for the state. And if you didn't argue that, you should say he wasn't effective. But for a prosecutor to put a gloss on something to a jury like that, I don't understand the point you're making.
Wow. And again, I'm from Michigan, but in Michigan, a prosecutor doesn't say something that's not true.
It's an opinion.
Still. I mean, he was looking at 2 consecutive life sentences plus 65 years. He got 1 life plus 10.
Right? And according to your article, he's never, ever, ever going to get out. So he got life without parole because parole is broken. It's a cruel and unusual sentence. It's harsh. He didn't get anything worth writing home about. I mean, you can't have it both ways.
It seems like the court is trying to. In his letter, defendants proposed exhibits B and C. He says that you all kept drilling in his head that he would do 14 years and be free.
I don't talk to defendants that are flipped about parole. That is not my job and I don't do it.
Did anybody tell him that, to your knowledge?
Not to my knowledge. You'd have to ask his attorney that.
What was the state of the law in Georgia as to parole eligibility in 2001?
For murder?
For a life sentence.
For murder?
Let me ask this way. Is it true that a life sentence in 2000 meant that a person could be considered for parole after 14 years?
I believe so. I can't remember when it switched to 30, but it was sometime in the 2000s that it became 30.
And you're saying that nobody told him he'd be eligible for parole after 14 years?
Objection, Your Honor. She said she does not know.
Right. She didn't, her testimony is her testimony. Next question, asked and answered.
Would you agree there's no way this was going to happen? He wasn't going home in 14 years.
Objection, speculation.
Sustained.
Recognizing the court's instructions, I'm going to move on then. What, if anything, can you tell us about Carl Greenberg?
I knew Carl Greenberg. I'd see him around the courthouse, but he was an appellate lawyer and I wasn't, so I'm not even sure we had cases together, but I would see him around and talk to him.
True, he used to be in the DA's office?
He was in the Fulton DA's office?
Yes.
I don't remember that. I remember Carl Greenberg as an appellate attorney who would float the circuit here. He was just kind of in and out of court.
Do you know the when and why he left the FCCD office?
The who?
When Carl Greenberg, the when and why he left the Fulton County Conflict Office?
No, I don't.
Is it true to your knowledge that Greenberg never raised ineffective assistance of counsel against his friend and colleague, Gashard?
I don't know.
Was Gashard as a trial lawyer and Greenberg as an appellate lawyer in the same office back then, was that a conflict of interest?
I don't know.
Is it now?
I don't know.
Did you know anything about the state filing a motion for appointment of counsel and for a status conference on August 5, 2005?
I have no memory of that. You'd have to show me a motion. The state filed a motion?
Yes.
I don't know.
ADA appellate attorney Mark Mellon.
So then I didn't file the motion. So no, I don't know anything about it.
Okay. Did you want to see it?
You could show it to me, but I have no memory of it. Probably because I didn't file it.
Why don't you ask your next question about it? Because then we'll see if she even needs to look at it.
Did Mr. Mellon ever discuss this with you as the trial lawyer?
Not that I have any memory of. Malin handled lots of appeals, including lots of my appeals, but I don't have any specific recollection of Mark Malin talking to me about this case.
Is that the norm back then for appellate attorneys to confer with a trial lawyer?
It depends on the case.
How was that the norm for Mr. Mellon? Did he talk with the trial lawyers when he was doing appeals?
I don't know, because I can't remember him taking one of my cases all the way from motion to new trial to the Supreme Court. I remember being in court with Mark on certain cases, but it was before they were convicted, because sometimes appeals would help us, but no, I don't know.
Do you know why he filed a motion for appointment of counsel to replace Mr. Greenberg?
I do not.
Do you know why the judge didn't act on it?
I have no idea.
Did you have any discussion thereafter when the court did nothing about filing another motion?
I don't know anything about anything that happened to this case after the trial.
So it's possible that you could have, you just don't remember.
I have no memory of it.
It's possible that you could have, you just don't remember.
I didn't participate in appeals. I very rarely would participate in appeals. There's only one case I handled here as a trial lawyer that I also did the appeal. Otherwise, I would try my case. They would either get convicted or they would get acquitted, and it would go to appeals. And then I move on to the next trial. We were a trial unit, and there was an appellate unit who handled our appeals.
What case was that?
The only one case?
Yeah.
It was Scott Davis, because the record was too long and the appellate division didn't want to read it, so I had to read it.
So
Sorry.
appellate lawyers and trial lawyers weren't talking to each other.
We do talk. That's not what I said. I just said, I have no, I don't.
She doesn't have a specific recollection of what happened in this case.
That I-
Could have happened, might not. Those are my words, not hers. She is saying she doesn't recall what happened.
I mean, can you tell us anything about attorney Elizabeth Rogan?
Objection relevance.
I'm remembering how she's connected to the case, so.
Your answer is, can I tell you anything about her?
Yes.
No. I mean, I think I know of her. I know her, I think in passing, but I don't know what you mean by, can I tell you anything about her? I know her name.
You don't connect her in any way with this case.
I don't have a recollection of her being involved in this case.
At sentencing, Gishard indicated an intention to ask the court to keep his juvenile with the Department of Justice until he turned 21, volume 4, page 1130. Did he ever pursue this or talk to you about this?
I have no memory of my conversations with Gary Gishard outside of court.
And with the court's rulings, that's the end of my questions.
All right, Mr. Armstrong, do you have questions for Ms. Ross?
I do.
All right. Prepare your cross-examination.
Good afternoon, Ms. Ross.
Hello.
So last time that we were here, there was an assertion that maybe we talked together. Have we talked about the substance of your testimony since you began testifying?
No.
Okay. We did talk about you having a potential issue with a flight, correct?
A flight from, to fly to Atlanta?
Correct, from Philadelphia. And that was because you might not have been able to attend the hearing as scheduled.
I think technically it was Pittsburgh, but yeah.
But we didn't discuss any of the substance of the case. We were just talking about logistics. Okay.
I didn't think I was going to be here in the morning, which is why yours is the only number I had to call to let you know I wouldn't be here.
And you specifically asked me to contact the judge and the defense attorney.
Should I not arrive? Yes.
Correct. Okay. Gonna go near the back, State's Exhibit T, the letter that you wrote about the plea that Michael Waters had entered.
Yeah.
Why would you send a letter like this?
Because I wanted to notify the defense attorneys that a co-defendant has fled and was going to testify.
Okay. And to the best of your knowledge, the plea and everything associated with it is on the record.
Yes. I say the plea is on the record. I don't think the November 28th, 2000 statement is on the record, but there is a record of it that I disclosed to the defense attorneys.
Okay. And is that the typewritten document that we've seen in previous hearings?
Yes, I think Mr. Ford had handed it to me as defense. It might be T also.
Let me see.
I can't read. Is that also a T?
I hope not.
That really looks like a T.
Okay.
So then we got two Ts.
Can you show that to Mr. Hort, just so we can relabel things?
Your T?
Could be a Michigan letter.
Yeah. Never can see where it matches up.
That was a two.
All right. Well, what is that document?
It is the statement that was made with Ms. Ross and Mr. Waters, defense counsel and others.
Got it. So it's Waters number 3. We've been talking about, so it's the November 28th.
I don't know the exact date off the top of my head.
Round
but yes.
about that. Okay. We've talked about that fairly extensively. So I think previous days will have a T associated with that. So we should come up with a different letter for, as in a letter of the alphabet, for Ms. Ross's, back then it was Ross Finley, letter to Ms. Walsh and Mr. Gishard.
I believe U and V were the last exhibits that he has, so W would be next.
Well, but we also have an X already in, so I don't know if W is spoken for.
I hate to,
The T back, I don't want to like
it's
walk.
not a key for why.
That's a Y?
Oh, it's a Y.
Oh, great.
Okay.
Do you mind if I write the Y a little bit clearer? Okay.
Problem solved.
That would explain that. Okay, so I'm handing you back what you just handed me. That's marked Y. Looking at that document and the questions that you're asking, Mr. Waters, those are open-ended questions, correct?
Yes, somewhat.
And that's because you're trying to get information from Mr. Waters, correct? Now, there have been questions about whether people have been coerced into making statements. Did you ever tell a defendant, did you ever feed a witness information that you wanted them to testify to?
No, I mean, I can talk about topics that I want to talk about, but I don't really understand your question.
The question is, did you tell Mike Waters what to say?
I didn't even really remember this statement until they showed it to me. I have no memory of my conversations with Michael Waters. I'm sure I had, more than one, but no, I don't tell my cooperating co-defendants what to say.
Okay.
They're either going to cooperate or they're not. And I don't really care one way or the other. That's why he's left open for sentencing. He's either going to cooperate or he's not going to cooperate.
Absolutely.
It's up to him.
In your direct just a few minutes ago, you testified, you were asked about pressure put on Ibarra, and you testified that you did not know of any pressure or coercion against Ibarra, and that you'd have brought it to somebody's attention if you had known about it, correct?
Yes, and I guess pressure was Mr. Fort's word, and I don't really know what he meant by pressure, but what I meant by coercion, no. I mean, some people think talking to police officers just alone is pressure, so. But no, I have no memory or knowledge that Mr. Ibarra or any other witness was coerced unlawfully by law enforcement.
And I'm just going to go through it very, very quickly. Do you have any reason to believe that Mike Waters was coerced by the police?
No.
Do you have any reason to believe that David Marquez was coerced by the police?
No.
Do you have any reason to believe that Leslie Singleton was coerced by the police?
No.
If the transcript represents that at trial, Leslie Single testified, would you have any reason to doubt that?
That he just testified, period?
Correct.
Okay, not about what he said.
I was doing the steps.
Okay.
Trying to avoid the compound questions.
Okay.
I have no reason to believe that the transcript is inaccurate.
Okay. And so if you asked him about whether officers had threatened him before he gave his statement, you would have no reason to believe that that wasn't actually what you'd said.
No, I have no reason to believe the transcript's not accurate.
And if Leslie Singleton denied being threatened by the police, you have no reason to say that that transcript is wrong for representing that.
Correct.
Okay.
I have no reason to believe the transcript is inaccurate.
Okay.
Can you get a volume and page number for that?
Yes, it is volume 3, pages 887 and 888. If transcripts of pretrial hearings indicate that you were surprised by Mike Waters' attorney out of the blue saying he was going to plead guilty to the indictment, would you have any reason to say that that didn't happen?
No.
Okay.
How would a transcript reflect surprise? As in, she literally said, I wasn't expecting this, or something to that effect.
Do you believe that both she and Ms. Down and Judge Downs both said that?
Okay.
Excuse me, I thought we weren't going to do that.
I was
Do
asking
what?
her a question. He asked me a follow-up.
Speak for itself.
Well, I'm asking her if she has any reason to believe that the transcript is wrong as to that very specific instance.
I can do that then.
If you're asking about what's in the transcript, but not her, you should ask the questions you want on redirect.
Do you have any personal animosity against Mike Waters?
No.
Do you have any personal animosity against David Marquez?
No.
Do you have any personal animosity against Leslie Singleton?
No.
Was there any reason that you just needed to get Leslie Singleton and do whatever you could to get him convicted? Okay. There's an issue about sleep or narcolepsy that was brought up about Gary Gouchard previously. At any point in time, do you have any memory of noticing Gary Gouchard asleep during this trial?
I would object to the leading questions.
I'm on cross.
You called the witness.
Yes, and she's a hostile witness. She's the state. I mean, they even sat together at the table here.
No, we didn't.
So I think the court does have some discretion to control the process.
I do, and I don't find it inappropriate for this attorney to cross-examine this witness.
Leading questions.
That would be cross-examination, correct?
At any point in time, do you have any memory? Strike that. At any point in time, saying that again, strike that. Do you have any recollection at any point during this trial of Gary Gouchard being asleep at counsel table?
No.
In your experience, Do you bring something like that to the court's attention if you see it happen?
I do. Yes. And I've seen judges bring it up if it happens.
Is Judge Downs one of those judges?
Yes, Judge Downs is a very active jurist.
You indicated that you had seen Carl Greenberg around the circuit, correct? Are you aware?
Not like I've seen him in a courtroom. You know what I'm saying? I've seen him in this building. I've seen him in the courtroom.
Yeah.
We weren't friends or anything, but I would just see him around. He's one of the lawyers I would see.
Are you aware whether he was a defense attorney for death penalty cases?
I thought that was Mike Mears. It may have been Greenberg as well. I can't remember.
Okay.
I don't know. I just don't know.
Your recollection is that Leslie Singleton said CJ and Ron did it in his first statement to the police, correct?
No, my recollection, I don't have much of recollection of this case, but whatever he wrote in his statements, which are here. And also, I'm assuming there's a recorded statement that goes along with this.
Okay.
And I'm not even going to try to tell you the exhibit numbers because I can't read them, but CJ and Rod is in the statement here somewhere.
So I'm going to do a callback to a previous hearing. If officers are looking for two people who were not actually involved in a murder, would that be considered a wild goose chase?
Yes.
Okay. If you could just have a moment, Your Honor.
Sure.
Right, these are water statements. That's not Singleton statements. So that's a different statement. Those are water statements, not Singleton statements. Did you ask me about Waters or Singleton?
Singleton.
Right, okay, those are water statements that are in front of me. I don't have Singleton statements in front of me. Those are all Waters, those are transcripts.
I think you testified about this on direct. There have been allegations that you have met with defendants alone. Have you ever met with a murder defendant alone?
No.
Why not?
Because one, it's dangerous, especially if it's a male. And two, I always have an investigator or a police officer or a witness who is with me to witness the conversation.
Okay.
But it was also just dangerous.
Yeah. No further questions, Your Honor.
Mr. Hort, redirect.
So fair to say that when you talked to Mr. Waters, maybe even Mr. Ybarra, you would have had your office investigator with you or a police officer, something like that?
Somebody would have been with me. I would not have been alone.
Okay. What about once he agreed to testify, when you talked to Waters, would his attorney have been there?
If his attorney wanted to be there, he would be there. Sometimes the attorneys want to be there. Sometimes they don't want to be there. I leave it up to the attorney.
Okay, thank you.
But I would still have an investigator with me because I can't be alone with a male defendant.
Nothing else? Okay. May Ms. Ross be excused?
Well, has the court ruled on the notes?
No, we can talk about that. And excused doesn't mean she can't be recalled if there's a development in some discussion we have that prompts you to have some questions you want to ask her. But for today, it sounds like we're done with Ms. Ross. And at this juncture, there's not a reason for her to expect to be hailed back into this courtroom for this motion for new trial. Fair statement?
I want to make sure this subpoena still remains in effect if we do get to that point.
She never received a subpoena. It was her testimony before.
Yeah, y'all just need to tell me to be here.
Right.
If I'm not traveling, I will be here.
Exactly. I have no worries about getting Ms. Ross into court if I decide it's appropriate for her to come back for further examination. So don't worry about the subpoena piece. She's not going to not show up if we need her to be back here.
Start right now, office with your subpoena.
Don't know, but I'm not worried about that. So thank you, Ms. Ross, for all your time. May you have a joyous weekend.
Thank you. May I be excused?
Yes.
Thank you. And there's all this stuff still here. I'll just leave
Yep.
it.
We'll deal with it in an organized fashion. All right, Mr. Hort, tell me what you'd like to do next. We can talk about the work product, the notes. There may be other procedural things. You graciously agreed to put some things towards the end of the day. I know Mr. Singleton is anxious to testify. There's no way we will get through all of that before he needs to roll off per GDC rules. So I don't know if you want to start that and then we pick it up later, or you want it to be all in one fell swoop, or if you want to have a private conversation with him before we decide what to do. You may have a plan.
I would like to discuss, there are many outstanding motions and questions. And as we draw near the end of this hearing process, I need to know whether I got to call any witnesses, if the court's going to deny my request, those type of questions.
Okay. Tell me what you'd like to discuss first. I need you to get a little closer to the microphone so Ms. Rivers can hear you. And if it's easier, I know your preference is to stand and you can do that. You've been standing for a while. You're also welcome to be at council table as long as you're speaking into that microphone.
It might be easier for me to stay here.
Okay.
The first one is the offering into evidence exhibit N.
N is the police certification board. You used an acronym that no one knew, but it's the basically Popless investigation.
Yes, the case summary, case number is 002-578-0703.
It's a long case number.
And it's just the results of the investigation and the revocation of the certification.
Is it Post that's investigating him? Because I'm not interested in going much deeper if we don't even know who wrote that. I don't mean Fred Jones wrote it, but what's the entity that did it?
The recommendation to the council by the chairman and the vice chairman, and it says PCC chairman and council chairman.
Where did you get that?
Mr. Alig got that through our research.
Okay. But you're not in a position to say that it came from the Peace Officer Standards and Training Council or something different? And with no origin, it's kind of hard for me to sort out what to do, not having even heard Mr. Armstrong's objections yet. But if you have no objection to N being made part of the record, we don't need to dig deeper. Do you have a copy of N in front of you?
I do, Your Honor. My objection is mainly to relevance because it came across years after the trial of this case. Gabriel Bouchard could not be ineffective for failing to raise something that had not happened yet at trial. And so I do not believe it is relevant. I am not entirely sure what it is. Typically, organizations will certify documents, and if it's certified, I have no objection to it. As far as being for authentication purposes, so no witness would need to come in here to do anything about it. But this is essentially assertions of fact from information where they're not relevant and there's nothing, I don't see a purpose to it, but also we don't have a situation where we need to have a sideshow where Officer Popless comes in and defends himself for something that's not relevant.
Okay. Mr. Hort, setting aside the authentication work that you might need to do on that, it sounds like the date of this decertification or whatever happened to Popless was long after the trial. How does it tie into an argument that you intend to make and probably have already been making about why there should be a new trial for Mr. Singleton?
One, that Bouchard was ineffective for not looking into Popless.
Okay, but let's do one at a time. When were these findings made that Popless maybe wasn't a super reliable guy?
It says on July 16, 2002, he admitted during a GBI investigation to tampering with evidence.
Okay, so July 2002.
That's when he admitted it.
Yeah.
So I can't tell. That would also be the date that it happened.
The dates under the signature or like the names of the people is 2005.
Right. I heard the 2005. So this report wouldn't have been available for Mr. Gashard to do something with until 05.
I'm sorry, I was talking about the date that he tampered with evidence.
Okay. We don't know that, I guess. There's just an admission that he supposedly did that. But that admission date to the GBI, and I don't think this report's from the GBI, was also after the trial. So tie it back into Mr. Gashard not doing what he should have at the sort of basic level of professionalism for Mr. Singleton.
Well, one, we've already admitted into evidence, defendant's exhibit. J, which was the Fulton County Police Department statement form for Officer Darren Bell, who raised all of these issues as to Officer Populous. And so to my thought, there is one, that should have been enough that that Gary Gashard should have gone ahead and done some investigation. And
How do
two,
we know that Mr. Gashard had Bell's paperwork?
I assume the state gave that to them in discovery,
How did you get it?
from Mr. Armstrong, I believe.
Okay, so your sense is that's part of the discovery packet? I don't know these things.
Yeah, and I think I got maybe an answer to that, but
There was in Discovery 6 pages that I turned over. It is under 14-Darren Bell-6 pages. That was written in January 2001.
Okay.
and I don't know when ADA Ross turned it over to Gashard. My client, I believe, is going to testify that he only found out about it post-conviction when his family got the report.
Okay. But your sense is that Mr. Gashard would have had it before trial, and whatever Bell did was to decide, I don't think Populous is being upfront about what happened with his gun?
You'll see in that exhibit, again, that's been received, that there were legitimate concerns by one officer as to another officer.
And Bell is what letter are his reports?
Exhibit J.
J, okay.
So it was already out there that Gashard should have looked into it. And my point is this corroborates that Populous had issues. And if Gashard would have done the investigation, who knows, there might have been other things that corroborate that Populous was fabricating what happened.
Okay. I'll tell you what, if you can get me and Mr. Armstrong a little more information about the origins of this document, then I'll consider making it part of the record.
And maybe Mr. Armstrong knows what PCC stands for.
Well, I'm not going to put the onus on Mr. Armstrong. He's not the one trying to get in. And you don't need to solve it right now. You can reach out to Mr. Allig.
Okay.
And he can refresh your recollection as to where it came from.
I guess my thought was in response to the court's concerns that there's no question but that looking at this exhibit, it's admissible under the rules of evidence 24.9.201. It's evidence that a document authorized by law to be recorded or filed, in fact, was recorded or filed in a public office.
What was that rule of evidence number?
24-9-901.
Oh, 901. Okay. Well, I think you've got some authentication issues with it. I don't know where it came from. It's not certified. So.
And with all due respect, I don't know that it needs to be certified if it's clear from the document itself that it's public record.
How would I get my hands on that?
Probably the same way Mr. League did.
I don't know how he did. That's the problem.
Yeah.
Well, did he slip someone $10? Is it on a computer? Did he have a subpoena? So let's table N for now.
Okay. So, motion for discovery of the state trial attorney's notes.
Yes.
And I have another copy of that if you want to look at it.
Nope. I'd like to hear from Mr. Armstrong, the state's position on that. And my interest is twofold. One, I think is relevant. I appreciate the work product protection, et cetera, but we're now, I don't know if statute of limitations is the wrong word, but it's 25 years afterwards. And I'm just curious how, when we read about convictions that are overturned 20 years later, somehow the defense got a hold of the prosecutor's notes during jury selection and they're like, no, you got to strike that guy. He's the wrong skin color. And then all of a sudden a Batson issue is articulated years and years and years after the trial. And somehow those notes get handed over. And I'm assuming it's not inadvertently handed over. Maybe that's what it's been. What's the state's position on this?
The state's position is that there is no need for it, but also they called a witness. They made her opinions on everything an issue in the hearing, which it's not relevant for any of those things. What happened in the hearing is what happened in the hearing. And so basically, if you do it in this case, you're going to basically do this in every case. And so basically every case is going to have work product turned over, which is unnecessary. It's a privilege for a reason. I have not read through all the things. If the court is inclined to grant his motion, I'd ask instead that you not give it to him, but the court read everything,
right,
which was probably going to be bleeding eyes at the end of it. But no, the state is not going to just give over to somebody who's made Sheila Ross a witness all the notes, regardless of who might have written them.
Okay. Mr. Hort, what do you want to add to the discussion?
I think as with so much of what we've talked about, there's a difference here. There's not a jury. There's a judge that can do things back in his office, look at things. He can do things and keep privileged information privileged. But again, this trial is unique and it's not just another one that Mr. Armstrong's going to have to worry about tomorrow. The passage of time, the passing away again of the trial attorney, the mental health issues of the appellate attorney, the other witnesses that have died, Marquez, Ybarra. I would cite, United States versus Nixon.
Oh, is Ybarra dead also?
Yeah.
Just write that down. And what's your, I'm not doubting you, but how?
He was killed, murdered. Okay. I found that out by doing the Google search. That.
Well, if it's on Google, it must be true. So Marquez, Kashard, and Ybarra all deceased.
And the Department of Justice person.
Oh, you keep saying Department of Justice, which has particular connotations these days, but it's DJJ.
The justice person that did the statement or did the report.
Juvenile justice.
There we go.
Yeah. And I know who you're talking about. I don't know the name, but you mentioned that at the outset. Okay.
And so again, citing United States versus Nixon, that evidentiary privileges in litigation are not favored. And the problem is we don't know what those notes say. Maybe Mr. Armstrong does, but.
Let me give you a what if, because I'm curious how these advance your arguments. What if Ms. Ross's notes from her interview of Mr. Waters, turns out there is one, making all this up. She talked with him and in there, it says little brown wallet. So that's in her notes. How does that advance the cause of a new trial for Mr. Singleton?
Because it does show that she talked with him. Mm-hmm. And my memory of the last hearing is that she denied talking to him.
My memory of every time you asked her is she doesn't recall. I don't remember a specific, no, that didn't happen concerning Mr. Waters, other than she did not suborn his perjury.
And it may be that you might be right. She didn't recall ever talking to him. The day she.
Well, to be clear, it was, she talks to witnesses who will talk to her. And so she said she would have spoken with him before he testified. She couldn't tell you how many times, but the record is the record. I'm recalling that she said she did talk to him. So it wouldn't, not that impeaching her is going to, again, advance the motion for a new trial, but let's say in the notes, little brown wallet's in there.
So if it shows that she had talked with defendants prior to the trial, could that then show that she knew when a person was not going to testify truthfully or did anything to encourage less than truthful testimony?
Okay, she's testified a whole lot about how that's not what she did, but and I will tell you that the examples that you've highlighted, you and I have a fundamental interpretive disagreement. They don't fall into the clear category of witness told prosecutor before trial, I wasn't there. At trial, witness says, I was there, and that's helpful for the prosecution. It's much more like the one we got hung up on, you and I did with Ibarra, where Ibarra says it was Waters' idea, but he testifies that Singleton was part of it. To me, both those statements can be true. One isn't in conflict with the other. So it seems a little bit like a fishing expedition to say, I want to see the notes because I want to see where it was that a prosecutor learned X and the testimony was opposite X, as opposed to the prosecutor learned X and the testimony was Q. Those aren't opposites. There's just little brown wallet came out. But I would ask if it's, Mr. Armstrong, have you looked at the universe of notes? I don't mean, did you read it all, but you know that it's like 5 pieces of paper or?
It's more than 5 pieces of paper.
Do they appear to be organized in any way? And I ask it because I would be inclined to ask to get from you for my in-camera review the notes that would be reflective of any interviews Ms. Ross had with Mr. Waters. But I don't want to make you go through 700 pieces of hard to read paper to find that.
I would be handing it to you if you go through those 700.
Okay. All right. Is that both Redwell's worth?
I'm sorry?
Both Redwells are?
There are handwritten notes in both of them. There are other things that I turned over. There are printed out case citations, but there's a mix of it. They're typically in file folders within it.
Okay.
And then you have things it's going to hold the place for. You have things like a notepad.
Right. Okay. All right. Anything else, Mr. Court, you want to add to your motion for the production of state's work product?
And it's not just Mr. Waters, it's Detective Martin, it's Ybarra.
You want lots of things, but your wants and my inquiry aren't necessarily fully aligned.
What if it's Brady material? What if her notes say, wow, Waters isn't going to say this, I got to keep trying.
Right, what if, but to Mr. Armstrong's point, the default is not that prosecutors' notes are handed over during the course of a motion for new trial, or really ever. It is after a showing that there's reason to believe that there's been the withholding of information like that. And so now we're circling back to me asking you for specifics and not, did you believe this witness? And the specifics we heard today were in statements, only one of which was given to Ms. Ross. There was not mention of a little brown wallet, but at trial there is mention of a little brown wallet. That doesn't mean that the earlier statements were untruthful. they weren't as complete. They omitted something. You've got those statements. And so you had an opportunity to confront Ms. Ross and say, look, you asked him, did you see anything on the ground? He said, no, ma'am. I would remember it if I saw something on the ground. And then at trial, all of a sudden, a little brown wallet. Something like that coming up is a reason for a judge to say, all right, I need to look at the notes. I've been a prosecutor in a case where the judge said, I need to see the notes. Co-counsel, but it was still something that needed to be worked through. I don't feel like we're in that space.
You don't think Gashard should have done that?
Two different things. I don't know what Gashard did. You didn't tell me he didn't ask for the notes. But I don't know what he would have pointed to. Because that's the point I'm making is I'm not seeing the, yes, Mr. Waters' statement evolved, as did Singleton's, as did Merez's, and we all see that. The first statement is CJ and Rod. I mean, your client told the police the first time out, there's a guy with a big blonde afro who was the shooter. There were no big blonde afros there. So, gosh, statement number one wasn't truthful. That doesn't mean that the prosecution, even writ large, law enforcement was involved in eliciting or procuring false statements. It means that a young man who's scared doesn't tell the whole story at first. But you haven't highlighted for me a reason to think that the state got one version of events, didn't like it, and concocted version 2. These story evolutions seem to be much more the organic process of the young man who dissembled and withheld initially and evolved. I don't know that any of us should think that the story at trial was the full story either. I don't know what was in the affidavit from Mr. Waters that now isn't coming in because Mr. Waters had a change of heart. I don't know if that's the full story. And that's years later. Maybe he added something because his heart wants him to add it, or his memory has faded, or it's too hurtful to remember the way it really worked. And so he substituted something for it. I mean, those are unknowable things. But if you can point me towards look, told the state there was nothing on the ground, and then there's the testimony, and Ms. Ross didn't then and there say, now, wait a minute, that's not what you told us before. Why are you changing your story? Then, there may be something for me to explore, but you've got a hunch or hey, I just know how prosecutors are out to win no matter what. Law enforcement, they're feeling a certain way because it's their colleague who was shot, and so they're going to steamroll this one. But maybe I'm missing an example that you brought up where it is, here's what witness X told the prosecutor or law enforcement before trial, and it fundamentally shifted at trial.
But I guess that is what I'm trying to tell the court. It was not in his earlier statements, 1, 2, or 3.
The little brown wallet?
The little brown wallet. It was not in the indictment. And then all of a sudden it's a trial. And I think the way the question was asked, the questions that were asked, suggest that the prosecutor knew this was going to happen. So that's why it would be important, I think, if there was any note that one showed that she did talk to Waters before the trial, and 2 was the little brown wallet discussed.
Okay. Anything else?
On that specific, I can talk about Ybarra and I can talk about Martin if you want me to.
Talk a little bit about Martin. Ybarra, I'm not particularly persuaded by.
So Detective Martin said, the second Waters statement was the truth of what happened.
He said that on the stand?
Yes.
And no one objected to that?
And no one objected.
Okay.
And like the last hearing, you said Gashard should have, and I appreciate that. But that also was not a true statement from Detective Martin, or at the very least, it was misleading. Because after that second statement, they then went and looked for the items that Waters had mentioned in that statement, could not find it, came back and took another statement from Waters. That statement was not recorded, not put in writing. And to me, there is a red flag right there. Martin also said that after he talked to Singleton, he didn't have any further contact with him. That was also not true. After they talked, he then also took Singleton looking for evidence. After they talked, they had the one-on-one show up. After they talked, Martin was also present when his blood was withdrawn. And I think there was one more, maybe, I don't remember what that one was. So he did have contact with Singleton after he took his statement. And that was either false or at the very least misleading. And also, Detective Martin has testified that he did not make any promises to Singleton. And that's not true based on what we found out what happened when this area was explored in Clayton County. So all of this again points, one, to ineffective assistance of counsel. Two, if nothing else, it raises red flags. And three, can that be supported by notes? Anything that gives further light, again, after so many years in the passing of people, that I could ask that question.
Why didn't you call Detective Martin?
We've tried to find him. I can't find him. I even reached out to the Fulton County Public Defender people.
Okay.
And if I had to guess, his testimony might be similar to Ms. Ross.
Could be. All right. Anything else on your motion?
Again, I've cited case law about waiving the privilege. I just think under that worst scenario, the court should look at it with an open mind and see if there's anything in there that is relative or relevant to our discussions here in court, the evidence that we've been trying to present. And two, is there anything in there that falls under Brady or that is exculpatory that should be disclosed? And as I say that again, I know you, I know me, and I know that after something happens, if we have concerns that this wasn't right, we don't not do nothing. We check it out, we do something.
Right. Okay. What other matters did you want to discuss?
I'm starting to lose my voice.
Okay. Well, nature may bring a close to today's session. I'm listening.
Okay, there have been multiple emails back and forth between counsel, sometimes including the court. I don't know if, for the record, if you want any of those to be part of the court file. What's your norm? What's your preference?
I don't tend to make communications part of any file. If there's something you want made part of the record, then there's a way that you don't need my permission. You can file them in. You just have a pleading that says the attached are made part of the record, or I don't know what that looks like on the drop-down menu and the e-filing system.
And I do have some additional information so far as the populace case summary and with his
Meaning N?
I've got documentation from the State of Georgia Peace Officer Standards and Training Council.
Okay.
Still doesn't have that PCC. But it
No, but
does.
that's where it would have come from. I don't know what PCC stands for, but the only organization in Georgia I'm aware of that could be tangling with a peace officer certification would be Post.
So I don't know if I can attach that or include that with N. I don't know if that answers the court's question or Mr. Armstrong's concern so far as its admissibility.
Well, why don't you can package that up and send it to Mr. Armstrong. He can look at it, and just via email, we can see if that addresses any concerns about authenticity. I understand there's still the relevance objection from the state, but that may at least suffice to show this is what this is and where it came from, and it is a record produced in the ordinary course of business, et cetera. Whatever might get it in through 901 or another evidence law provision.
And you had mentioned earlier that you would also like to see that bond motion filed by Mr. Gishard for Mr. Singleton.
I have a copy for him.
Great. It doesn't need to be an exhibit. I'm just curious because there was a whole lot of emphasis put on it. And I know you didn't know what was in it, so it was going to be instructive to you.
Doesn't say that it was filed, at least from the one Mr. Armstrong gave me.
That might explain why it wasn't in the docket. Okay.
And I don't know if you want to have any further discussion on defendant's proposed exhibit S, the article from the Atlanta Journal-Constitution.
I don't, but if there are more things you want to say about it, you should make the record you want.
Well, we left off with me wondering if I need to bring in the Atlanta Journal-Constitution reporter, or if the state was willing to acknowledge that it is an accurate copy of that article and the reporting, and then work by the journal, and then for the court to rule whether it is admissible or not. I don't know where we stand on that.
Well, I don't want to speak for Mr. Armstrong, but I have no doubt that that is an accurate copy of Ms. Gross's article. But I don't know how it's not hearsay opinion from Ms. Gross insofar as she made it more of an editorial than a fact-based piece. But then there's the relevance concern as well. So I want you to make the record you want about how it's not opinion, it's not hearsay, and it is relevant. And then if there's anything Mr. Armstrong wants to add from the state side, he can do that. But I think you have trouble clearing all three of those hurdles. But I didn't get to hear a ton from you because it was a surprise appearance of getting it in through Ms. Ross, and we agreed to talk about it later.
So the article is not, as the court wonders, just an opinion. It cites facts. It takes statements from people. For example, they reached out to the state parole board. Steve Hayes declined to comment on the suits, but issued a statement. The board provides meaningful consideration to all parole eligible offenders. The board uses its discretion authorized by the Georgia Constitution to make release decisions. And then it talks about one person who was 17 when she was convicted in 1981, and then resentenced in 2017 from the death penalty to life with the possibility of parole. And she was 17, now she's 62. It talks about what some of these people have done when they were in prison.
And what makes that relevant to whether there should be a new trial for Mr. Singleton?
Because I would respectfully disagree with Mr. Hayes' statement that the board provides meaningful consideration to all parole eligible offenders.
Okay. What does his statement have to do with whether Mr. Singleton should get a new trial as opposed to parole, which is not a right, is evenly handed down across the state of Georgia?
What do you mean by evenly? I'm assuming not saying fairly. You're just saying this is what they always do.
I don't know what fair would mean in the context of parole. It's not a right, but I guess by evenly it would be some people get it and others don't. Then I guess, but the fact that we're having this discussion should show you why it's not relevant to a motion for a new trial, not the sentence was an inappropriate or illegal or cruel and unusual sentence.
Well, the article reports that while over 300 people are eligible for parole review, only 17 have been released in the past 2.5 years, ending in March 2025, according to data reviewed by the AJC. And 6 parole eligible people have died while waiting during that same time frame.
Okay.
And again, we're talking about juveniles. And then it goes ahead and gives a list of all the people and the years that they have served their juvenile status when sentenced. And
so apart from the article perhaps suggesting that there is the potential for policy reform for the State Board of Pardons and Paroles, what does it have to do with a motion for new trial in a discrete, one set of facts, one defendant situation?
so Mr. Singleton was given a life sentence with the possibility of parole. The fact that that is not going to happen under our current state of affairs in Georgia makes it cruel and unusual punishment. I've already argued and continue to argue that his sentence was as a 16-year-old juvenile, but also now being denied parole, the way the process works, it is in essence cruel and unusual punishment to deny a 16-year-old parole ever.
What was his sentence out of Clayton?
It's interesting, and I would ask the court to look at those transcripts. You've been doing this long enough. I did it for 25 years. You can tell when a judge takes things personally. Mr. Singleton, I'm going to give you exactly what you did to that officer. I'm going to give you what you deserve. You're getting life in prison.
So he has 2 life sentences. Was it life with, I guess back then it would have been life with parole from Clayton as well?
Yes, that's my understanding.
Okay. All right, Mr. Armstrong, anything you want to add from the state as to the admissibility? Was that N?
Yes.
S.
Yes, I submit that it is not relevant to what the court is deciding. It is hearsay because, as Mr. Hort indicated, it's what this person said and what that person said. It begins with lawsuits say, and it starts about what people are advocating for somebody. They're challenging things based on assertions. It's not useful for that. And also, if his assertion is that no one who is convicted of murder as a teenager will ever parole out, that is demonstrably false. I happen to know one case that I can easily find online. There's a book entitled Grace Horse by Damian Terrell Chapman and Lisa Green Johnson. I had to look at her middle name. I know her very, very well. She's my old boss, who is convicted of a double homicide from when he was a teenager, and he has now been paroled out several years, like a decade ago or more. And so the idea that there's no such thing as parole for juvenile murderers in the state of Georgia is false. I'd also like to point out that this article would be of very limited relevance to the court because it starts talking about Janice Buttram, which when she was convicted for the homicide of somebody who was raped and sodomized and stabbed 97 times, according to the article. It's probably an individualized basis for determining whether somebody is parole eligible or not. And so this is not relevant. It is hearsay. There is no basis for bringing it in, and bringing an AJC reporter in would not make it more admissible.
Okay. Thank you. Mr. Hort, you remain fully empowered to argue that the fact that Mr. Singleton, with 2 life sentences, not 1, has yet to be paroled is somehow a factor to consider about whether he should be granted a new trial. But I will not be admitting defense S into the record of this case. Anything else before your voice goes entirely? You need to be able to holler tomorrow.
Yes. And did you decide that the motion supports the notes that was denied?
No, I haven't ruled on that. I'm going to take that under advisement. When you say the note, this was your motion to disclose the work product?
Yes.
Yeah, no, I'm taking that under advisement.
I believe that certainly doesn't involve everything, but if I may, I think that's where I would like to finish for today.
Okay. Ms. Hansberry has identified a date when we can reconvene. She needs to confirm it with Coffee Correctional, meaning that they have space that's not already claimed that Mr. Singleton could use. I want to make sure it works with the 2 of you. It would be on July 11th at 1 p.m. Is that a conflict for you, Mr. Hort?
I do have matters set, but no, I can be here.
Okay. Mr. Armstrong, I know you have to be in many places and you got a little emotional about how busy public servants are. So how does that afternoon look for you? Oh, and Department of Corrections has said that works. So we will be able to have Mr. Singleton. So your answer needs to be yes.
Call that date, but it is in the morning.
Okay.
So it should not conflict because it is not a 6 hearing type case.
We rarely get those. So we'll send out the usual notice. I don't know how Ms. Hansberry has been keeping you posted, but she's been doing it well. And she'll let you know, but pencil it in. Well, don't pen it in. It will be on the 11th of July, 1 p.m. And you'll connect with Mr. Singleton before then, Mr. Hort. Mr. Singleton, you should unmute and let me know if you have any questions about what's going on.
I have no questions about what's going on, not at all.
Okay. Well, Mr. Hort will be in touch with you, and I will see you on July 11th. We'll see what's next from Team Singleton. Okay? Thank you to our friends from GDC for making Mr. Singleton available and adjusting to our change of time and change of Zoom link. And we'll be in touch.